Bien, bonjour à tous. Nous allons reprendre nos travaux d'exploration des droits voisins en envisageant ce matin dans la première session le droit des organisateurs de manifestations sportives. Alors, vous savez que les Portugais étaient maîtres de la navigation, notamment grâce à leur art de dresser des cartes. Et où placer ici le droit des organisateurs de manifestations sportives dans la carte des droits voisins? Si j'en juge par les réactions d'hier dans les discussions que j'ai pu avoir avec certains d'entre vous, nulle part. Nulle part, il ne s'agit pas d'un vrai droit voisin. Pour reprendre l'expression de Frank Godsen d'hier, c'est plutôt un droit voisin des droits voisins ou un quasi-droit voisin. Alors, est-ce que ça veut dire qu'emportés par leur élan habituel, avec un vent favorable dans le dos, les navigateurs portugais dépassant naturellement le champ du droit d'auteur, emportés par leur élan, ont dépassé les frontières des droits voisins, peut-être. Et s'il faut en effet un constat de ce que les droits sportifs ne sont pas des droits voisins, il suffit de prendre l'exemple de la loi française. Dans le droit français, ces droits-là ne sont pas dans le code de la propriété intellectuelle, mais dans le code du sport. Donc on est vraiment dans un autre registre. Alors ça, ce sont des observations de théoriciens qui intéressent peu la pratique, parce que dans la pratique, il y a des enjeux très importants auxquels l'existence de ce droit est censée apporter des remèdes. Alors, dans le fond, le droit sportif que nous allons étudier ensemble confère à son titulaire une exclusivité. Cette exclusivité va être le levier juridique pour pouvoir éventuellement, d'abord, autoriser ou interdire la captation du spectacle sportif, ensuite la retransmission de ce spectacle sportif. Or, cette autorisation est l'occasion d'une très forte monétisation. Les enjeux économiques autour de ces droits sont de plus en plus importants. Ils sont de plus en plus importants et on verra, ils sont pourtant plutôt mal connus. Alors important, il suffit de voir si vous vous intéressez au sport, si vous prenez le cas par exemple du football, les droits sportifs aujourd'hui représentent des revenus plus importants que ceux générés par l'accès au stade, l'achat de la place, ou plus important que le sponsoring ou la publicité. C'est donc pour certains clubs professionnels de sport la source majeure de revenus. Et pourtant, c'est un droit où la piraterie est extraordinairement forte, ce qui a une conséquence assez simple. La perte économique pour les clubs sportifs est colossale. La perte économique pour les chaînes de télévision qui perdent leur exclusivité est également très importante, de sorte que les chaînes de télévision ont plutôt la volonté d'acheter les droits à la baisse, ce qui induit donc une baisse des revenus des clubs de football. Alors pourquoi cette piraterie? Il y a les raisons habituelles des pirateries que nous avons rencontré déjà hier, mais il y a aussi une piraterie qui vient tout bêtement du bon père de famille, c'est-à-dire qu'à un moment donné dans un foyer, il y a un arbitrage. Je veux voir, par exemple, du foot à la maison, je vais m'abonner à une chaîne. Or, la plupart des chaînes des sports sont des chaînes payantes. Et tous les couples ne peuvent pas payer un abonnement à une chaîne de sport. Donc la piraterie est un remède à cela. Deuxième raison, il existe un émiettement des droits relatifs aux droits sportifs. Par exemple, en France, pour regarder le football, il faut s'abonner à plusieurs chaînes différentes pour à peu près avoir tous les matchs. Imaginez les discussions que ça engendre dans les foyers, où peut-être que l'un des membres du couple n'est pas totalement en accord avec cet abonnement multi-chaînes de télévision. Donc là encore, le recours à la piraterie est vraisemblablement une solution pour les couples moins fortunés. Alors, ces pertes sont importantes et évidemment, ce quasi-droit voisin va être, s'il est bien mis en œuvre, un instrument pour lutter contre cette piraterie. Mais il faut tout de suite faire deux constats. Un, le droit dont nous allons parler n'existe pas partout dans le monde. Deux, il existe de réelles difficultés à mettre en œuvre efficacement ce droit. Et ces deux constats élémentaires vont structurer la session que nous allons entendre. Dans un premier temps, vous aurez deux exposés. Et à l'occasion de ces exposés, vous verrez d'abord dans la région européenne si ce droit est bien ou mal reconnu, existant. Puis nous aurons le même exposé à propos de l'ère sud-américaine. Fin du premier temps. Deuxième temps, nous verrons si ce droit est efficacement mis en œuvre. Ça ne sert à rien d'avoir un droit si, dans le fond, il ne permet pas d'atteindre les objectifs poursuivis. Or, nous avons parlé hier de l'article 17, de la lutte contre la contrefaçon, mais la lutte contre la contrefaçon, c'est un travail de longue haleine. Un match de football, ça dure 90 minutes. Est-ce qu'en 90 minutes, vous avez le temps de saisir, de trouver un juge pour que le juge fasse interdire l'accès au site où on trouve ces matchs en retransmission illicite? Non. Il faut donc trouver d'autres moyens, d'autres mesures pour y parvenir. Alors, nous allons faire ce tour d'horizon ensemble. Et la première intervention sera justement ce parcours dans l'Europe. Et la personne qui va faire pour vous ce parcours a réalisé dans le cadre de l'Observatoire européen de l'audiovisuel, à la demande de la Commission européenne, un rapport établir cette cartographie. Elle va donc maintenant nous en parler. Elle a une solide expérience puisqu'elle a un passé dans différents pays, dans différents cabinets d'avocats et dans des organismes de gestion collective, cabinet d'avocats américain, si ma mémoire est bonne, et organismes de gestion collective en Espagne. Donc elle a cette vision européenne qui sera très riche pour son exposé. Pardon Sophie, j'ai pas dit que vous vous appeliez Sophie Vallet. Tous ceux qui consultent le programme le savent.
Merci Monsieur le Professeur. Bonjour à toutes et à toutes. C'est un plaisir et un honneur pour moi de participer aujourd'hui à ce congrès à l'AI. Et je voudrais remercier chaleureusement les organisateurs et le président de la LAI et les membres de la LAI pour m'avoir invité et également pour permettre à l'Observatoire européen de l'audiovisuel de présenter nos derniers travaux dans le domaine de la propriété intellectuelle. En quelques mots, pour ceux qui ne connaissent pas l'Observatoire européen de l'audiovisuel, nous sommes un organisme de service public qui fait partie du Conseil de l'Europe, donc basé à Strasbourg, en France. Nous célébrons cette année nos 30 ans, donc nous avons été créés en 1992, et notre mission principale à l'époque, est toujours actuelle, est de promouvoir la transparence sur les 40 États européens que nous représentons. Alors, comment nous remplissons cette mission? À travers différents rapports d'ordre de marché économique et également juridique sur l'état du marché audiovisuel dans ces 40 États. Et nous publions ces rapports de manière gratuite sur notre site web, ainsi que des bases de données pour la partie juridique, notamment la mise en œuvre des directives. Voilà pour la partie en français. Maintenant, je vais passer en anglais, puisque ma présentation est en anglais. So, unlike other content, the screen life of a sporting event is as short as the duration of the match in question, because its interest lies mainly in the fact that it is being watched live. The natural consequence of this is that piracy of such live content leads to immediate and unrecoverable losses in audience and in revenues. So given this specificity of sports content, sports organizers face specific challenge in the digital environment with regard to the illegal streaming of sports content and the illegal distribution on IPTV channels, which call for immediate reactions. But the question of ensuring a timely and an effective enforcement of the rights is also closely related to whom is entitled to take legal action in case of online infringement, and more importantly, on which legal basis, as certain remedies are reserved to rights holders. So this brings us to the question of the legal protection of sports organizers. And my contribution today to this discussion, as said Mr. Cirinelli, is to present you the results of this mapping report that the European Audiovisual Observatory has carried out on behalf of the European Commission in 2021. So, more precisely, this report had as a main purpose to track the national remedies against online piracy, meaning the legal provision, the procedural rules in place in the countries that we covered, but with a specific focus on the functioning and the availability of injunctions, and more particularly on dynamic injunctions, which are increasingly being used in case of illegal streaming. So I will focus specifically today on the question of the legal protection, not so much on the legal remedies. But before I start, I would like to give you a few elements of background on the policy context, as well as some methodological insight of our project. So the issue of the challenge of sports organizers in the digital context has been in the regulatory spotlight for quite some time now. So in March 2019 already, the moment of the adoption of the directive on copyright in the digital single market, the European Commission included a statement as an annex to the resolution of the Parliament, where it highlighted the importance of sports organizers in the sporting ecosystem and in the development of sporting activities and the financing of these activities. And the Commission announced in this statement that it would assess the challenges faced by sports organizers in the digital context. And 2 years later, in May 2021, the European Parliament, based on a report that commissioned, went one step further and published a resolution, on a self-initiative resolution on the challenges of sports events organizers in this digital context. And beyond stressing again the role of sports organizers in the sporting activity development in the Union, the Parliament called on the Commission to take a legislative act and based among a certain number of recommendations. Among these recommendations, there was the need for an effective enforcement of the rights, meaning an immediate removal of illegal content within a maximum duration of 30 minutes from the notification of the rights holders. Then the Parliament insisted on the problem of the cross-border enforcement of rights and for the need for harmonization of procedures and remedies in the Union, and an improvement of the exchange of cooperation between authorities and exchange of best practices. The Parliament also highlighted the need for an improvement in the notice and action procedures by setting up mechanisms for certified trusted flaggers. The Parliament also asked the Commission to assess the availability and the functioning of allowing real-time injunctions to tackle this question of piracy of illegal streaming. Also, the Parliament mentioned the question of the neighboring right, possibility of neighboring rights for sports organizers. So in July 2021, the Commission acknowledged that it would examine the question, and the report of the Observatory takes place within this assessment. We published our report in December 2021. It is also available on the website of the Commission, and it gives an overview of the legal framework in the 28 countries that we cover, which is the EU plus the UK, based on the long-term experience of the UK in this field. The data was collected between May and October. In terms of methodology, we use always the same methodology for mapping reports, which is based on 4 steps. First, the selection of national legal experts. Some of you are in this room today, and I take the chance to thank you again. Then we prepare a questionnaire on the national legal framework, the rules, the law, the provisions, but also the case law. Then, based on the replies, we prepare national country reports, which are cross-checked by the national authorities. So in this mapping, it was the ministries or the Copyright Office. And then, based on this, we prepare a comparative analysis with the support of an international expert that we select. In this case, it was Giovanna Maria Riccio, an Italian lawyer from the e-Lex Studio Legale in Rome. So, on top of the report and the country fact sheets, we have also some case studies analyzing more in detail some topics that are relevant in this case of piracy. In this case, we have analyzed the case law on live blocking injunctions, the role of police forces, the administration and voluntary cooperation enforcement mechanisms, and technology-based enforcement systems. And I must also say that here we benefited from the very valuable support of sports organizations, which gave us some information about the methodology and the technologies that they use in this field. So the key findings as far as who takes legal action, as I mentioned, this is closely linked to the scope of protection and the legal basis on which one can intervene. And the starting point was to look at the sports event itself. Without surprise, we found out that in all countries, sports events are not subject to copyright protection. This is without surprise because the Court of Justice of the EU said so in 2011 in the Premier League case, ruling that sporting events cannot be regarded as intellectual creation because they lack of originality. So this was confirmed even in some countries by the Supreme Court, for example, in Spain, many times in Poland. However, this being said, the audiovisual recording of the event is protected by neighboring rights of the producer on the first fixation of original and copies, and the neighboring right of the broadcaster on the signals. And in some countries, we found that there is some copyright protection granted to the recording when it fits some originality criteria, creativity criteria. For example, it can be the filming angle. In a match, you have several cameras everywhere, so you can do some interesting things, I guess, in the editing. So on this basis, producers and broadcasters and their assignees can take legal action based on copyright law. So when it comes to the protection of sports events organizers, the situation is more fragmented in Europe. We found different type of protection, but first of all, what caught our attention was that we couldn't find really a definition of the key concepts, either of the sports organizer himself or the sports event. Even in the countries that have installed some specific rights, we couldn't find a statutory definition of the sports organizers. In Italy, which is one of the countries where there is a definition, the sports club is the entity which undertakes the responsibility and the obligation for the organization of the event taking place in the facilities at their disposal. And also the sports league is defined, the sports league organizer is defined as the person to whom the organization of the competition is delegated by the federation. Then what we found also is some countries have different concepts. You have in their sports law, like for example, the sports main organizer, the organizer of service, the event organizer, and it's not always very clear which term refers to what. And the same applies to sports events, where we barely found any definition at all. Then, when it comes to the legal protection, as you know, there is no specific right for sports organizers in EU law, but we found 3 types of protection at national level. First, a protection which is linked to the venue or the stadium where the event takes place, and this is so-called the house rights or domiciliary rights. Then a protection which is directly linked to the contractual practices through the collective management and the selling of the audiovisual rights to broadcasters by the leagues and federations based on the federation statutes. And finally, this is the topic today, protection linked, created by law, creating some specific kind of protection either by new sui generis right or another form of protection in the law. So I won't have a look at the contractual practices because this was not the purpose of our study, but let's have a closer look at house rights and this specific form of protection. So in many countries, as you can see in this map, mainly northern countries of Europe, we found house rights granted to the sports events organizers, and this category of property rights grants protection to the owner, the tenant, or any other subject who may claim rights over the premises where the event takes place. So sports clubs in practice are entitled to these rights because they own the premise, or more frequently because they lease the facility, for example, to the municipality. So the house rights only allow the rights owner to control the access to the venue where the event takes place based on property rules, and to authorize or prohibit the recording of the event, for example, through mobile phone, based on contractual rules through the purchase of the ticket. So based on these rights, the sports club, as the owner of the house rights or any licensee, may take legal action against any persons who would record or transmit the event without prior authorization in breach of the property rules or in breach of the contractual rules. In practice, the legal actions are very rare, as this would be against the spectators illegally recording, and this is not really where the damage takes place. This does not relate to mass infringements such as those committed by websites which retransmits the signals of the sports events. But as Professor Cirinelli also mentioned, the house rights may also offer the legal basis for sports organizers to negotiate the condition of audiovisual recording a production and with broadcasters to record or to broadcast the event. These rights can be transferred by contractual agreements, which resemble a license agreement, but the permission is granted only on a contractual basis, and they are only effective against the parties to the agreement, and not against third parties, because this is not copyright. So now, in the other countries that we have seen where there is a specific form of protection, first of all, this Premier League case that I just mentioned added, beyond the fact that sporting events are not copyrightable works, that they have a unique and original character which can transform them into subject matter that is worthy of protection, comparable to the protection of works. And the court added that it is permissible for member states to protect them by intellectual property rights through specific national legislation or by recognizing protection conferred upon these events by agreement concluded between the person having the right to make the audiovisual content of the event available to the public and the person who wished to broadcast that content to the public of their choice. Based on this possibility offered to the member states, we found that 4 countries, namely France, Italy, Spain, and Greece, have created in their law some kind of statutory right to protect sports organizers. Then we found another form of protection in 4 countries, Bulgaria, Hungary, Romania, and Slovakia, where there is no such right, but the law organizes also a form of protection, and which is between the house rights and a specific right. So I will present you now a bit of detail, very simple, about these different configuration of rights in these 4 countries that I mentioned. So in France, this is the French Code of Sport, which organizes the protection of sports organizers, and it assigns exploitation rights to the sports federation and the event organizer in the sports event or competition that they organize. However, the French legislation does not really set the boundaries of this exploitation right. It doesn't specify what is included in this notion of exploitation. But the case law has ruled that, especially in the Roland Garros case against Unibet, that these exploitation rights refer to any form of economic activity whose purpose is to generate profit and which would not exist if the sports event itself did not exist. And the court ruled that these rights were included in the property rights. In any case, these rights cover only the broadcasting of the sports event, and they may be assigned also to the federation. And based on these rights, the rights owner, so the sports federation, the sports organizer, and the assignees can take legal action in case of infringement of the copyright and related rights related to the broadcasting or the online transmission of the sports content. In Italy, we found also something similar and not so much, not exactly the same. In Italy, it's the Melandri decree of January 2008, which holds that the organizer of the competition, so the federation or the league, and the organizer of the event, so the club, are joint owners of the audiovisual rights, but it specifies, it separates in 2 layers these exploitation rights. First, the exercise of the audiovisual rights belongs to the competition organizer. In practice, the competition organizer is granted the exclusive right of economic use of the moving image on all possible platforms through various competition procedures, which are organized by standards for the assignment of the audiovisual rights. And the audiovisual production of the event is managed by the events organizer, so the club, who can film directly the event or more generally through a filming service company or relying on the broadcaster who have been assigned, in this case, the audiovisual rights. So based on these rights, the code also, and this is very interesting in Italy, it's basically the only country where there is a neighboring right for the sports organizers, which has been included in the copyright law. Next to the provision on the neighboring right of the producer, a new Article 178 has been introduced, which says that first, the copyright law is applicable to audiovisual sports rights, and which grants these related rights to both the organizer of the competition and to the producer for the first fixation of the recording. So rights owners are entitled to take legal action in case of illegal broadcasting or online transmission, and broadcasters and sports events organizers as licensees are also entitled to take action. Now in Spain, the ownership of the audiovisual rights belong to the participating clubs, but according to a royal decree on the commercialization of the exploitation rights for the audiovisual content of professional football competition. In this official competition, the rights belong to the competition organizers or the league. So there is a mandatory assignment of the audiovisual rights to the competition organizers who will commercially these rights jointly. This is reserved to the first and second division of the Football League and for specific tournaments like Copa del Rey or some specific tournament. I'm not a very sport expert, so I'm sorry for the lack of examples. So in Greece, the last example, in Greece also it's an interesting provision because the Greek law on sports provides for specific protection for sports organizers through an exclusive economic rights over the sports event, as they are the legal entities organizing and running the event. So every sports club or professional sports entity enjoys the right to authorize through remuneration the radio or television broadcasting or retransmission by any technical means of the sports event hosted by said club. They have also the right to authorize the recording and the reproduction or the snapshot by any means and on any fixation material, and the public distribution of this reproduction by transfer of ownership, rental, or public lending. And the sports organizers may transfer these rights to the federation or the league, and these rights can be licensed to broadcasters through an exclusive or a non-exclusive license. However, these rights are sui generis rights, akin to neighboring rights, but not considered as such in the copyright law as it was specified in Greek law. So the other forms of protection that we found in the other country, mainly in East European countries, are in between these specific rights and the house rights. Contrary to the house rights, they are explicitly referred to in the law. They are referred to as broadcasting rights that may be assigned by contract to third parties, for example, the broadcasters, but they are not economic rights, they are property rights and not intellectual property rights. So the sports organizer holding these rights are not entitled to take legal action based on violation of copyright, and therefore they have not access to certain remedies. So this is a brief overview of what we found on the field of legal protection. We have found a diversity of stakeholders entitled to take legal action in case of online piracy. We have found also a diversity of legal bases, property rights, IP rights, contractual rights. We found a diversity of legal framework, copyright law, sport law, to say the least. And when it comes to remedies, we have found also a diversity of national schemes. So the question now, which is open to all of you, is how best to combat online piracy of sports content? Is it through the creation of new rights or through the improvement of the existing enforcement procedures to the existing rights? Thank you very much.
Merci. Merci Sophie pour cet exposé. En fait, c'était une double cartographie. Une cartographie géographique, mais également une cartographie par rapport au droit. Comme vous l'avez dit, il y a différents modes de protection, mais il y a aussi le bon vieux droit d'auteur et les bons vieux droits voisins. Je pense qu'on en reparlera tout à l'heure, soit dans la deuxième partie, soit au moment du débat. Ce qui conduit peut-être à considérer qu'il n'était peut-être pas utile de créer ce nouveau droit voisin, mais ça c'est une autre question. D'autant que lorsque en France nous avons travaillé sur le thème, on a constaté que les modèles qui faisaient rêver étaient ceux du Portugal et du Royaume-Uni, qui dans votre carte étaient bonnes pratiques et pas du tout les législations. Alors on va voir maintenant une deuxième cartographie, on change de continent et on va essayer de voir avec le docteur Alero Barrenechea, si on trouve le même type de solution en Amérique du Sud, et intuitivement les sportifs que nous pouvons être pensent peut-être qu'en Argentine ou surtout peut-être au Brésil, il doit y avoir des choses. Alejo.
Buenos días a todos. Voy a hacer mi presentación en español. Quiero, en primer término, agradecer a los organizadores del evento y en la persona de Víctor, especialmente la gentileza y disponibilidad permanente para colaborar con todos, para que este evento tenga la característica y el nivel que está teniendo. Me han encomendado hablar del derecho de arena, específicamente la situación en Latinoamérica. Es un tema bastante complejo, donde tenemos únicamente un antecedente legislativo en Brasil, pero de todos modos quiero compartir algunos elementos generales sobre el instituto para luego avanzar sobre la normativa concreta en el tema. Posiblemente todos los abogados que trabajamos en temas de derecho de autor o derecho de entretenimiento en algún momento hemos tenido que contestar a la pregunta de cómo hago para utilizar las imágenes del gol de Maradona en el Mundial del año 86. Nos gustaría poder dar rápidamente una respuesta, pero en general es bastante dificultoso. Queda claro que en esa transmisión hay diferentes participantes. Por un lado tenemos al jugador, por otro lado tenemos a la entidad deportiva a la que él representaba, tenemos al organizador del evento, tenemos al organismo de radiodifusión que tenía contratado los derechos de transmisión de ese evento, y para sumar complejidad al asunto tenemos que mencionar que en general las imágenes que se han popularizado en el país son aquellas que están sincronizadas con un relato efectuado por un uruguayo, por un locutor que se llama Víctor Hugo Morales, que a su vez tenía una relación de empleo con otro organismo de radiodifusión. Es decir, las imágenes que suelen divulgarse o utilizarse son una sincronización de la transmisión televisiva de FIFA más este relato radial de un locutor de nacionalidad uruguaya, como decía. Lo cierto es que en la práctica estas imágenes se utilizan permanentemente. Yo tengo aquí solamente algunos ejemplos bastante recientes. En primer término tenemos el documental de la BBC sobre Maradona, que en los créditos menciona la titularidad de derechos por parte de la FIFA. Tenemos la reciente película de Paolo Sorrentino, que también hace mención a una titularidad de derechos por parte del organizador del evento en el que se tomaron las imágenes. Y por último tengo una imagen de un libro que transcribe palabra por palabra el relato radial de ese partido. Está publicado como obra literaria, está protegida como derecho de autor. En este caso yo no voy a hablar de los últimos eslabones de la cadena de derechos, sino de los primeros, jugador, entidad deportiva y organizador del evento, para ver si podemos sacar algunas conclusiones relativas al derecho de arena. Si tuviéramos que ensayar una pequeña definición o una primera definición sobre el derecho de arena, diremos que es un derecho exclusivo que le corresponde al atleta de autorizar o prohibir la utilización o explotación de su imagen en el marco de la realización del evento deportivo y eventualmente la posibilidad de obtener algún ingreso por dicha utilización. Como ustedes saben, el derecho de arena toma su nombre de lo que sucedía en la arena romana, donde los gladiadores, otros participantes, animales, formaban parte de lo que se consideraba un espectáculo frente a un público presente. Hoy en día los elementos que configuran el derecho de arena no son los mismos y esto presenta algunas dificultades. Si tuviéramos que buscar una justificación para el reconocimiento de este derecho de arena, en general se busca en términos de proteger la inversión que desarrolla un organizador de un evento. Creo que esto inició con la Vuelta de Roma de Italia en ciclismo, donde el organizador había puesto a disposición de los atletas medidas de seguridad, salarios, condiciones de salud, etcétera, y las imágenes fueron tomadas por un tercero y explotadas por un tercero, generando ingresos no para el organizador, lo que se consideró como una clara injusticia. Entonces, la justificación se encuentra, de alguna manera, en la necesidad de proteger la inversión que desarrolla el que idea, el que organiza y el que finalmente ejecuta este evento de carácter deportivo. Una de las cuestiones relevantes en función de esta primera definición es quién tiene la titularidad de los derechos. Y acá tenemos, esto está ligado con la naturaleza jurídica del derecho de arena. Respecto a la titularidad, podemos discutir si esta pertenece al atleta como persona física que desarrolla o forma parte del evento deportivo, o si en realidad esto le pertenece a la entidad deportiva a la que pertenece o eventualmente al organizador. En esencia, en la medida que consideramos la naturaleza jurídica del derecho como un derecho de imagen, diríamos que en esencia el derecho le corresponde al atleta. Sin embargo, en la práctica, los negocios, las economías del negocio, los modelos de negocio, terminan determinando que la naturaleza, la titularidad de los derechos pertenece a la institución a la que pertenece el jugador, siempre con el respaldo a un contrato previo de cesión o autorización de uso de la imagen, pero cuando analizamos las normas, tal como mencionaron precedentemente, en general los derechos están en cabeza de la persona jurídica y no del atleta que forma parte del evento. En cuanto a la naturaleza jurídica y ligado a esto que mencionamos, la titularidad, tenemos una primera posibilidad que es la de considerarlo como un derecho conexo, algo que personalmente no comparto, fundamentalmente porque por más que consideremos la actuación de Maradona como una obra, como una creación artística, me parece que no hay involucrado en este caso una obra protegida por el derecho de autor, ni hay un derecho conexo que busca difundir esa obra. Por lo tanto, yo descartaría la protección del derecho conexo como una posibilidad. Me parece más claro que esto es un derivado del derecho de imagen personal. Ustedes saben que el derecho de imagen es un derecho personalísimo con atributos muy fuertes en defensa de las personas. Como una derivación en un contexto deportivo, se reconoce este tipo de posibilidad y hay una transferencia, una cesión o autorización de uso por parte del atleta que en general se resuelve contractualmente como paso previo. Como les adelantaba, ya para dejar atrás las cuestiones formales, mencionaba que tenemos un único antecedente en Latinoamérica legislativo, que es el caso brasilero. Se conoce como la Ley Pelé, es una ley del año 98 que tiene algunos antecedentes. Lo primero que quiero destacar es que esto tiene apoyo en el artículo 5 de la Constitución Nacional de Brasil, que reconoce expresamente el derecho de imagen de las personas y hace la aclaración de que esto incluye las imágenes tomadas en eventos deportivos. Esto verdaderamente es una particularidad, no lo he encontrado por lo menos en otros textos constitucionales de la región, y es lo que ha servido de sustento a este reconocimiento legislativo posterior. La ley del año 73 reconoció en un primer momento el derecho de arena como un derecho conexo, es decir, el derecho estaba en cabeza de la entidad deportiva, tenía la posibilidad de autorizar o prohibir la fijación, la transmisión y la retransmisión de las imágenes del evento al que se puede acceder con cobro de entrada, que era un elemento de la normativa, y establecía la obligación de distribuir los ingresos generados por esa autorización en un 20% para los participantes del evento. Tiempo después se modifica la norma y en una norma, en una ley específicamente referida a las actuaciones deportivas, a la práctica deportiva, más o menos se sigue el mismo lineamiento normativo en el sentido de reconocer el derecho en cabeza de la entidad deportiva. Se reconoce este mismo 20% de derecho, salvo pacto en contrario, por parte del atleta, aunque se elimina esta condición de que el evento sea con cobro de entrada. Ya en la Ley Pelé del año 98, que ha sufrido varias modificaciones, pensemos en una ley del año 98 en contexto, ¿no? Lo que significaba una transmisión deportiva o las necesidades técnicas para poder desarrollarla comparadas con la posibilidad técnica actual de comunicación pública, de streaming, etc. Los elementos de esta norma en la actualidad reiteran la titularidad en cabeza de la institución deportiva. El derecho es amplio, la enumeración de derechos es más abarcativa. Se habla, por ejemplo, del derecho de negociar, autorizar y prohibir, la fijación, la transmisión, la retransmisión, la reproducción. Son todos los derechos que están expresamente enumerados en la ley. Y como contrapartida se reconoce a los atletas involucrados que formen parte del evento deportivo una remuneración que tiene que ver como mínimo del 5%. Este 5% es salvo que hubiera un convenio colectivo de trabajo que estableciera un régimen distinto. Esto ha generado bastante problemas, fundamentalmente porque se discutía, entonces volvíamos a la discusión sobre la naturaleza jurídica del instituto, fundamentalmente porque se le atribuía características laborales y esto entonces formaba parte de una remuneración al momento de considerar indemnizaciones por rescisiones contractuales, lo que generó bastante litigiosidad, y la norma, para solucionar esta cuestión, termina aclarando que esto es de naturaleza civil. Es decir, la norma que reconoce el derecho, que dice que esto se refiere a contratos, a deportistas contratados profesionalmente, o sea, que hablan de una naturaleza laboral, que hablan de una remuneración, salvo convenio colectivo de trabajo distinto, termina mencionando que es de naturaleza civil. Esto la doctrina lo ha cuestionado como considerándolo contradictorio, pero se suele afirmar que es una respuesta a los lobbies de los clubes que tienen peso al momento de la negociación de los contratos y eventualmente de los textos legislativos para evitar este tipo de conflictos. En Latinoamérica, en el resto de los países de Latinoamérica no tenemos una norma específica sobre derecho a arena. Entonces, en definitiva, el tema se termina resolviendo por el derecho de imagen, el derecho de imagen genérico, y lo que se termina resolviendo por contrato con las instituciones. Cuando hablamos de contratos, hablamos de contratos individuales y en algunos casos contratos regulados a través de estatutos profesionales, ¿sí? Ya sea el estatuto del futbolista. Es frecuente analizar todo este tipo de normativa a la luz del deporte del fútbol, pero la norma de Brasil no excluye otras prácticas. Se hablaba de primera división, de las ligas que concentran mayores ingresos, pero hoy en día el auge del fútbol femenino, de las ligas, divisiones menores, ponen un poquito en juego esta regulación porque la idea es abarcar todas las prácticas y reconocer este tipo de derechos. Entonces, en definitiva, en el resto de Latinoamérica la cuestión se termina resolviendo contractualmente. También lo que tiene que ver con la distribución del derecho, con la distribución de los ingresos, con respecto a la negociación colectiva o individual por parte de las entidades. No es lo mismo que negocie el Real Madrid con un cable operador, con un organismo de radiodifusión, que negocie otro equipo, que hace las veces de local o de visitante, que una negociación en conjunto de la liga en concreto. Para cerrar, cuando el deportista negocia su imagen a título individual, hablamos de un derecho de imagen liso y llano. Es decir, Lionel Messi negocia con Adidas su participación en un anuncio publicitario. Cuando la participación del futbolista se hace en el marco de un evento deportivo, y esta foto me parece importante, porque cuando hablo de evento deportivo no solamente hablo del uso tradicional de la imagen, de la emisión del evento deportivo en vivo y en directo, sino, por ejemplo, una imagen estática, ¿sí? Esta imagen estática está tomada de un partido. Por eso, en general, cuando los derechos los negocia la institución, se suele utilizar lo que se conoce como el abrazo de gol, ¿sí? No está Messi solo, para no entrar en ningún tipo de confusión sobre cuál es el derecho que se está involucrando. Este es el derecho de la selección argentina, por más que podamos identificar claramente la presencia de Messi en la imagen. En definitiva, con ese contexto normativo yo creo que hay muchas cosas para seguir discutiendo. Una de las importantes es la conveniencia del reconocimiento del derecho de arena como un derecho conexo y discutir las ventajas o desventajas. La ventaja que podemos encontrar en que la discusión la llevemos adelante aquellos que trabajamos en temas de derecho de autor, que tenemos un especial cuidado en proteger el derecho de los autores, incluso los derechos conexos, o que la discusión quede fuera de ese ámbito y uno después tenga que soportar los resultados de una normativa que no ha tenido en cuenta esta tan especial particularidad de los derechos intelectuales. Esto es todo, muchas gracias por su atención y quedo a disposición para contestar las preguntas que se presenten.
Ça marche, pardon. Merci à Véro. Vous avez compris qu'on a ajouté une couche supplémentaire de droits, les droits à l'image, et qu'on est en présence d'un millefeuille juridique absolument extraordinaire, peut-être qu'il commence à être un peu indigeste pour certains d'entre vous, surtout tôt le matin, mais il faut bien avoir conscience que ces différents droits qui ont été énumérés ont tous des objets différents. Peut-être que nous allons nous en rendre compte, et nous allons passer maintenant à la deuxième phase de cette session, celle de la mise en œuvre de ces droits. Et évidemment, pour ça, il faut des spécialistes et des gens qui font ça à longueur de journée. Et Silja Krutz, qui est avocate en Allemagne et au cabinet Klinkert, va nous expliquer les difficultés qu'elle peut rencontrer dans la défense de ces droits. Silja.
So, hi everyone. Thank you for the kind introduction, dear Pierre, and thanks to all the organizers for this conference. I will give you today a short overview about the problems that arise in the enforcement of the sports events organizers' broadcasting rights. As we all know, sports content is usually exploited as live content, and live streaming in general is the simultaneous transmission of audio and video files to internet users. In the last years, operators of illegal live streaming have various technical possibilities to provide offers. So we have an increasing number of unlicensed live streaming offers with a quality that does not differ from that of the legal offers. Due to this, there is an enormous effect on the value of the sport event organizers' broadcasting rights. There are different categories of piracy regarding sports content. We have streaming offers on websites, on IPTV services, and the third one would be the social media networks. On social media, it is only the sharing of content by the individual user. And these users typically do not share whole sports events, but only the highlight clips, for example, short clips of spectacular goals or slow motion. Although the highlight clips are part of the media rights exploitation of the rights holders, there is no significant effect on the value of the broadcasting rights, in particular since the highlight clips are distributed after the sport event and not live. In addition, the sharing on social media is part of a fan culture, so already for this reason, there is a very high tolerance level. Social media as a platform is essentially a problem insofar as it is used for advertising illegal offers. But the problem is still the professionally operated illegal live streaming offers that do this for their own profit-making purposes and not the single user of a sharing community. Website streaming offers and IPTV services are both usually professionally operated. Website streaming offers are financed via advertising placements and viruses or malware, and IPTV services provide subscription models that are typically offered at a slightly lower price than the licensed IPTV offers, so that the illegality is often not obvious for the user. In both cases, it comes to a direct evaluation of the rights holder's content, and in addition, it is fraud in the direction of both the advertising partners and the users. Professionally operating pirates have a complex structure in the background which enables them to offer the services to the extent they do. On the bottom, we have the content sources. They detect and steal the content. Usually it is just an individual who has a subscription to a paid service and rebroadcast this content. They sell the content to the piracy content aggregators that trade the bundles with multiple content built as packages to the wholesaler. The content packages include not only sports content, but also, for example, movies and TV shows. The wholesaler operates the end-to-end streaming, but is not the entity that offers the subscription to purchase to the end user. Before the end user, there are the pirates reseller and the interface aggregators, and these are offering the illegal subscription to purchase. The proceedings against resellers and aggregators and also the end users are just ineffective. The relevant parts of this structure are the wholesaler and the pirates resellers, because they sell ready-made packages as kind of white label solutions that can be offered on every other website when a content is blocked. In order to fight against piracy, the rights holders have built up a structure internally or also in cooperation with certain agencies, which clearly shows the complexity of the anti-piracy work. To gain speed and also to avoid false positives, they combine human resources with automatized processes. As preparation, they search the internet for streaming offers. For this, they behave just like normal users who want to stream a certain content. Then they put the results in a database to scan this database on the next match day to find out the actual offers. For these results, they collect screenshots, IP protocols, and save all evidences in a file. In addition, they send an automatic takedown notice to the operator if they can identify an operator. And if the operator does not comply, they hand over the files to law firms. The law firms move on with the usual process like warning letters, cease and desist declarations, and so on. The problems of enforcement are based on the following main points. The most important is the time, because as already said, sports events content is predominantly live content. So we have a very small time window for effective measures, because action is effective only if it's removed in real time. Subsequently enforced, the value is significantly lower. And even if the infringement is stopped, the piracy content can be re-uploaded to another domain in seconds. Another point is the difficult tracing and also the anonymity. The operators often use foreign countries that makes tracing difficult or almost impossible. And the servers they are using are usually located outside the European Union. The operators manage their offer in addition on their top-level domains whose registrar does not cooperate, neither with state investigating authorities nor with the rights holders. And furthermore, they provide no imprint or a false imprint and no contact for report or an adequate address. In conclusion, the enforcement against users is ineffective due to a high number of users, and furthermore, it is not opportune because users are the fans and usually they do not know that it is illegal. And so they are equally the ones who have been fooled. But the enforcement against aggregators, wholesalers, and resellers is ineffective too, because they conceal their identity, they relocate the headquarters to foreign country, and it is a highly agile business. As explained, the content can be rebranded and moved to other domains in seconds. So the first part of the enforcement, the finding of the offers and finding the people behind them, as well as collecting all evidences, is very complicated and cost-intensive. And in addition, because we have no special right for sports events organizers, the rights holders have the full burden of proof, inclusive the proper standing to sue, so the proof of exclusive rights, and the legal proceedings are also very difficult and time-consuming. One possibility that is used and that appears simple at first glance is the DNS blocking. A DNS can convert the domain name that you enter into the browser line into an IP address. DNS blocking is possible for the internet access provider. So in conclusion, it is actually only effective for all people if every internet access provider implement the DNS block and not only a few of them. To simplify and to accelerate the process of DNS blocking in Germany, as well as in other countries, was set up an out-of-court proceeding possibility. In Germany, it is called KUI, it is a clearinghouse, and it is an association of various rights holders and internet access provider. It is a voluntary procedure that enables blocking of access to structurally copyright infringing websites without costly and time-consuming legal proceedings. The blocking procedure by means of this out-of-court proceeding starts with a blocking request by the rights holders. This is based on their own investigation, as explained, and after unsuccessful legal enforcement options with the operators or the host providers. The blocking request is submitted to the review board, which discuss and give an unanimous recommendation for blocking. This recommendation must be forwarded to the Federal Network Agency, which monitors the network neutrality in Germany. They give an informal statement on harmlessness, and without this statement, a DNS block is just not allowed. The procedure is still quite new in Germany, but KUI exists now for more than 1.5 years. It was established in the beginning of 2021, and only 9 DNS blocks have been set up so far. In addition, no website offering illegal streaming of sports content has been blocked. There are 2 reasons in particular that have resulted in the lack of success of this in terms of sports content. The first one is the subsidiarity principle. The internet access provider is running a neutral business model. Although it is not explicitly required by an EU directive or the European Court of Justice, at least in Germany, blocking by the internet access provider is only the last resort, and the subsidiarity principle must be respected. This means that the rights holder, if possible, have to take priority legal action against those parties who either committed the infringement or who contributed to the infringement. So, in particular, the website operator and the host provider. Reasonable measures to uncover the identity of the operator of the website are, for example, involvement of state investigating authorities by way of a criminal complaint, or private investigations. I don't know how the state authorities in your countries are working, but in Germany they are not known as working very swiftly. If legal action is not expected to be successful, it doesn't have to be initiated. For example, in Germany, a court has already decided that the rights holder is not obliged to take legal actions against a host provider that is based in Russia. But at least it must be proven that legal proceedings would be unsuccessful. The second reason is the interpretation by the network agency of the definition of structurally infringing website. In principle, this includes those websites that are designed for infringements from the outset. This depends, among other things, on the proportion of legal content to illegal content on a website. The German Federal Court of Justice said in probably the most important judgment in Germany in this regard, if a website contains only 4% of legal content, the assumption that blocking measures are appropriate does not fail due to the fact that lawful content is affected. As a result of this sentence, the Federal Network Agency now requires that it must be proven that 96% of a website is illegal. It is not enough to prove that 100% of the content of the rights holder that is available on a website is illegal there. The rights holder must therefore make a random selection as part of a statistical survey and contact all the rights holders for all selected content and ask whether this content has been licensed to the corresponding streaming service. But the streaming services usually include sports content from all over the world, and not only from the large organizers who provide relevant contact options, but also from very small sports events, and their organizers probably will not respond. In conclusion, it is almost impossible to prove that it is a structurally infringing website for sports events organizers. It's probably easier for other industries when there are not only the big companies who work commercially, but regarding sports content, there are only a few who commercially distribute content, if you think about how many sports clubs we have in the world. Besides these problems, the difficulty is that a normal DNS block can be circumvented easily. It is sometimes argued, however, that in fact there is no way to effectively block websites and that DNS blocks are effective only for completely inexperienced internet users. Other argues that there is a strong deterrence when a DNS block is put in place and that the number of users decreases significantly. Regardless of this dispute, case law considers DNS blocking as an effective measure. According to the experience we get from our clients, the problem is not that users can circumvent the DNS block, but rather that operators can easily circumvent the blocks in just shifting to another domain. And it is always a kind of cat and mouse game. For this, the rights holders would need two different things. They want a legal basis stipulating that internet access providers must set up a block within 30 minutes of being notified of an IP address or domain name, and they want more effective blocking techniques. IP blocking instead of DNS blocking, as well as dynamic injunctions and live blocking orders. Dynamic injunctions follow the infringing website even if the operator changes the domain name or the IP. The primary domain name and the IP address, and also any subsequent domains the operator shift to, is blocked with a dynamic injunction. It would allow flexibility to cover repeated infringements without the need for new judicial procedures to obtain new injunctions for every case. The time problem can be solved by live blocking orders. These allow the repeated blocking of a website every time a live broadcast is in process. These live blocking orders are dynamic insofar as they provide that the list of target servers will be redefined at a regular basis during the life of the blocking order. At the moment, neither dynamic injunctions nor live blocking orders are implemented in Germany so far. Both are used, for example, in the United Kingdom, and there are several courts in EU countries that allow at least dynamic blocking. That to be implemented in all countries could be the next step in fighting against online piracy. In conclusion, the enforcement is enormously difficult and shows various problems at every level. Sports events are predominantly exploited as live content, so we have a very tight time window for effective actions against infringements. The preparation, the finding, and in particular the saving of all evidences are highly complex and with a low ratio of success. These problems correspond with the lack of legal basis for sports broadcasters for their audiovisual broadcasting rights. That brings us to the end of the presentation. To summarize from a legal point of view, it would help in any case if at least the standing to sue of the sports broadcasters no longer had to be proven by disclosing the acquisition of derivative rights. And procedures are implemented for easier and faster blocking and new possibilities to be established of super injunctions or at least blocking techniques that are not so easily to circumvent as DNS blocks. Thank you.
Merci Sylvia. Vous l'avez compris, donc c'est un vrai parcours du combattant qui attend le titulaire de droit voisin ou titulaire d'autres droits dans la mise en œuvre. Alors, je voudrais simplement ajouter à tout ce qui a été dit que dans les efforts pour appréhender l'avenir de façon plus efficace, parallèlement au rapport dont il a été question tout à l'heure, il faut savoir qu'un autre rapport a été rédigé pour les autorités européennes de notre ami membre de l'ALAI, Paolo Marzano. C'était un rapport pour le Parlement européen qui voulait justement appréhender cette question, prévoir des solutions. Pour le moment, il n'y a pas de suite à ce rapport qui a été rendu il y a à peu près un an. Il n'est pas absolument simple. La Commission réfléchit aux solutions possibles. Il n'est pas absolument certain qu'on s'oriente vers la création d'un nouveau quasi-droit voisin, mais peut-être que les efforts porteront sur justement la mise en œuvre d'une protection plus efficace à partir des droits éventuellement que nous connaissons. Et de ce point de vue, le dernier exposé était très riche puisqu'il vous a montré la palette de possibilités, mais aussi le nombre très très important de difficultés. Alors, je voudrais d'abord demander, avant d'engager un débat avec la salle, aux autres panélistes si vous avez quelque chose à ajouter, Sophie par exemple, sur cette difficulté.
Merci. Alors effectivement, dans notre rapport, donc, la partie principale portait sur les recours disponibles au niveau national et sur les injonctions dynamiques et injonctions dynamiques en direct, donc, qui ont été abordées très effectivement par Célia, donc je ne reviendrai pas dessus. Je voulais signaler aussi qu'on a vu également d'autres manières d'intervenir, notamment à travers des organisations, des organismes, des entités administratives dans certains pays qui se sont révélées assez efficaces, comme en France par exemple pour l'ARCOM, mais également des Memorandum of Understanding ou des codes de conduite, comme par exemple l'exemple du Portugal, qui a été mis en place en 2015 et qui a été plus tard étendu aux événements sportifs en direct, le football, et qui semble donner des résultats aussi très intéressants. En plus de cela, donc, il y a la partie mécanisme de notification et retrait, je ne sais pas si je le dis correctement en français, qui, nous, quand nous avons fait cette étude, c'était avant le Digital Services Act, mais peut-être qu'aussi à travers le DSA, il y aura des améliorations pour la mise en œuvre effective et l'utilisation de ces mécanismes, où nous avons constaté une grande diversité d'approches au niveau national, et c'est aussi quelque chose qui peut intervenir dans la lutte contre la piraterie en ligne des événements sportifs.
Bueno, desde el punto de vista de mi presentación, creo que sería interesante para poder obtener medidas rápidas y eficaces que pudiéramos obtener algún tipo de armonización respecto de cuál es el derecho que vamos a defender. Simplemente eso.
Merci. Alors, je vous propose maintenant d'engager un débat avec la salle. On voit assez mal d'ici, on a les projecteurs de face. Donc je vais vous demander de vous présenter, de lever le bras, la main, et de vous présenter au moment de prendre la parole. Il n'y a pas de demande de prise de parole. Ah oui, pardon. Alors, il faudra que quelqu'un se dévoue, c'est bien. Non, devant. Merci.
Hello, good morning to everyone. Thank you for this wonderful presentations and the panel. My name is Daphne Papadopoulou, and I'm the acting director of the Hellenic Copyright Organization. It's not actually, I don't have a question, but I want very, very briefly to mention, just to give you an idea, that in Greece we have actually also an out-of-court system. It's an administrative authority actually that's it's working on combating online piracy. And lately we had an amendment almost 1 year ago, and regarding live blocking, and especially for live events, actually more for sports events. And we have the possibility not only for DNS blocking, but also for IP blocking. And we have also established this 30 minutes that we have the ISP as soon as receives this notification, it has to block the access, so in order to be more effective. And within, let's say, less than 10 months, we have only for this procedure, for live blocking, because also we have the other normal procedures. We have blocked the access to 608 domain names and 587 IP addresses, while to the other procedures we have almost 600 domain names and 4 IP addresses. So it's actually working quite good. Although I have to mention it's working very good because also we have an excellent cooperation with the ISPs. So just to give you also the example of Greece. Thank you.
Merci. Est-ce qu'il y a d'autres demandes d'intervention?
Hi, good morning. My name is Daniel Reis. I'm a lawyer, and my experience is working for sports organizers. I have a comment and a question. My comment, I'm a Portuguese based in Lisbon. A comment to Sophie is that the Portuguese mechanism is unfortunately DNS based. It's not IP based, so its efficacy is it's very much a cat and mouse exercise, and so the numbers might be impressive in terms of number of websites blocked, but in terms of overall piracy reduction, it's not that fantastic. And my question to Celia is, focus has been lately very much directed at wholesalers, because they need to have very high capacity servers because of the quantity of content, and so they are not that difficult to identify them, but the pirates use geographic dispersion. They are incorporated in the company, which is a PO box. The shareholder is outside the European Union, and the people who work are in different countries of the European Union. So it's a nightmare to chase them. My question for Celia is, have you any experience on, hopefully, any tips on how to catch the wholesalers? Thank you.
No, unfortunately, I have no tips for this. This is the reason why in Germany we have the subsidiarity principle, and I think it is the only possibility to act against the internet access provider, because these are the ones they are available. They are not relocating their businesses to foreign countries. And so I think we have no other possibility as to hold on these.
Pour rebondir sur votre observation et pour l'exposé précédent, en France, on n'a pas de principe de subsidiarité. On peut s'adresser directement aux fournisseurs d'accès. Alors, on est obligé de passer par le juge. Et trouver un juge à 21h au moment où commence le match, c'est trop tard. Ce qui fait que le système repose sur une logique différente. La loi française, qui est entrée en vigueur au 1er janvier, prévoit le système suivant. Les titulaires de droit, avec éventuellement le soutien d'une autorité administrative indépendante, font l'observation des actes de piraterie. Et quand un site a été repéré comme étant manifestement pirate, on demande au juge le blocage. Le blocage est prononcé, les fournisseurs d'accès doivent le mettre en œuvre. Puis nous avons derrière des mesures dynamiques sans avoir à repasser par un juge, c'est-à-dire que la mesure qui a été prononcée, l'injonction par le premier juge, est étendue à tous ceux qui ont des contenus semblables. Et on peut même encore aller plus loin grâce à l'intervention de l'autorité administrative indépendante. Alors je parle sous le contrôle de ma collègue et amie Alexandra Bensamoun, qui a été membre de l'autorité administrative indépendante, ou qui l'a quitté juste au moment où elle prenait en charge ce travail, qu'elle me corrige si je dis des bêtises. Apparemment pas. Est-ce qu'il y a d'autres demandes d'intervention ? Donc, en fait, si vous voulez, en France, de façon tout à fait paradoxale, les titulaires de droit voisin du droit voisin sont mieux protégés que les titulaires du droit d'auteur. Ça fait rêver quand même. Hein.
Oui, je vois une vengeance de la part de Pierre Sirinelli. Il ne veut absolument pas me donner la parole. Sylvie Forbin, donc je ne me présente plus, puisque j'ai parlé hier, vous m'avez identifié. Je voulais simplement ajouter à tout ce qui a été dit que, comme je l'ai un tout petit peu indiqué hier, ce thème fait partie des sujets sur lesquels nous avons commencé à travailler assez récemment, je dois dire. Une étude vient d'être publiée qui va peut-être aider aussi avec un autre angle les réflexions par nous, réalisées par Jacques de Vera, professeur à l'Université de Genève, et qui a pour titre Reference Guide to Sustaining Sport and its Development through Intellectual Property Rights. C'est donc un exercice qui a plutôt pour vocation de montrer comment les droits de propriété intellectuelle peuvent soutenir le développement de cette activité et le développement économique des pays, plutôt que, et bien sûr, la contrepartie, c'est-à-dire la défense de ce droit. Mais je dirais, pour rajouter sur la complexité du millefeuille, du point de vue de l'OMPI, il y a bien sûr la question de savoir comment développer un quasi droit voisin, mais il y a également tout un angle qui couvre le droit des marques, le droit des brevets, sur lequel nous avons commencé à nous interroger et sur lequel nous allons engager une réflexion un peu cross-sectorielle dans les mois à venir. Et c'est, en m'adressant à notre collègue argentin, c'est ce qui me frappe dans ce que vous avez dit, c'est-à-dire vous privilégiez, il semble qu'il soit privilégié en Amérique latine, le droit à l'image et ce qui en découle. Il est possible que l'intervention d'autres droits puisse couvrir de façon plus ample et donc protéger aussi l'industrie du sport du point de vue de la propriété intellectuelle. Nous sommes sur un plan normatif pour l'instant uniquement attachés à travailler à cette question à travers notre projet de traité sur la radiodiffusion qui bien sûr intègre ces éléments, et ce domaine et ces préoccupations, mais nous allons sans doute ouvrir un autre champ de réflexion pour lequel je lance à nouveau un appel à réflexion pour nous aider à le développer. Voilà, merci.
Merci. Je crois qu'il y avait une demande d'intervention ici.
Okay, so my intervention will be about enforcement. I'm gonna be, I'm gonna do my intervention in Spanish. Yo soy Julián Ruiz, soy el presidente del Centro Colombiano del Derecho de Autor, que es el capítulo colombiano de ALAI, y soy asociado de Baker McKenzie. Y me gustaría preguntar, me llamó mucho la atención el tema del enforcement con estos servicios pirata, porque la realidad de las cosas es cuando solicitamos una medida cautelar. En Colombia tenemos unos cuantos casos, tenemos aproximadamente 5 o 6 casos, en donde hemos logrado ya medidas cautelares en contra de servicios IPTV y en contra de esos piratas que retransmiten, que transmiten una señal, pero a través de servicios web IPTV. Pero la problemática que ha surgido ahora es que en realidad cuando uno solicita una medida cautelar, una medida preliminar, pues el juez se puede tomar unos meses en decidirla y en esos meses el pirata ya cambió la IP y ya cambió el nombre de dominio. Entonces, claro, tenemos una medida cautelar que estamos tratando de solicitar que es un poco más efectiva y un poco más rápida, pero la realidad es que incluso el pirata es aún más efectivo y más rápido que la misma justicia. Y cuando ya sale la medida cautelar, en contra de un servicio IPTV y nos dicen que te bloquean la IP, pues la realidad práctica es que ya no sirve de mucho porque el mismo pirata cambió otra vez de IP y tengo que volver a solicitar otra medida cautelar en contra de otra IP que seguramente cuando salga ya habrá cambiado nuevamente de IP. Y es una lucha constante en contra de los piratas y es un poco frustrante con la justicia. Entonces, quisiera preguntarles si ustedes ven alguna alternativa. Digamos que en otras áreas del derecho existen unas medidas cautelares de urgencia de 24 horas que uno podría pensar en la necesidad de implementarlo también para este tipo de infracciones que son tan rápidas y tan cambiantes. Esa podría ser eventualmente una solución, pero si ustedes ven alguna otra solución para combatir esta realidad, y es que el infractor y el pirata es incluso más rápido que la misma justicia.
I think this is the point where the dynamic blocking techniques comes to be important, because when you have a dynamic injunction, you can just mention the new IP address and you don't need a new legal proceeding to get a new injunction. And when we can implement it, that after notifying the internet access provider of a new IP address or domain name, and when they then implement a DNS block or an IP block within 30 minutes, I think that would help much.
Merci. On va prendre une toute dernière question, parce que je ne voudrais pas qu'on commence la journée avec retard. Victor. Victor qui sera responsable du retard.
Ouais, ça serait ma responsabilité. Je voudrais ajouter quelque chose à ce qu'on a dit. Nous avons au Portugal depuis 2021 une loi qui nous permet d'aller un peu plus loin en ce qui concerne le blocage. On peut faire le blocage par IP dans certaines conditions, notamment le fait de ne pas avoir une réponse de la part de l'entité responsable du site pirate. Et nous avons 48 heures pour avoir une réponse. Et si c'est le cas, l'Internet fournisseur il-même peut et doit effectivement faire le blocage. Et tous les fournisseurs Internet doivent le faire. Comment? Parce qu'ils ont une commande spéciale de la part de l'Inspection générale des activités culturelles, qui est l'autorité de supervision en matière de droits d'auteur. En effet, Luís Silveira Botelho, c'est l'inspecteur général, il n'a pas pu être ici aujourd'hui pour nous expliquer la façon comme fonctionne ce mécanisme, mais il est très efficace en ce qui concerne les transmissions en direct des événements sportifs, justement ce qu'on a traité ce matin. Donc, il fonctionne dans un écart de 15 minutes et tout est bloqué. Et à ce moment-là, personne ne peut continuer à assister au jeu. Et ça, c'est la façon de le faire. C'est l'unique façon de le faire. Pour tous les autres cas, qui ne sont pas la transmission en direct, nous utilisons effectivement le domain name, le blocage par nom de domaine. Mais pour cet effet en particulier, il y a la permission de le faire avec le blocage d'adresse IP. Et ça fonctionne. Et ça fonctionne.
Merci. J'ai commencé en disant que les Portugais avaient ouvert toutes les nouvelles routes maritimes dans l'histoire. Et bien là, ils viennent de nous montrer qu'il y a des routes juridiques à explorer ensemble pour améliorer la situation des ayants droit. Je voudrais remercier tous les participants à ce panel pour leur très riche contribution. Et nous allons rendre la salle avec 5 minutes seulement de retard, totalement imputable à Victor, comme vous l'avez tous constaté. Merci à tous.
Okay. Please be seated so that we can start this session sort of on time, and that way you can have lunch sort of on time.
I like to have a look on the website performance.
I forget. I started and I'm so concentrated on talking, and I forget at what time it started.
Okay, yes.
Okay. All right, please be seated. We're going to get started. All right, this session, titled Protection of Creative Contributions to Theatrical Performances, will, I hope, be quite thought-provoking, because one of the themes that we're going to explore is in a Congress devoted to neighboring rights, whether the contributions that will be discussed in this session actually should be the subject of neighboring rights or of a proper copyright. The distinction between neighboring rights and copyright in systems that have the neighboring rights, the United States, as you know, does not. But for those systems that have neighboring rights, the classic distinction is between creation and interpretation. This is a distinction I have never understood, maybe because I'm an American. But I think that our three speakers are going to do quite a persuasive job of demonstrating that there is essentially no meaningful border between interpretation and creation, and they will plead in their various ways for copyright recognition of the contributions of theater directors, actors, and sound and lighting designers. Another aspect that they will discuss is what is the practical importance of protection, whether it be copyright or neighboring rights. There's obviously a difference in duration between copyright and neighboring rights. What, if any, other differences does it make in terms of remuneration or in terms of that intangible but essential quality of the respect owed to the creator/interpreter. So with that, I'd like to introduce our panelists in the order in which they will be speaking. Isolde Gendreau, who is a professor at the University of Montreal in Canada and is a vice president of Alaï International, and in line with her country, she will present in 2 languages, I believe first in French and then in English, but consecutively, not concurrently. Then she will be talking about theater directors. Then she will be followed by Irina Eidsvold Toyen from Norway, who is a professor at the Norwegian Business School and an actor. So I believe that what she says will come very much from the heart and from direct experience. And finally, last but not least, Rudolf Leška, who will be talking about sound and light design. Rudolf is the president of the Czech group. As many of you know, he was the host of the last pre-pandemic ALAI Congress. He is also probably known to many of you as a great lover and expert in opera, and I believe that some of his interest in sound and light design comes from his attention to opera productions. So with that, each speaker will have 20 minutes. Victoria is going to be our timekeeper, and then we will have some time for general discussion. Thank you.
Merci beaucoup, Jane. J'aimerais bien normalement remercier Victor pour cette invitation à venir vous parler d'un sujet que j'ai trouvé absolument passionnant, qui est celui de la protection des metteurs en scène. Je trouve vraiment que c'était une excellente idée et je crois qu'avec le panel que nous aurons, vous trouverez qu'il y a beaucoup à dire sur ces questions dont on entend peu parler dans les congrès. Mais traiter de la question des metteurs en scène en particulier n'est peut-être pas un sujet particulièrement évident pour une association très internationale comme l'ALAI, parce qu'il n'y a aucune mention expresse des metteurs en scène dans les conventions internationales ou dans les conventions régionales, sauf peut-être dans le traité sur l'Union économique eurasiatique de 2014, qui réunit l'Arménie, la Biélorussie, le Kazakhstan, le Kirghizstan et la Russie. Malgré tout, la protection existe et on assiste surtout à une sorte de valse-hésitation entre le droit d'auteur et les droits voisins. Il y a des pays où les metteurs en scène sont protégés par la loi, des lois qui leur reconnaissent carrément un droit d'auteur. On pense par exemple au Portugal, l'hôte de notre congrès, mais aussi au Kenya ou au Sénégal. Il y a d'autres pays où la loi les protège en tant qu'artistes-interprètes, donc détenteurs de droits voisins. Et on pense ici évidemment à la Fédération de Russie et les autres pays dans cet accord que j'ai mentionné, le Japon et l'Espagne. Il y a des pays où, sans direction législative, ce sont des tribunaux qui se sont présentés. Et s'ils sont en faveur de la protection, c'est rarement de manière très affirmée. C'est pas toujours aussi net qu'on aimerait. En France, on les considère comme des auteurs, d'après la jurisprudence. Et en Allemagne, on hésite entre le droit d'auteur et les droits voisins, et on penche plutôt du côté des droits voisins. Tandis qu'en Italie, on a cette même hésitation et on penche plutôt du côté auteur. Mais là où on s'entend en Italie, c'est que dès qu'il est question de mise en scène d'opéra, ce sont des auteurs. Dans les pays que vous reconnaîtrez comme étant des pays de tradition de copyright, on est moins en faveur de la protection. Il y a eu une décision américaine importante en 2006, une décision qui vient de la Cour du district sud de New York, qui en fait n'a pas vraiment réglé la question. Ils disaient, c'est pas vraiment notre rôle ici, mais ils ont au moins discuté de manière générale de ce qui se passait sans en venir à une conclusion ferme. Au Royaume-Uni, au Canada, en Inde ou en Jamaïque, il n'y a pas de décision de jurisprudence et il y a surtout des spéculations de la part de certains auteurs dans la doctrine, et en général, ces spéculations vont plutôt vers l'absence de protection. Donc, il y a manifestement un malaise, des réticences à protéger les metteurs en scène, Alors, que font-ils? Qu'est-ce que l'on peut faire lorsqu'on est metteur en scène et qu'on ressent le besoin d'être protégé? J'aimerais voir avec vous d'abord les sources de cette réticence de qualification de protection à leur égard et ensuite les moyens de protection qu'ils essaient de concevoir pour obtenir quelque chose qui les réconforte. Dans les sources de réticence à la protection, j'ai cherché à subdiviser en deux sous-parties. La première me permettant de regarder davantage la nature du travail des metteurs en scène et la seconde pour regarder justement différents éléments à la lumière de critères juridiques de protection, que ce soit des critères de droit d'auteur ou de droit voisin. Donc, pourquoi une telle hésitation? Il y a d'abord, je dirais, pour moi, ce qui est le facteur numéro 1 de la difficulté de les protéger, c'est que la création du metteur en scène se matérialise pour le public à travers des prestations de personnes qui peuvent elles-mêmes prétendre à une forme de protection. Donc, je pense ici aux comédiens, aux danseurs, aux chanteurs, aux créateurs de décors et costumes, ceux qui conçoivent les éclairages, la conception musicale. Donc, le public perçoit ce que ces personnes-là font, et ce que ces personnes-là font, c'est, on l'espère, en cohésion avec la vision du metteur en scène. Donc, pour le membre du public, ce qu'il voit, c'est un travail de mise en scène à travers le travail d'autres personnes. Le travail du metteur en scène peut aussi varier avec le temps, tout en demeurant relativement le même. Donc, il y a une certaine stabilité dans ce qu'il fait, mais on sait qu'à travers le temps, surtout quand les productions durent un certain temps, il peut y avoir des modifications. D'abord, il peut y avoir des changements de distribution qui peuvent avoir une certaine influence. Il peut y avoir des éléments de décor qui sont modifiés parce qu'ils ne sont pas arrivés à temps à cause des perturbations dans les avions. Et il y a tout le travail de dynamique des représentations parce qu'on est dans un milieu qui est extrêmement humain et la dynamique entre les différentes personnes qui travaillent, des acteurs qui ne s'aiment pas ou des acteurs qui s'entendent bien, ça peut avoir un impact sur la façon dont ils interprètent le travail. Il y a aussi le rapport du metteur en scène avec l'auteur du texte ou de l'œuvre qu'il met en scène. Alors, ces textes ou ces œuvres, parce que je pense surtout opéra, sont plus ou moins variés. Vous avez des œuvres qui relèvent du domaine public. Vous avez d'autres œuvres qui ont été faites par des auteurs encore vivants, mais ce sont des œuvres qui ont connu leur forme plutôt définitive. Et vous avez aussi des représentations de création, des textes vraiment nouveaux où tout est découvert en même temps, la mise en scène et le texte ou le travail, la chorégraphie, la musique de l'auteur, de ce qui est mis en scène. Il y a aussi l'impact des didascalies sur le travail du metteur en scène. Certains auteurs peuvent être très dirigistes dans ce qu'ils veulent de la part des personnes qui sont sur scène, tandis que d'autres le sont moins. Donc, la marge de manœuvre ou l'originalité ou la personnalité ou la créativité du metteur en scène peut se manifester, peut varier sensiblement d'une œuvre à l'autre. Et donc aussi, comme je disais, la dynamique, les rapports de force entre ces différentes personnes peuvent varier aussi selon les types de productions. Il y a des productions où la vedette, si on peut dire, c'est le metteur en scène. Il y en a d'autres, la vedette, c'est un certain comédien. Et d'autres encore, c'est l'auteur de l'œuvre. Et tout ça a une influence sur le statut que représente le metteur en scène. Si on regarde la situation aussi un peu plus nettement du point de vue des droits voisins, on pourrait comparer le metteur en scène, ça arrive souvent, au chef d'orchestre. Sauf que le chef d'orchestre, il est là tous les soirs à diriger l'orchestre. Tandis que le metteur en scène, il n'est pas visible, il n'est pas là de représentation à représentation. Donc, on a ici aussi une difficulté à voir ce que fait notre metteur en scène dans une catégorie de droits voisins. Mais justement, pour moi, c'est l'occasion de regarder cette situation d'un point de vue des critères juridiques. Alors, au départ, mon parti pris, c'est qu'un travail de création, c'est tout autant l'apanage des auteurs que des artistes-interprètes. Donc, il y a de la création dans le domaine du droit d'auteur et il y a de la création dans le domaine des droits voisins. Et c'est extrêmement difficile, je croirais, d'envisager un statut où on va alterner entre les droits voisins et le droit d'auteur selon l'ampleur de la contribution du metteur en scène. Ça me paraît assez difficile à gérer pour tout le monde. Si on regarde du côté des droits voisins, il y a déjà l'absence physique de la personne et il y a la pérennité de sa création d'une représentation à l'autre, tandis que la prestation d'un artiste-interprète peut facilement varier d'une représentation à l'autre. Si on regarde du point de vue du droit d'auteur, une question qui revient souvent, c'est la question de la titularité. Est-on en présence d'une œuvre de collaboration? Parce que les collaborateurs du metteur en scène peuvent être très nombreux et ils peuvent varier aussi au cours du temps. Et ce qui peut signifier que de nouvelles contributions qui s'ajoutent, ça vient compliquer l'identification de cette œuvre de collaboration. Donc, on a vraiment une situation complexe en termes des règles concernant la titularité. Dans les pays où c'est important, et je dirais en particulier dans les pays de copyright de tradition britannique, sauf américaine, donc copyright Commonwealth, il y a la question de l'identification de la catégorie d'œuvre à laquelle appartiendrait le travail du metteur en scène. Est-ce une œuvre dramatique? Il y a en général 4 catégories, littéraire, dramatique, musicale, artistique. Donc, il y en a qu'on peut éliminer. Dans la catégorie des œuvres dramatiques, les énumérations sont-elles à titre d'exemple ou non? Si c'est une liste fermée, est-ce qu'on peut les rapprocher des chorégraphes? Donc, là aussi, il y a des interrogations qui peuvent vraiment avoir leur importance sur l'existence d'une protection. Évidemment, ce qui est dans la tête de tous, c'est la question de la fixation du travail du metteur en scène. Est-ce que son livret du souffleur, est-ce que le livret du souffleur correspond à la fixation du travail du metteur en scène? Quand il y a un enregistrement vidéo, c'est peut-être plus facile de considérer qu'on a ainsi fixé le travail du metteur en scène, mais parfois, quand on est dans des représentations théâtrales qui ne sont pas filmées, donc il y a ici encore un certain souci. Ça m'amène à la question du rapprochement le plus fréquent qui est fait, qui est celui du rapprochement avec le réalisateur de film. Le statut d'auteur d'un réalisateur de film n'est pas vraiment controversé et on peut facilement dire que le réalisateur de film, c'est le metteur en scène dans l'univers de la cinématographie. Mais il y a une certaine différence qui est liée à cette question de fixation, c'est que justement, on peut identifier le film, en parlant vraiment du support matériel, on peut identifier ce film comme étant un objet de protection autonome. Et à ce moment-là, c'est plus facile de dire que le réalisateur est l'auteur un des auteurs de ce nouvel objet qui a été créé. Tandis qu'avec les mises en scène, on n'a pas du tout la même situation. Il y a une situation aussi qui est très présente dans le questionnement par rapport au metteur en scène, c'est les rapports avec le droit moral de l'auteur. Et le travail du metteur en scène peut faire en sorte que la mise en scène soit assez fidèle à ce qu'aurait voulu l'auteur du texte, ou bien elle peut vraiment s'en écarter de manière assez importante. Et je dirais un exemple assez bien connu, c'est celui de la pièce En attendant Godot, qui, avec une distribution entièrement féminine, a été considérée comme étant en violation du droit moral de l'auteur, Beckett en France, mais n'a pas été considérée une violation du droit moral aux Pays-Bas. Donc, comme vous pouvez voir, j'ai beaucoup plus de questions que de réponses. Et la situation des metteurs en scène, elle est exacerbée par le caractère traditionnellement local des représentations théâtrales ou scéniques. Ça se déroule dans un certain lieu et c'est vraiment quelque chose qui est assez évanescent. À cause de ça, dans chaque pays, on s'habitue à un certain mode de fonctionnement et finalement, on ancre ce fonctionnement dans des habitudes et on ne cherche pas nécessairement à en sortir. So I'd like now to switch to English to talk about the protection measures that stage directors have been able to come up with in order to obtain some form of protection. Because the quest for protection, and especially the quest for a certain status, is essentially a quest for bargaining power. And this bargaining power can be individual, because you can have stage directors who are extremely famous and they don't need any special kind of support. You know, their name is sufficient, Peter Brooks or Zeffirelli. And there are others who find strength in numbers, who are less stars of the stage directing world. And in many countries, they are left on their own and there are no associations to help them. Another issue that has come up is that sometimes stage directors can be employees of the theaters. And this is probably truer in cases where you have theater or opera houses that provide repertoire productions that go on year after year, where they may have a few stage directors as employees for their own protections. Otherwise, the kind of bargaining power that they try to seek can be achieved through professional associations and through collective management organizations, CMOs. If we look at professional associations, they can definitely help, but the help they provide can vary from country to country. Some have very limited powers. They're not allowed to lobby. They cannot negotiate contracts with producers. They can offer guidelines, which is perhaps the best they can do, but these guidelines may not be binding. So this is better than nothing, but concretely it doesn't offer that much, except perhaps an opportunity to vent frustrations. On the other hand, some other associations are very structured and therefore more or less efficient. It looks like the US Professional Association is quite structured and quite efficient. It's the Stage Directors and Choreographers Society, so you see that the stage directors are associated with choreographers, and this is particularly true, I've been told, in cases of musicals where the choreographers of the musicals end up being very much the stage directors as well. In the UK, you have Equity, which was formerly British Actors Equity Association, and here Equity represents, therefore, the stage directors and the choreographers, but also actors. So you've got a combination of these statuses. And in Canada, we have two associations divided along linguistic lines. So there's Canadian Actors Equity, and in Quebec, we have l'Union des Artistes, the Union of Artists. Because the status is not so clear, the contracts by the US Association, the SDC, their contracts refer to the stage director's intellectual property rights. So they don't name it precisely as copyright, but they just give a broad statement. We see that Equity in the UK is also very active. Equity has negotiated agreements with different producers, West End producers, off-West End producers, subsidized theaters, outside London, small theaters. So there are various categories there, and these are just basic agreements, and the stage directors can negotiate upwards depending, again, on their bargaining power. In Canada, the situation is not identical in that the agreements negotiated by the Canadian Actors Equity is not binding, but the agreement negotiated by the Union des Artistes in Quebec is binding on the producers. An issue that has come up with these associations is that they are concerned with increased filming of stage productions, officially for archival purposes, but sometimes they think that these archival purposes end up being other types of purposes. So that is a concern for them. And they are also concerned about the ownership of the prompt book, because the prompt book, it's one thing to say that the prompt book would be where the stage director's work is actually fixed and where we can identify his work. But then there's the issue of who will own the actual book in which you have all these indications. Collective management organizations now. I think I'll need a bit of water. The SACD in France does some management, and essentially in Spain, you have a mixture. This is not going to be good. So you have associations, you have countries where there's a mixture of professional associations and CMOs. And of course, there are CMOs in the countries of the agreement with Russia. So since there's very little time left, I'm ready to move to my conclusion. I believe I've presented you a very motley picture of what it is for stage directors. And it could probably develop like this because there's no formal intellectual guidance. And this is perhaps a bit similar to moral rights that also develop in all kinds of ways because the minimum status of moral rights is fairly minimal. So the mere mention of stage directors in the law may be insufficient, and it may be good to think about devising certain rules, even if they were protected in a statute. And it's an issue where their creativity is not really challenged. Yet, we have all sorts of questions about whether they should be protected or not. And I find that there's a real irony with this situation when we compare the haste, when we compare their situation with the haste with which we've protected computer programs in copyright law, and with which we are now talking about other technical developments. And therefore, perhaps the basic question that we can have with respect to stage directors is, well, what does copyright law really protect? I'd like to leave you with this question. Thank you for your assistance.
Thank you very much, Isolde, for soldiering on as well. I neglected to mention that Isolde is the co-author of a WIPO study that was referred to yesterday, covering the rights of stage directors in a number of different countries. That study is, of course, available from WIPO if you'd like to know more.
Hello, everyone. Thank you so much for letting me present this very important topic. As a young law student, I got accepted to the Norwegian State Drama School, where I became an actor. When I returned to law and intellectual property law some years later, I started thinking, why are actors only characterized as performers? Actors are also authors. According to European copyright law, actors and other performers are seemingly only protected through a neighboring right regime. Does this mean they cannot achieve copyright if they fulfill the requirements for copyright? That is the research question for my presentation and the center of some of my latest research and an article I'm working on. Okay, why is this not moving? And moving too fast. Okay. Okay. We'll trust this one now. First, I will shortly describe what a performer do. I wrote a PhD in 2015 where I interviewed different performers that expressed how their working process in advance of their performances were. The interviews encompassed different types of performers, in addition to actors, dancers, musicians, music directors, and theater directors. Some of the main findings will be shortly presented here. Then I will briefly present the neighboring rights structure, also because it is of importance for why copyright for performers is significant. Then I will also shortly present the requirements for copyright in the EU law and subsume an actor's work in connection to these requirements. I will then consider if international obligations and treaties hinder copyright for performers. Conclusively, I will substantiate why EU ACWIS, as I see it, demands copyright for performers, as long as she fulfills the originality requirement. So what does a performer do? I frame my research with a starting point from the definition of a performer as in the Rome Convention. A person performing a work or folklore. Roughly speaking, a performer has 4 main stages in the working process ahead of a performance. Firstly, the performer chooses how to interpret the work she's performing, then how to perform the interpretation, physically, technically, and psychologically. Then the performer performs the interpretation through use of herself or an instrument if she is a musician. While she performs, she makes an improvisation, trying to live the interpretation and at the same time communicating with the public listening or being present. Sometimes there are no public, but a recorder or a film or video camera replacing the addressee for the performance. In this presentation, I will highlight the actor, but through my research, I found that all performers have similar process, but use different means to express their choices. An actor interprets the script. Then she chooses the underlines and the actions in the situations and transmit words to speech or silence. She chooses arrangement, how to walk and what to do physically on stage, to underline the interpretation or to hide it. She personifies the character through voice, rhythm, body language, and movements. The actor is the instrument. Then she improvises while performing her choices, more or less consciously chosen, trying to live on stage, at the same time communicating with the public. A dancer has a similar process, using movement as her words. Performers are usually granted the neighboring rights structure. What kind of protection is that actually? The neighboring rights structure is regulated, for instance, in the Norwegian Copyright Act, paragraph 16, with reference to the Rome Convention, Article 3, and WPPT, Article 3. A performer has exclusive right to manage her performance of a work or an expression of folklore. The neighboring rights structure offers a kind of personality rights. There are no requirements to the performer, no demands in the performance, neither time-wise nor quality-wise. Everyone performing a work or folklore can claim neighboring right protection. The neighboring right structure not being different from a personality right protection is also supported by legal theory. Neighboring right is a kind of personality right. Are actors authors? The Norwegian Copyright Act is my point of departure. Through the EEA agreement of 1994, Norway is part of the EU acquis. Broadly speaking, this means Norway has to interpret the Norwegian Copyright Act according to EU law, which means, again, what I find is also decisive for other EU member states. The Norwegian Copyright Act, paragraph 2, states that the one creating a work has copyright and is the author of the work. A work has to be compliant with EU law. The Norwegian, the basic requirement and threshold for copyright is originality. According to the InfoPack case, originality shall be interpreted in line with EU's international obligations and other EU directives. In EU directives, it is stated original in the sense that it's the author's own intellectual creation. Through the InfoPack case, it's also determined that the copyright term is harmonized within the EEA area and that the threshold is low. 11 words can be sufficient for protection by copyright. In the Painter case, the EU CJ, the European Union Court of Justice, expresses more in detail how originality is decided. Originality is when someone's own intellectual creation is expressed. Someone's own intellectual creation comes through when free creative choices are made, and this is expressed in a work. In the judgment, it is also stated that all works have same scope of protection. When you apply these requirements to the process of an actor, you will find that an actor translates words to speech, steps to dance, etc., which is a kind of an adaptation. She also takes free and creative choices on how the interpretation and the characters shall be expressed, by choosing everything from underlines of the text and actions on stage to choices of what to wear or how to move. In short, actors select the interpretation and decide how to present the choices. And how to present the choices. In legal literature, which Jane Ginsburg has written, this is expressed as the essence of originality, qualifying for copyright. So far, actors are authors. But is copyright for performers in conflict with international conventions? Berne Convention is a minimum convention, which means member states can give better conditions. Several Berne Convention countries have copyright for performers, like US and Canada. Already during the process of constituting the Berne Convention, many countries wanted to include performers as protected under the convention, stating their similar creative processes. Also, interpretation of the Berne Convention can lead to such a conclusion. The Berne Convention is not a barrier, as I see it. Other copyright conventions are minimum conventions too, and clearly stating that it will not interfere with other rights, for instance, copyright. As I see it, copyright conventions are not obstacles for copyright for performers. Is the EEA agreement an EU law that complies Norway to follow EU acquis on copyright an obstacle for copyright for performers? This question has at least two aspects. One perspective is how far the outreach of EU's copyright is. The second is the fact that EU in its copyright directives expresses a neighboring right regime an obstacle that hinders copyright protection to performers fulfilling the originality requirement. The European Court of Justice confirms that EU copyright is not a person-oriented protection. It is work-oriented. If a work is original, it achieves copyright. The judgments also show that all kinds of work can claim protection. Not once has the court denied protection because of the kind of work, only because of lack of originality. Legal theory supports such an understanding. The neighboring right structure is expressed in several EU directives. When it comes to the question of whether establishing a neighboring right structure itself is an obstacle for copyright for performers, I can't see this as an obstacle either. EU offers double protection as copyright for performers in addition to neighboring right protection would be in several other situations. The term protection directive expresses that photography both can be protected as a photography and as a work. Through the database directive, we find that databases both can be protected as copyright and through a sui generis protection. Also, other regulations in the EU expresses similar. Same product can be granted other intellectual property protection and copyright, design, patent, personality right. Other EU sources support such a conclusion. As I see it, EU law demands copyright for performers fulfilling the requirement of originality. And why is this important? Because it's correct. And because the most important aspect of a performance is not that it is performed, but how it is performed. This is what gives it value. Societies all over the world has acknowledged the importance of creativity by establishing copyright. Also, because it's important for the development of cultures, giving incentive to more creativity. The protection for performers and performances should mirror this value. If a performance is original, the performer is an author, and she qualifies for copyright. Because it is not evident in the EU acquis, I think EU law must change and express this directly in its copyright directives. Thank you.
Well, good morning, or still morning, ladies and gentlemen. I hope you'll go quickly for a lunch, and I will entertain you before we do so with a contribution on stage and light design. And well, thank you for all the wonderful speeches we heard, because I will sort of follow up to them and explain or share with you some views on the work of these important theater people. Because in theater you need light and sound, and if you don't have light and sound, you don't see the actors unless you are staging the Silent Night or something like that. So this is the Silent Night staging, and I will have better examples, because the problems we are dealing here are imminent to theater, because in theater you need to obviously work with light and the sound, and perhaps the first light and sound designers were actually the playwrights. And we know from Sophocles and from other ancient authors that they counted in their plays with the movement of the sun and with the changing light in the theaters where their plays were performed. So here you can see that a theater from Delos, where the audience saw the actors on the stage, and also they saw the beautiful sea, which gave them an understanding that they are part of a bigger, let's say, of a bigger world, or that they are not, just individuals. And of course, the ancient theater makers, they were also great technicians and acoustic technicians, so they understood the laws of the acoustics. Fast forward, when you put the theater into the interior, you need to deal somehow with the light, what the Baroque artist did wonderfully. This is the Baroque theater from Český Krumlov in Bohemia, where and it's a splendid 17th century theater with original sets still available, and you can see an opera performance there. And what they can show you is an intricate machinery for the candles, and how with the candles they could really make a different atmosphere, like different light in the theater, and they were really like playing with the light and changing the light during the production with this wooden mechanical machinery. The third picture, that's the Bayreuther Festspielhaus designed by Wagner after Gottfried Semper. And as we know, Wagner was a big theater reformer, and he also reformed the light on theater. He was, I believe, among the first one, if not the first one, who actually shut down the light in the auditorium so that the people only saw the actors on the stage. And he also was obsessed with a perfect sound, and Bayreuth is an example of of how such an obsession can end up in a very splendid way. So sound and the light, the problems with sound and light are not new, and they're continuous in the theater. What the difference is that in the past there was only room for let's say simple technical decisions, or maybe more complicated, but still the technique did not allow you to make really a lot of free creative choices, or as the Biner case puts it, and as we will hear later today. So this has changed in modern theater, I think, and I will try to explain you first what a light designer and a sound designer do in theater. I started with the light designer. It's sort of more, I would say, understandable to me, at least. It's as mentioned, there has always been light design, but nowadays with the technique you have available, you can be really incredibly creative on theater. The first picture is actually quite an old picture. It's from 1960, and it's a production by Wolfgang Wagner. who was quite a reformer too, and he loved staging without any props on the stage. And as you can see, he used light to actually create the setting. So you can use the light instead of the props, instead of the sets, just to create the artificial land on the stage, so to say, by light. Robert Wilson is another excellent example of someone who works with light. He's also a director. And in this example, he had a delicate task in the opera, the Woman Without a Shadow, to do the light in a way that the actress does not have a shadow actually on the and this was a beautiful production of the Paris Opera in 2002, and it worked incredibly well. But nowadays you would find hundreds of examples of excellent light designs, and maybe this is not the best I could choose, because in both cases they are also directors, but we have also light designers who are only light designers. Usually nowadays they work in a team with one director, so if the director is assigned a task somewhere at the theater, he takes his or her own team and with the light designer, and it's the light designer task to execute stage director's idea. They of course work closely, and they work closely with the stage designer or the set designer. And at the end, what the light designer delivers to the theater, it's a technical file, more or less, and this is the fixation of the light design, and you can reuse it repeatedly. And since it is a digital file, you can of course even take it and use it at a different place. Always some minor or major adaptations to a different room or to a different space are necessary, but it's still always the same identifiable creation, the same identifiable light design. And I wanted to also draw your attention to the fact that there's a Tony Award awarded for the best lighting design, and actually since 1970. So I sort of have the feeling that in the theater community, in the artistic community, has been a long understanding that what the light designer is doing is a creative work. With the sound designer, there are many more questions, I would say, and starting from backwards, the Tony Award is awarded for best sound design, but only since 2008, and even there come some controversies whether actually is it an artwork for which we should grant a theater prize, and for 2 years they were not granting this prize. The commission was not working, the commission for the sound design. So it's interesting that even in the community, if we think about it, that there's some hesitation to accept this as a creative work. But I have allowed myself to put 2 very short videos, that's like 40 seconds each, to document somehow that perhaps there is something creative about what the sound designer does on theater. And don't think about the sound designer as a sound technician or as someone who is executing the sound design even at the live show or at the stage, because that may be very well someone different from the sound designer, from the person who designed the complete acoustic picture or the soundscape, let's say, of the show. And often, again, it is becoming very common nowadays that not only lighting designer, but also sound designer comes with is part of a constant creative team and comes to a theater when there's an assignment, and then works with local technicians on the sound design of a play. So here you can see, I'm not going to read it, what sound designer does, and let's have a look on it.
One sequence in particular on Frankenstein is where the ice cracks and reverberates on a very large area, and an Arctic storm with a howling wind is blowing at the same time. The Arctic storm gradually increases in volume, becomes more and more vicious. The ice fades out, and gradually the storm fades out.
So, well, scary, right? This was Jan Crawford from Abbey Theatre talking about his how he worked on a Frankenstein production after Mary Shelley, and you can see actually the video is much longer and it's very interesting. And but as you can see with sound, it's like less visible, it's more abstract, and maybe it's more difficult to conceptualize it as a work of art. And talking about what the sound designer does, I also picked another example, and this is Elena Kelleher from the London National Theatre talking about some of her productions, but it's a very short excerpt so that the artist talks by her own.
So a sound engineer deals with the technical side of things. So they make sure that everything works and that everything's plugged in correctly, and then they also balance sound really intricately. Whereas sound design, I actually make noise. I build the noises and the sounds. So it's almost more musical in that sense. My sound is often quite musical, as I said, and quite flowing, and you almost can't hear the end of one sound before the next one begins. So I treat it almost like a score. So I compose the sound rather than just kind of pick sounds to go in places.
The video is too long, but you would see on the video that even if you have one actors or one actress play, like a monodrama, there's a big room for the sound designer to influence not only the color of the sound and the dynamics, but also the whole emotional situation and the outcome of the story. And as one sound designer says it, the sound designer shapes the entire storytelling and viewing experience. Of course, perhaps that's something you don't know about, but that necessarily does not mean that there is no sound design if you don't spot it, because good sound design does not necessarily needs to be spotted. And so let's go to the legal analysis. As it's obvious, the sound design is somewhere between the utility and creativity, and as we have discussed it's somewhere between the creation and interpretation. The first question might be whether it's a work, if it's a work of applied art. Well, obviously not, because it does no. But still, there is a lot of utility or there must be some function that the work has to fulfill so that it is technically apt to be performed. So one question can be whether it's protected at all, whether it has the necessary threshold of originality, because as we can see here, we have also some light design and some sound design in the room, but perhaps it's too banal to grant it copyright protection, or at least I would hesitate to do that. But on the other hand, you have now, with these technical possibilities, a very intricate designs which need not only some technical understanding of the things, but also artistic vision. And often, it happens that a sound designer or a light designer is even not a technician or a technically educated person. So there are light designers who don't know how to put it in the computer, so to say, but they do the sketches and they do the whole lighting plan even without a computer, and then there's a technician who puts it into the computer and works with him or her how to best express the work which was sketched on paper before. So it does not necessarily need to be a technical profession. There's very little case law, which I actually didn't find any, but I'm sure there is some somewhere, which would deal specifically with the light design on theater or with sound design in theater. But there we have some case law from related fields. I quoted one case from Prague, which dealt with the light design of a concert show. It was only in the phase of the preliminary ruling, and then the case was settled. But the court said expressly that they have no doubts about the fact that this is a copyrighted work of visual arts, and that it is protected. With sound design, you might know of various different cases from different fields, mainly from the film. We have there's an often quoted decision of the German Supreme Court, which said that a film sound designer might be an author if he crosses a certain threshold of originality, and that otherwise the sound designer might be a performer. This is something we quoted already. I think Isolde talked about it, that there's a prevailing idea in Germany with which I don't agree, that certain people, like, I don't know, sound designers or stage directors are performers unless they are so original that they are creators and they are authors. And to me, you can either be a performer or a creator, or it either can be a performance or a work, but not like both at once, depending on the level of creativity. So this is, to me, conceptually strange. But anyway, we have this decision of the Supreme Court, which allows under certain circumstances the film designers to be authors. And as I have learned, it's my understanding that the German collective management organization, Bild Kunst, is accepting representation of film sound designers, and then distributes the residuals from the audiovisual use of their works. Anyway, this does not need, does not necessarily can be applied automatically to theater, but at least we can make the analogy. But in the literature, we can still read many, there are many question marks whether the sound designer is a performer or an author, and if he or she is an author, what is the work actually? Because if we say, okay, the lady we listened to said that she is composing the sounds, and if I hear that someone is composing the sounds, it sounds to me like that the person is a composer, right? And if you have a look on the contemporary electronic music, or even not contemporary, it's like from the 1960s onwards, all the electronic music in the so-called classical music, that's they are doing very similar experiments to what these people are doing when they are staging something. And the question is, like, is it really different from the musical work? And this question popped up in the Czech Republic because in the Czech Republic there's a collecting society, collective management organization for sound designers. And it has an authorization from the Ministry of Culture. They were able to convince the Supreme Administrative Court that a sound designer might be an author, not only in the context of film, but also in the context of recording of music and also sound design in theater. So they are representing actually also theater sound designers and distributing residuals when, for instance, there's recording of a theater show on TV. So, and then they collect some money from the further use under the collective management. And one of the questions was when if a sound designer is working with either with existing music and is adapting the musical work, or is creating something completely new with new sounds and so on, if it's not a musical work, because then it would be under the umbrella of the traditional PROs, right, like GEMA and OSA and etc. But the courts so far said that we have being guided by expert witnesses from the field of sound design, that it's something different from music, and that it's it's an autonomous work of art. So at least the Czech courts treat sound designers and even sound designers in theater as authors. And if we have a look around and the things like, the Tony Awards being awarded and all of that, and how they taught the sound design in theater school, art school, and so on, it seems to me that the development really goes towards the copyright protection of sound and light design, and sooner or later we will have to get used to this. So to me, my conclusion would be that it still needs a case-by-case analysis, but the development goes this way. So thank you.
Thank you very much. I think we can bring the lights up. I want to pick up with your question, what is the work? And I'd like to address it to the panelists and then open it up for discussion. We have about around 15 minutes if we end exactly at 1 o'clock for lunch. I'm looking at Victor if he wants to allow some more. But okay, so what is the work? I think we don't have too much trouble conceptualizing sound and light design as an autonomous work when it's not incorporated in the theater, right? So there's lots of son et lumière shows. There's a Danish artist whose name I'm forgetting, who specializes in sort of sequences of lights illuminating bridges and things like that. And I don't think there's any question that those would be a work of art. A stage director's prompt book for a public domain play, so we don't have the derivative work problem, is accepted for registration by the U.S. Copyright Office, and I've certainly seen books of famous directors' stage directions, so we can acknowledge that as an autonomous work. But how far does this go? These contributions, if they were incorporated in an audiovisual work, would be part of an audiovisual work, and we would recognize copyright in the totality. But is there a difference when we're talking about the stage? These contributions, are they autonomous? There is a precedent in the United States. The facts were terrible, but the bottom line was that an actor does not have a separate copyright in her performance. The court did not address the question, because it wasn't asked to, whether the actor might be a co-author of the audiovisual work. Because in audiovisual works, the elephant in the room, the ownership question, is generally resolved by work made for hire, presumption of transfer, and things like that. Perhaps not quite so systematized in the theater. So let me start with Irina. What is the work? Are you arguing for an autonomous copyright in actors' performances?
Yes. The work is, we know that we give parts to different actors because they will interpret the character in a different way. And we have no difficulties in these days to prove what the contribution is from night to night, because we have videos and different cameras and recording tools that can factualize what's happening on stage. But for a performer, the choices that are made, which is also how the European Court of Justice has been working, that is the job of the court to identify these choices. Are there any choices to perform this character in a different way? And has this particular actor made these choices? And I think measuring whether things is original in general is difficult, and I can't see that it's more difficult to identify a performer's contribution to a performance. When I go to theater, because I'm trained, and we all use specialized people to work with in the court when we have such cases, I can see whether it's a bad play or a bad direction, theater direction, or a bad actor. I can identify that because I'm trained. And I think that's how it can be also captured, these choices she has made to make this particular performance of an actor.
Assuming that one can identify the requisite originality, a big difference between a neighboring right and a copyright is that the copyright allows the author to say no, right? Which would be problematic, or some might think it was problematic in the context of a stage production. So then you probably have to have some regime of presumption of transfer, and then how different is it from a neighboring right apart from duration? But I want to pass the microphone to other panelists.
Well, one of the questions which is, to me, which can be used to draw the borders between neighboring rights and copyright is, or the works of authors, is the way of how you can replicate the work and what is an infringement of the work. Because if we say that, the performer, if an actor every night performs Hamlet, he has a distinct copyright in the performance every one of every performance, right? And there can be even different owners of both performance. One night it can be on TV and another night in theater and so on. And now, would you say that someone who is mimicking an actor because he's a famous actor or he's learning from him or something, would it be an infringement? That's a question we would ask in the traditional world of author's work. And why I took the mic also was because there was no time to address it specifically, but this is a question of the light design and sound design. And when I talked to the designers, I asked them, does it happen that someone replicates really like your sound design, for instance? And I was told, well, actually, this happens, but of course it's very difficult to prove that someone is inspired by certain solutions or something. But at least now with the digital file, it's like fixed, and you can take the file. But in a way, with light design, of course, you can replicate it, or with the works of visual art or literature, and this sort of this replicability. And on the other hand, the very personal nature of the performance rights and even the performer himself or herself cannot replicate the performance, right? That maybe is one of the differences between the works and the performances.
Thank you. I think one of the distinctions we can draw between the stage directors as author or as performer is related to one thing you've mentioned precisely. It's the fact that it's the qualification as a work for hire or a situation where the rights are or can be assigned to someone, if we make the comparison with films. And in such situations, it is possible to envisage that the director's rights or the performer's rights and everyone who participates in the movie creation, that the rights are assigned to the producer. But I think that in the case of stage productions, it's difficult to identify to whom the rights would be assigned. I don't think that the lighting designers or the performers would like to see as something common the possibility that the rights they have over what they do should actually be assigned to the director or to some producer, the owner of the theater or just a producer of a play. And I think that is a difficulty with the status of everyone in this room, so in these issues. Yeah.
I guess historically, actually, the theater owners did claim to own the play as well as everything around the play. But I think that we should open it up for general discussion. I see a hand over there. Yeah, why don't you stand up so that you can get a microphone? And please say who you are.
Hello, Thilo Gerlach from GVL, the Performers Collecting Society in Germany. I think, I mean, we have a long experience on stage directors who are members and based on neighboring right, and they get money from us. So I think this neighboring right for performers is not just an moral right, just to mention. I think we have to differentiate in our practice what is the exact work which is protected. And our members deserve their rights for contributing to the performance. They guide the performers, the actors, and that's why they are regarded as performers. But if they also have a good stage interpretation, I mean, we have this famous case of Konvichny, the gay widow, I think it's called, or funny widow of Strauss, who did it, this operetta in Dresden, and this was transferred to the First World War, because it was made during that time. And he claimed moral rights, and the court stated that he is an author because of that work. So, but this is a different task. One is guiding the performers, and one is thinking how to interpret an existing work, in that case an operetta. That's just, I think this is how we should differentiate as well. And regarding this idea of having authorship, a copyright for actors, I feel very uncomfortable, I must say, for certain reasons. Firstly, I deeply regret that the existing neighboring right for performers, which is a creative right, is obviously not attractive enough to really reward the creative actors. That's just one remark. Another remark is if you disconnect this originality from the work to be interpreted, I think the next step is that everyone who is original deserves copyright. And this is then something, I think there will be no borders left. You don't need this work, if I understand you right. So interesting people, original people, they all can claim copyright. And this is, I think, something which is very worrying. And as Mr. Leska said, we do have the problem of replication. If the performance is protected, everyone can act the same way without infringing the performance or the right in the performance. It's just protected to be exploited. But in that case, no colleague would be able to act in the same way. And my last remark, sorry for being so extensive, is you regret, I think, that all performers, irrespective of their quality, are protected. But with authors, it's more or less the same. And where to draw the border? Who is so original that he deserves a copyright? I think this is not administrable anymore. Just a few concerns. Thank you.
There was a hand on that side of the room.
Thank you. Johan Kaas from APO Artis. First of all, thank you very much. I think this was by far the most interesting discussion of the whole conference so far. It really brings us back to the core of what we're talking about, so thank you very much for that. And I've heard speakers excuse themselves and say, okay, I will not let you wait for lunch or coffee. We can wait for it. We're here for you, not for the coffee or the lunch, so take all the time you need to say what you want. But I will try to keep my talk as short as possible. First, Ms. Gendreau, you did an explicit explanation, and maybe what I am going to say is in the full study, but a little element you did not fully take into account when you made the comparison for the stage director between is it copyright or neighboring right, is the moment when he or she becomes dependent of the protection by rights. So the stage director of the theater piece is present every day. You made a reference to his or her presence, and when you said the difference between the music conductor is that it's not visible, but the performer himself does not need to be visible. It's the contribution that needs to be perceptible by the audience. So needs to be present and the contribution needs to be perceptible, but the actual visibility is not a requirement to be considered as a performer. But the difference with the author is where the writer of the piece does not have to be present at each performance of the piece. Well, the stage director does. And because of that, they, well, in a normal working society, they would get paid every day for that being present. So they are not dependent of their protection by means of a copyright or a neighboring right each time the piece gets performed. But when that piece gets recorded and becomes an audiovisual work, then they are no longer present. And they, like the actual author, become dependent of this protection to receive any additional remuneration for additional exploitations. And then, of course, there is the discussion then, is this to be considered as an author or as a performer? And I can say that lots of my members who are collecting Society for Performers have this problem because they come in when the piece is recorded. So they take care of making sure performers get remunerations. But in their law, often the stage director, well, it's a director, so the law points him or her out to be an author of the audiovisual work. So they can be member of the society, but once that the piece is recorded, they have to say, oh, now you have to go to the author society. So that's and that brings me to the point made by Irena. So do we have to give performers copyright, yes or no? And I agree fully with Thilo that if we start doing that, we would create even more problems for the collaboration between Collecting Society for Authors and the Collecting Society for Performers, because producers, they have no problem with it. In many European countries, you will see that the contract that a performer signs with an audiovisual producer does not only provide the transfer of their neighboring rights, but also the transfer of their copyright, author rights, and sometimes even patent. I've seen contracts that demand the transfer of patents. It exists. But so in the contractual world, it's not a problem, but when it comes to representation by collective management organizations, if you would start giving actors copyrights, it would create additional problems. Who gets to represent who? I think the most important thing is that you give performers the same protection. And if you give them the same protection that legislation gives authors, no one cares about the title. It's the protection they care about, not the title.
Victor, in theory, we have hit the lunch hour. Do you want to extend this discussion? There are still some hands out there. Okay, so how much take? 15 minutes? Okay. All right, so let's see, 10, okay. All right, so having said that, you said you saw...
There's a Polish guy beside the lady, the blonde lady.
Oh, Okay, Annie Morin.
Avec votre permission, je vais parler en français. Alors, on a entendu mon collègue Johan qui a mentionné qu'effectivement, s'il y avait un droit d'auteur octroyé aux artistes-interprètes, il y aurait de la confusion entre les... quant à savoir si l'acteur doit aller à une société d'auteurs ou une société d'artistes-interprètes. Mais c'est en prenant en considération que c'est la personne qui est protégée, alors que la protection est soit sur une œuvre ou sur une prestation, du moins c'est le cas au Canada. Et effectivement, dans la loi canadienne, ce qu'on peut voir, c'est que les droits qui sont octroyés aux artistes-interprètes, on parle effectivement d'un droit d'auteur de l'artiste-interprète sur sa prestation, alors que l'auteur a effectivement un droit d'auteur sur son œuvre. Maintenant, peut-être une question pour Madame Irina. Dans la mesure où effectivement un acteur, lorsqu'il fait une prestation, fait soit une prestation dans un spectacle vivant ou une prestation qui éventuellement sera fixée. Quelle est l'importance à ce moment-là? Je comprends parfaitement quand il vient le moment de pouvoir autoriser ou interdire la fixation de sa prestation comme artiste-interprète et comme acteur. Maintenant, lorsque on parle de la possibilité pour un comédien de théâtre d'autoriser ou d'interdire une communication au public, par exemple, ou une exécution en public de sa prestation, quel est l'intérêt d'avoir un droit distinct alors que, dans le fond, il est clair que si un comédien monte sur un théâtre, sur une scène de théâtre, jusqu'à un certain point, il autorise ça. Et à ce moment-là, le droit du travail ou les relations de travail peuvent prendre le relais pour lui assurer une protection.
As I have tried to express, I think it's the principally change of identifying performers as creative and as authors for the interpretation is, for me, as I see it, more important for the recognition of the artistry in the expression. Of course, it is consequences when we move from theater to film, and we know that it's protected 100 years less than the composer of the music in the film. But I think if we believe that respecting the character of the performance or the interpretation, I think this is of importance for the actors, for the performers, because they don't look upon themselves as creative. And I think that is dismissing or disrespecting some of their contribution to the creative society. I think it is important. Like in Canada, I know that you don't have a protecting regime for infringing work for a performer. You only recognize the performer as a copyright holder, but you don't have protection for someone copying the performance. And I think that's natural, because I don't believe that performers need protection for infringement of a performance, because when you perform a work, you have to let it go through your own system. So someone else that someone wants to watch or listen to also have to make this private contribution through their performances. So I don't think they need the protection of infringement of their expression. But I think they need a recognition of being artists and get, of course, the same time of protection as other authors in the society.
There was a hand over there. Right. And please introduce yourself.
Hello, my name is Tomasz Targosz. I'm from Kraków University. So my question would be also regarding this double protection of performances as copyright works and through performance rights. So firstly, is it not a result of the lowering of the criteria of copyright protection? Because probably when the special regime was being established long ago, the general consensus was that typically a performance would not qualify as a copyright work. If I understand Irina correctly, in her opinion, most of performances, according to the criteria we apply today, would qualify as copyright works. And that, in my opinion, would make this double regime rather difficult to justify, because if it were the case that only very few performances, let's say especially creative, would enjoy these both regimes, then it would be justifiable. But if almost any performance is a copyright work, then why should performance be privileged in such a way as to enjoy two regimes of protection? And I would not also agree that these are that the performance rights are personality rights, at least in the way we understand personality rights, let's say in civil continental system. They are very far away from that, and you also have performance moral rights, for example. In Poland we do have them, so that would be difficult to say that this one is personal right and you also have a moral right of a performer. And also if you were to be an author, then you would have moral authors moral rights, so you'd not need any personal rights, I would say, in addition to that. But isn't it simply caused by the fact that this lowering of the criteria has made such discussion possible? Because, in fact, it is very difficult to argue if you look, and I think Irina has given very good examples of what is being protected as copyright works. It is truly difficult to find legitimate reasons, and I fully agree with all the other speakers that it would not be advisable to do so. But if you look at how the CJEU perceives copyright works, it is indeed very difficult to argue why performances cannot enjoy this protection unless you say that it is sort of implicitly excluded by the very fact that there is a special regime in place. However, that is not an obvious conclusion. So that would be my comment. Thank you.
Rudolf, I think, would like the last word.
Just very briefly, I would be again very cautious to think about performances as a way of inferior work. And that's what happens very often, even in the doctrine and in the court's reasoning. But it's not like that. A performance is something distinct from the work, I believe. And we had this problem in 1920s, 1930s. I just wanted to say that performers used to have author's rights in Europe. There was a case law from 1900 onwards in Germany, and the Opernsänger, and then there were other cases which led to an enactment of a law which said that if a musician is performing and recording a musical work, that he is or she is actually adapting the work, and that the musician is holder of the copyright in such adaptation. And that was the law also in Poland, by the way, and in Czechoslovakia since 1996, and in Germany, in Switzerland. And it led to incredible problems we talk about, and that's why it was substituted by the Rome Convention, where the work started even before the World War II. So I would not go back there, because to create the same problems we had here before. But it's, to me, it's really something distinct. It's a difference to interpret music and to write a music, or to deliver a speech and to write, Hamlet. But even though I understand that it's still artistic work.
Can I just interpretation and adaptations, they are protected as copyright in other examples. So why is it less important for a performer when she interprets than someone translating a book to another language?
I think we're not going to not going to resolve this. I understand the rather strong plea of copyright as a dignitary interest, which I think is something important to bear in mind. The next ALAI Congress is going to be about artificial intelligence, and I think the dignitary issues around copyright are kind of a shadow stalking artificial intelligence. In the meantime, I know that this topic has excited great interest, which is wonderful. Mais on doit vous laisser sur votre faim afin d'assouvir une autre faim plus immédiate. And so I think maybe Victor is going to tell us about the lunch arrangements. 3:15? No.
Quarter to 3.
Oh, okay. So 2:45, quarter of 3, and lunch.
Oh, horrible. Oh, I lost my voice.
Okay. Hello, everyone. Firstly, thank you for being here. I know it's been both wonderful, in a sense, and isn't anything related to copyright wonderful, but it's been tiring. So thank you for being here. Firstly, you're very resilient, so give yourselves an applause, really. You know, you should. Well, here goes a mental applause for you. Yeah. So that's the first thing. The second thing is that I'm honored and it's a pleasure to moderate this panel, both because it's dealing with the conclusions to such fundamental themes, but also because of the panel members, which are all magnificent. So I'll just very, very quickly introduce them. So Tachihiro Ueno, who is to my left, just there. Can you say hi to everyone, Tachihiro? Can you say hi to everyone? There you go. He's been an IP professor at Waseda University since 2013. He's a member of the Japanese chapter of ALAI. I think most of you are, aren't you? You should be, if not. And he's also a member of the Computer Society in Japan. So, and he'll be our first, not yet, but he'll be our first panelist. Then we have, and isn't that a magnificent entrance by our wonderful Gillian Davies? She's also... There you go. Now, Gillian Davies is an IP barrister. She's an IP professor with Queen Mary IP Research Institute, and I say that name with pride because that's where I read for my PhD. So, and there she is, wonderful. She's also a member of the English chapter, the British chapter of ALAI, former chairwoman. And she spent years at IFPI representing the record industry around the world and went on to become chairman of a technical board of appeals with the European Patent Office in Munich. Wow. Then to my left too, I have UCA leaders. And, you know, UCA apparently spent many years at law school, more interested in business school than in law, but then we all know that he went on to, and I sought his permission to say this, to become a force of nature in the field of copyright law. He's been the chairman of so many bodies in the EU, WIPO, UNESCO, the Council of Europe, the Nordic Council of Ministers, and dealing with various issues, including copyright. And until October 2014, he was director of the Division for Cultural Policy in Finland. He continues to have a very active role with WIPO, and we'll hear a little bit more about that when he refers to broadcasting issues, which are still on the table. And then to my right, just to the right of Gillian, we have Daniel Gervais. He's an IP law professor with Vanderbilt Law Faculty. He spent many years working at WIPO, many years working at the WPO, and he also practiced, actually, as a partner in a law firm. But what I found was that Daniel there's this mathematician inside Daniel. I didn't know about this, which is so interesting, and which I'm sure connects well with all he does in the copyright field. And then we have Tatiana to the right, still to the right, I haven't finished on my left. Tatiana, she's a private and commercial law professor at the University of Cyprus, which she does love, because she's given so much freedom in terms of research. So her research, and she's done a lot of it, lies essentially in the copyright field. And she's also a member of the Cyprus chapter of ALAI. Wonderful. So, and then to my left, and then I conclude, I have Julian, and he's an attorney whom, and I need to read this properly, he's been ranked in IP and copyright by Chambers and Partners and Best Lawyers. Well done, I know that's not easy. And he's also the chairman of ALAI Columbia, so he's also lectured in various topics in connection to copyright, NFTs, artificial intelligence, and so forth. So, wow, what's a panel? So I'll just now move on to the first panelist, Tachiwiro Ueno, who will deal with and this is the order that we're going to follow, he'll deal with the first topic. So you have the floor, and thank you.
Thank you very much. It's a great pleasure to be here and to be able to talk to you. As you may know, it was originally planned that Mr. Shu Masuyama from Japan is here on the podium. But it's a great pity that Shu Masuyama had to cancel his participation just a few days ago. So I was asked by the organizer to take over his task to conclude the panel 1. So let me try to summarize the presentations and discussions in the panel 1 on the topic performers' right, and try to make some comments. Obviously, the panel 1 was very much successful one with 4 excellent presentations. I'd like to extend my congratulations to all speakers. Let me begin by briefly reviewing each presentation. So, Professor Silke von Lewinsky illustrated the global status of the protection of performers based on national reports, which shows the variety between jurisdictions in terms of the definition of performance, the scope of or nature of the performance rights, and so on. What struck me most was that Silke focused on the statutory remuneration right, and in particular emphasized the significance of so-called residual right. The residual right is a statutory remuneration right to secure that authors and performers receive fair remuneration for the transfer of their exclusive rights to producers, and it is unwaivable remuneration right in addition to the exclusive right for the same use of works and performers. So residual right, remuneration right, enables authors and performers to receive remuneration directly from the licensee after transferring their exclusive right to producers. I'm sorry, I'm missing. Okay. The residual right was modeled after the unwaivable right to equitable remuneration under Article 5 of the Rental and Lending Right Directive. And Silke has already proposed the same idea in the very early stage. Actually, if I understand correctly, quite recently, residual remuneration right has been introduced for authors and performers against some kind of platformers in several national laws in European countries, such as Germany, Spain, Poland, Belgium, and so on. In fact, a statutory unwaivable remuneration right, including residual right, and a series of copyright contract law are found mainly in the EU. So Silke concluded her presentation by saying that such European regime can be modeled for other jurisdictions, which I totally agree with. And Professor Raquel Charbel's presentation relates to the principle of appropriate and proportionate remuneration under Article 18 of the CDSM Directive. As you know, Article 18, paragraph 1 of the CDSM Directive obliges the EU member states to ensure that where authors and performers license or transfer their exclusive rights, they are entitled to receive appropriate and proportionate remuneration. But interestingly enough, not only Silke, but also LACAL, leads to the statutory residual lamination right. It is because that the CDSM directive offers the flexibilities to the EU member states in implementing the directive in terms of contract law as well. LACAL pointed out that the principle of fair and proportionate remuneration may be achieved through the statutory remuneration mechanism by mentioning the amendment proposal by Mr. Axel Voss. In other words, EU member states can implement Article 18 of the CDSM directive by introducing the statutory remuneration right in their national law. At the same time, according to the LACAL, to copy-paste Article 18 is not sufficient. The EU member states needs to go further. I understand that means EU member states should implement Article 18 in more appropriate way. It should be noted here that also LACAL supports the statutory residual remuneration right as unwaivable and collectively managed right. In particular, LACAL pointed out that the residual remuneration right works successfully in complex markets. Additionally, LACAL touched upon the interesting problem of applicable law to the residual remuneration right by considering the nature of the residual right, namely right or contract. She emphasized the importance of this problem because the scope of authors and performers benefiting from this right will vary widely. But in my understanding, the residual remuneration right is not a right based on a contract, but a right granted by law. It is true that the residual remuneration right is granted basically after the transfer of the exclusive right, and at the same time, residual right can achieve the principle of appropriate and proportionate remuneration under Article 18 of the CDSM directive. But the nature of the residual remuneration right should be considered as a statutory right. The Professor Marshall Leifer and Professor Ole Andreas Landstedt talked about the effect of the LAP decision of the CJEU. As you know, the LAP decision rendered on 8 September 2020 held that EU member states may not exclude performers who were nationals of states outside the EEA when transporting the word relevant performers in Article 8, Paragraph 2 of the Rental and Lending Right Directive and designating the performers entitled to a part of the single equitable remuneration. In particular, Professor Landstedt criticized that the court only concludes that the provision must be interpreted in line with the principle of national trust treatment and not the principle of material reciprocity, without proper discussion about the importance of the principle of material reciprocity. And he also pointed out the remaining problem of the retroactive effect of the ruling and the spreading effect for the whole field of copyright and related rights. It's quite interesting. So finally, let me draw my personal view. In my eyes, the point of session 1 is how to ensure an appropriate and equitable remuneration of performers. In other words, how can we guarantee an equitable share of the profit of the producers, profit to performers? There are some measures to do so, including granting rights or contract law, but today's highlight is statutory remuneration right, especially the residual statutory remuneration right. I think that you can call it special right. Actually, statutory remuneration right is not exclusive right. And you may think that an exclusive right is strong because it makes it possible for right owner to negotiate with others. However, in my eyes, well-designed statutory remuneration right, namely unwaivable, inalienable, and collectively managed statutory remuneration right can be helpful and preferable in order to guarantee an adequate share of the profit to authors and performers, rather than an easily transferable exclusive right. Maybe paradoxically, I would say that it is not sufficient to just grant an exclusive right to performers. If we would guarantee an equitable share to performers, because even if you grant a strong exclusive right to performers, it would be meaningless unless you ensure that the performers are not deprived of an equitable share in the name of freedom of contract. Therefore, we need unwaivable statutory remuneration right of performers or a contractor, guaranteeing an applicable and proportionate remuneration of performers. However, in the reality, there is great diversity in the global jurisdictions in terms of statutory remuneration right and contract law. I forgot to skip the slides. So there is great diversity. So the European countries have a lead in this regard. Therefore, if it would be needed to achieve the goal of guaranteeing an equitable share of the profit to performers, some kind of international framework to harmonize the standard would be needed in this regard. I hope that an international association such as RIE or the international organization such as WIPO, not other neighboring organization, would play a role. That's what I'd like to say about the successful panel 1. Once again, I'd like to extend my congratulations to all excellent speakers. Thank you very much.
Sorry, yes. And now our second panelist, Gillian Davies, is going to address the second topic, which is phonogram producer rights. So you have the floor, Gillian. Thank you.
Good afternoon. It's a very great pleasure for me to be here, and I'd very much like to thank Victor Castarosa and Margarida Almeida Rocha, as well as my great friend here, for the invitation to participate in this Congress on neighbouring rights. As many of you know, it's a subject that I've devoted much of my career to, and I'm delighted to have the honour of addressing you all today. I'm going to concentrate on the rights of producers of phonograms, as requested. And so I started by looking at all the responses to the questionnaire. And since I've not been working in this field for a bit, I found it was a rather encouraging overview. It gave me an encouraging overview of the state of related rights in all the countries that were covered in response to the questionnaire. So I felt I had an encouraging overview of the protection that's now provided to by the national laws to phonograms producers these days. And overall, it seems to me that their rights are well protected. They are well-established, long-standing rights, and have sort of stood up pretty well to all the slings and arrows of outrageous fortune in the form of new uses. So, of course, we first of all had piracy, but these days piracy, commercial piracy, seems to be fairly well under control. There didn't seem to be signs in any of the reports that it was a major problem these days. And performance rights in phonograms also seem to be widely respected and exercised well and efficiently by the many collecting organizations representing both producers and performers. And for a long time, it's ever since I was working in IFPI anyway, was one of the aims of both, I think, both sectors, that it was important that we work together, both in defending the rights and in the collecting societies. The main concern which kept coming back in the reports and drew attention to is that of the new act of what I consider to be a form of communication to the public, that's to say streaming, this latest technology which poses a challenge to right owners. In my view, I have to say, and I was asked by the BPI last year for an opinion on this, I consider it streaming just to be a new means of making music available to the public and falling under the well-known definition of communication to the public. But we must remember that the first copyright laws were introduced following the invention of printing, and that ever since technology has required the world of copyright to respond to a long line of new challenges in the form resulting from new technologies. My long career at IFPI and preceded, or rather no, not IFPI, in intellectual property, I wanted to say. My long career in intellectual property. It started at WIPO, which was then BFP, in the late 1960s, and then that was followed by many years at IFPI. And so all those years of really very stimulating, interesting work gave me a great overview of how, since 1970, the law has had to adapt continually to challenges to right owners posed by new technology. It was always sort of catch-up situation, that the law was always behind, certain new uses were not covered, and so we had to go to the government and say, please protect whatever it was, cable distribution or satellite distribution. And particularly in the English-speaking world, where the governments have been always opposed to sort of legislating in general terms. The Latins are better at that. But piracy really hit us all very hard in the beginning of the 1970s. And the record industry was struggling, and the performers were suffering. The first major step against piracy of phonograms was taken by WIPO and 4 major governments. And as a result of sort of talks behind the scenes with WIPO and the governments of France, Germany, the UK, and the United States. So WIPO got everybody together, and so WIPO and these 4 countries rallied behind the right owners, who were all affected. Because it wasn't just the record industry, of course, but performers and authors too, by this rampant and record levels of piracy, records and tapes around the world. The convention was adopted in record time. And I mean, I think it was sort of from planning to adoption, it was about 6 months or something. And then the member states of WIPO quickly ratified. At least a large number of states ratified quickly, and in particular the ones, you know, who were producers, major producers of phonograms and important culturally. And then that was followed by the governments who didn't already have satisfactory legislation hastening to introduce or improve their anti-piracy laws. And so gradually the situation improved. But without that hurriedly put together very general convention, the situation would have been pretty dire. And so then things settled down for a while, but then we had compact disc technology arriving, and all sorts of new uses as well, which I won't go into in too much detail because I haven't got the time. I'm supposed to have 10 minutes, so I better hurry up. Anyway, so in the 1980s, we briefly hoped that CDs were so expensive to manufacture that pirates wouldn't be able to compete. Well, there, of course, we were wrong, because in China and various places like that, they were only too willing and happy to build factories and pirate everybody's CDs. So, and meanwhile, there were other new means of distribution of music and audiovisual works too, for that matter. And these other means included, apart from cassette, tape recordings and so on, but now there was cable TV, satellite distribution, and all of these, and cable came up, well, there wasn't specific protection against cable distribution of music. Ditto with satellite distribution, this was new, wasn't in the laws. And so all these issues had to be addressed one by one as they came up. And so IFBI, for example, also working with the International Federation of Musicians and Actors, and with CSAC and so on, to some extent at least, we had to persuade governments that, you know, they'd got to adapt their copyright laws to all these new means of production and copying. And they did respond well. By this time, they'd realized that this was important from a cultural point of view, as well as a business point of view. So the governments did tighten up their laws, and the interested parties got together also to combat the problem. So piracy had a beneficial effect, that it did lead to much greater cooperation and coordination of efforts of all the right owners, starting with the producers, but also the performers' unions and the authors' society. So relations between those three bodies or representative organizations certainly improved, because we were all in it together. And piracy threatened the livelihoods of all of us. So we had a united front was sort of essential. And WIPO and UNESCO was also in the loop from the beginning. And they stepped up in the context of promoting the Rome Convention and the new Geneva Phonograms Convention. And in due course, the program of harmonization of copyright and related rights pursued by the EU also contributed to widespread reform of copyright and related rights throughout Europe. That, of course, came much later. It was sort of after the dramas of the early days of piracy were over. But so we can say that the last 30 years have seen a huge improvement in the level of protection and for related rights beneficiaries provided by both national and international law. As a result of all these legislative developments, copyright laws in Europe and around the world are in a much better position to adapt to further new challenges posed by new technologies to come. One of these new technologies, streaming, which has been on people's lips here this week, has been much mentioned in the national reports also. And I've had the feeling as perhaps the elephant in the room here in regard to things, something that everybody's a bit worried about. However, it seems to me that as a matter of law and practice, right owners actually do have sufficient means at their disposal to enforce their works against the streaming companies. It's protected by national laws and the conventions as another means of communication to the public. So new legislation is not required, just robust negotiations. And those negotiations also include the right owners getting together and making sure that they work together to get the contractual situation sorted out. So I would suggest that after the 30 years that I've been around of developments in technology, driving challenges to the world of copyright and related rights, the right owners today do have the tools to enforce their rights. And in conclusion, I'd like to say that the copyright interests will continue to face regular challenges. It has to be expected. Technology is not going to disappear. New developments in technology is not going to change. But I'm confident that with goodwill and a recognition that we live in an ever-changing world, the right owners, together with the governments, can and will rise to the occasion. Thank you.
Thank you very much for that, Gillian. And now Yuka, it's Yuka's turn, and he'll be addressing broadcasting like no one else can. It's you, isn't it? Yeah. Yeah, you're the third panelist, and you're going to address broadcasting, the past, present, and future, possible future of broadcasting protection. Thank you very much. Thank you.
Thank you very much, Patricia, for inviting me here to speak about the broadcasting business. Our friend Gustavo Schötz yesterday gave a very accurate and good and competent narrative of the state of the art, the state of the affairs in this area. He asked, in fact, and it was also a heading of his earlier article, is there still a case or cause for a broadcasters treaty? And in a friendly way, he commented this question, referring to the papers that are on the table in WIPO in Geneva. And in most, if not all cases, I agree with him and take the same positions. So that will not bring a good debate between us, but maybe there are others who then have other kinds of ideas. I will try to complement that narrative by additional points, speak a bit about the past, from where we come, where we are now, and where we are going. And that is, I had understood the idea why we are here. Conclude and then conclude with also with future trends. When the work to update the international protection of broadcasting organizations started around the change of the millennium, many of us were thinking then that broadcasting is an industry coming near to its sunset. Many discussions had this kind of tone. The Rome Convention was already obsolete, as Gustavo said. But who cares, because no international rules were going to be soon unnecessary in any case. And in WIPO, the work in the newly established SCCR started by receiving a considerable number, more than 10, 12, or between 12 and 15 proposals from different member states and groups of states, covering quite the whole globe, from all continents, well geographical distribution was there. And during the first years, the proposals were following the model of classical copyright and or related rights treaty as far as notions and structures were concerned. The draft working papers and treaty documents were drawn up, and as we now may call it, on the basis of a kind of maximalist view, containing a long list of exclusive rights or alternatively rights to prohibit. For instance, the working document, which was in fact a draft basic proposal for a diplomatic conference, which is called SCCR 15/2 from 2006, there were the following rights that were intended to be accorded to the broadcasting organizations: broad right of retransmission, right of communication to the public, which is present in the place where the communication takes place, right of fixation, right of reproduction, right of distribution, right of transmission following a fixation, a right of making available of fixed broadcasts, protection of signals prior to broadcasting, and finally, obligations concerning technological measures and RMI. This was 2006. There was even at some instance a conditional decision by the General Assembly of WIPO to convene a diplomatic conference to conclude the treaty after a couple of special sessions of the committee. Soon, in the end of this part of the process, it became evident that the treaty with a broad range of exclusive rights will not be generally acceptable. Brazil and India, especially Brazil, was instrumental in enforcing this position into the process. And so preparation of something completely different started. The first try failed. The narrow model of spring 2007 was considered by many as a bizarre animal, but now later, as we see, it is a completely normal idea of a narrow treaty. It was very similar to where we started recently this work. There was also a break of several years in the whole process. Nobody had an idea what should be done. After that break, the work was resumed around 2011 or 12. Now South Africa and Mexico were the instrumental delegations in this respect. The first part of the work, like scrabbling in a dark forest, and then a path was found, and then the path led to where we are now. The last 10 years of discussions have focused on a treaty with a very narrow scope and defined framework conditions like signal-based, anti-piracy nature, confined to traditional broadcasting. These are elements from the 2006 and 2007 mandates that the General Assembly of WIPO adopted. I am not sure whether that mandate is valid. In any case, over time it has been clear that the threshold to convene a diplomatic conference on the basis of this had been too high. Whether it is still too high, I already am not so certain. We may be able to pass those thresholds. And at the same time, when the switch to this broad classical intellectual property treaty switch happened towards the narrow, very clearly defined, with a very clearly defined scope, something most fundamental happened. The Rome Convention was still obsolete, but broadcasting was suddenly not anymore obsolete by any means. The transition to digital terrestrial broadcasting gave to traditional broadcasting a completely new life, at least one generation or two, as we will see. And the sunset scenario was not anymore valid. In my own country, the plan had been to focus on broadband internet television and invest on it. That would have allowed switching off the terrestrial transmitters. This scenario did not become at all topical. And once this scenario becomes true, there will still need for international protection, maybe even more than we can envisage now. Simultaneously, with the advent of the digital terrestrial broadcasting, the telecommunications industry is continued their efforts to make their networks more and more rapid and stable. This has led to a complementary new communications landscape around broadcasting, which is of course worth of another longer story. The need to update the international protection is thus still there, and now until to an unknown future, which may be even far. The reasons for protection belong of course, the case of signal piracy, but in addition to this, the protection is needed to handle the situation of broadcasters in the jungle of the dense vegetation of the activities surrounding them. Gustavo, in the end of his presentation, described cases in this area, and that demonstrated how inventive those services these days are. Many kinds of services. Many kinds of service providers are exploiting the output and investment of the broadcasters. A new legal framework is necessary to place broadcasting organizations in their role in this telecommunications and media markets landscape on fair terms. This aspect, of course, of the need of protection, in fact, goes beyond the mere anti-piracy doctrine. The broadcasters should be able to do normal business with their output with third parties, including licensing other third parties to use their output. The basic historical rationale of the protection of broadcasting organizations has of course been the investment in the activity. The investment rationale is still valid. It is not connected to the means of transmission of the broadcasting organization. It is connected, as Gustavo has earlier pointed out, on the characteristics of their activity, including the initiative, editorial responsibility, as well as programming and scheduling of the program law. The need for protection has nothing to do with the possible requirements to have an authorization from government authorities, and that is also what Gustavo has said. Nobody knows where the end of traditional broadcasting is. When the end one comes, also the idea of public service disappears. This is a reply to Jan Rosén. Mihai asked, who should be sorry? My reply is that nobody should be sorry. Traditional broadcasting is still everywhere, and there is a lot of it. The whole idea of related rights of broadcasting organizations in relation to their signals as the object of protection has nothing to do with the separate protection of the content that the programs are carrying. Now, in the model that is on the table now, the main right would be a broad right of retransmission. The new treaty would be a new self-standing treaty having no connection or a very, very narrow connection to the Rome Convention. Of course, 96 countries are already contracting states of the Rome Convention, so you cannot avoid a situation where governments are looking at Rome and the new instrument. The model that is on the table is a hybrid that combines the two extremes, that is exclusive rights and other kind of adequate and effective protection. And now I can make direct reference to the European approach. Many rights are already in the acquis in the United States. would like to see a system of protection with practically no exclusive rights, or perhaps at least one exclusive right, broad right of retransmission. For the contracting states of Rome Convention, virtually all elements in this new package that is on table would be plus elements compared to the previous system of protection. These plus elements which are suggested in the chair's paper are a broad retransmission right by any means, including cable and internet, and this, as far as rebroadcasting is concerned, is overlapping with Rome. Protection of catch-up signals, and protection against unauthorized third-party video on demand, protection of pre-broadcast signals, which have turned to be a very good candidate for signal piracy, as for instance the BBC people have demonstrated to us. Provisions on technological protection measures and rights management information. And then something interesting, a broad clause on national treatment allowing the internationalization of the higher levels of protection that many countries may have beyond the suggested instrument. That could be internationalized if these contracting parties want. A response from the broadcasting organization concerning this model have been, as far as I know, have been positive. This model would meet several relevant concerns of the broadcasting organizations. The list covers two cases or refer to situations which can be characterized as post-situation acts. This is painful for some Orthodox delegations who have taken the view that the treaty should solely concern a live signal. Despite of this frustration concerning post-fixation situations, I would still include, if I could, if I might, in the discussions, discussion points, the question whether the protection should cover the act of fixation itself, but no acts after the fixation except those listed earlier, a catch-up signal and third-party video on demand. At the moment of fixation itself, the signal is still alive. It just finishes it's live with fixation. And fixation is the portal to anything that happens after that. That would add considerably to the possibilities of broadcasting organizations to work against piracy, all for the benefit of themselves and for the benefit for content owners, because they are allies, they will be allies also in the future. And now the promised conclusion assessment. Several member states of WIPO have, as their main policy objective, taken the maxim that the treaty must provide a meaningful international added value. Anti-piracy functions are clear still, and the instrument could also secure the place of broadcasters in the more and more complex communications and media markets. This aspect is much, much stronger than 25 years ago. You get it for nothing or gratis for a low level of effort if that aspect follows with the anti-piracy function. The question is now not is there still a cause or case, but will there be a treaty? Of course there will be a new treaty. What we have now going on is an endeavor, is a serious endeavor to draw up and conclude a treaty. 25 years of preliminary work, beginning, middle part, and now the end, soon. The position of the unions of broadcasters is most important in this process. The text that is on the table will be made during this process, which is left, more solid. The concerns of some delegations will be taken into consideration, and the text will evolve. And then, not far in the future, in a foreseeable future, the member states will have come to the final conclusions, and they shall decide on going to a diplomatic conference. A treaty with a narrow scope would fulfill the functions in countries and regions where it is necessary, in Latin America, in Europe, in Africa and Asia, which are kind of mosaics of different countries having a lot of trans-border activities concerning and uses concerning broadcasting. And the treaty would not bring any harm to the others who maybe consider that they don't have need for this kind of protection. So the process has had a beginning, a middle part, and we are now coming to a positive end. Thank you very much.
Thank you very much, Jukka, for that. And now I give the floor to Daniel, who's going to talk about databases and publishers' rights. Thank you, Daniel.
Thank you, Patricia. Let me begin by thanking the organizers. I'm very happy to be here. So let me start by saying that I find the terminology we are using not very helpful in getting to clarity. Let me explain. There's an effort to put all the rights that concern literary and artistic material, but that are not authors' rights, in a single box. Look at the words we have. First, we call them neighboring rights. But if A is B's neighbor, then B is also A's neighbor. So if, say, performers' rights are neighboring on authors' rights, then authors' rights are neighboring on performers' rights. The same applies to the word related. If B is related to A is related to B. Then comes the word special. This word appeared in relation to what we call neighboring or related rights relatively recently in legal literature. The Indian Copyright Act, however, uses it for rights of broadcasters, performers, but also for authors' moral rights. This is not surprising. What is it to be special? What is the valence of this term? In everyday language, special can have either positive or a negative meaning. To say that someone that he's a little special is not always nice. But then, if someone looks you in the eyes, takes your hand, and tells you you're special, that's nice. More seriously, here's my point. I do not think we can put all these rights we are discussing in a single normative box, as it were. And indeed, I would like to congratulate Victor and the organizers right now, because putting all these rights in parallel over these 2 days has produced, I think, much needed clarity on this topic. Performers' rights are, in Europe at least, but not just in Europe, very close in scope to authors' rights. They even include a moral right. Performers also have related rights, at least I believe they do, in the United States. For example, the right against bootlegging, which is part of federal law, but not of the Copyright Act. What do performers gain by being bundled in normatively with database producers? Historically, performers came very close to being considered authors, and I'm talking here not just about the previous panel, but about the decade before the adoption of the Rome Convention. They do, in effect, very often make creative choices in their work. To put it bluntly, I'm not sure the author of a cookbook has a better claim to intellectual property than Yehuda Menuhin. As Thilo said yesterday, somewhere or there, performers can claim the word creator just as much as authors, at least in certain jurisdictions. Therefore, they share some similar normative foundations. As I see it, every category of persons who work in the literary and artistic field but are not authors need not compare themselves to authors. What they need to do is to make the case that they need a form of exclusivity or remuneration to do what they do, or to do it better in a way that produces better outcomes for everyone. Now, when it comes to databases, I wonder what's left to say. As Estelle explained yesterday, there is little, if any, evidence that the right has produced anything more in the EU than in jurisdictions where this right does not exist. As the Commission has said, there's little evidence of either positive or negative impacts. If that's true, perhaps it just remains there and will likely lose its importance over time, like other instruments. Then, as Irini explained, there are many other IP options, which in fact may explain the lack of measurable impacts of the directive. Perhaps let me add a footnote to what Estelle said yesterday. I'm not sure the word database in the directive still has much meaning. When electronic databases started to emerge in the 1990s, data generally had to be indexed and re-indexed regularly to be usable. Technology was called structured query language, or SQL. Facebook, Google, Amazon, to name just those three, found out very early on that relational databases were not a good solution for the volumes of types of data that they were dealing with. A lot of their databases contain raw machine-generated data, such as personal data that is vacuumed from search engines and social media apps. We heard about Article 35. This inadequacy of SQL technology to deal with many big data databases explains the development of open source software for big data, the Hadoop file system, the MapReduce programming language, and associated non-relational or no SQL databases, such as Apache's Cassandra. Whether the investment to clean up and verify the data qualifies for the sui generis right is an open question in my mind, but the question really remains, what good would it do? The case of news publishers is both different and interesting, as Tristan's excellent presentation demonstrated. One of the points he made was especially important. Most people don't write, create, publish, or produce to keep what they do secret. IP organizes the market. IP is a yes, but right more than a right to say no. In other words, you say no to someone because you've said yes to others. No is a way to make yes work. In principle, the fact that news organizations lost most of their advertising markets over the last few years to global tech giants could be seen as simply another case of creative destruction, the forward march of capitalism. Under that system, no one, as a matter of principle at least, has a right to the legal protection of their business model against technological disruption. But what I might call, to simplify, socially responsible or quality news is necessary for a democratic society to function, which means having journalists and professional news organizations that can exist with sufficient means and independently from state institutions. This means preserving or recreating adequate financial flows. There's several ways to do that. The most tempting, as we can see, is to tap into the global platform's income streams. They're seen as the digital beavers that built a dam upstream from news organizations and get to keep all the financial water in their reservoir. This was a Canadian analogy. The fact that there are very few players in the global tech space has competition law implications, and that might be a way to look at it. Providing a right that these tech giants must negotiate to use is another, but it is a solution fraught with controversy. Who gets what? Is there any assurance that the money will go to the production of socially responsible or quality news? And who can be the judge and enforcer of such a commitment, if one were made, without endangering the necessary independence of news organizations? Recall, in addition, that any new right means controversies about its implementation and interpretation, and a significant role for courts to define the scope and extent of the new right. We will have to wait 10 years for the CJAU to tell us what the right entails. Not an easy path forward, but again, in the case of news, we need to find a path. Would it be simpler to tax platforms and subsidize news? Ultimately, this poses the question whether there is a hierarchy between rights, which can be translated into a claim to financial remuneration. The relationship between the press-publisher right, which I will call the PPR, and copyright, it seems to me, is a little bit different than other related rights. Traditionally, the related rights in music are given to entities other than authors for performing functions necessary to disseminate musical works, namely performers, sound recordings, as we know, makers, and broadcasters. But EU law, as I understand it, requires that the monies generated by the PPR should be split with journalists. And those journalists are authors. In Poland, I believe the law says 50%. And of course, decently paid journalists are required for the press to perform the democratic fourth power function that the PPR is meant to protect. Journalists must also be properly resourced, and here the news organization's role is, of course, crucial. There is a key but related question of who qualifies as a journalist and who or what qualifies as a news organization. If extremist, ideologically based organizations get a share of the funds, the new right might actually create more harm than good. Then what about other people, non-journalists, at least non-professional journalists, who contribute to news? They are mentioned in French law. Copyright doesn't typically care about quality, but the PPR may have to. It will only achieve its stated aim if journalism is of what I might call sufficient quality. Something needs to happen to ensure the survival of an independent press and quality journalism. But I'm not sure a related right will do it. I'm a bit of a skeptic, to say the least. If this right is managed by CMOs, can they make rules to ensure that the purpose of maintaining and even adding sources of quality news is achieved? I, for one, will keep a close eye on this field. But I can also see a future in which Google and Facebook or others use AI to generate news content to replace journalistic content and get rid of PPR. As they say in French, attendons la suite. Obrigado.
Thank you so much, Daniel. So I'll give the floor now to Tatiana, and she'll be talking about the fifth topic, which is the protection of sports event organizers. Thank you.
So, good afternoon. It's a great honor and joy to participate at the ALAI 2022 Congress, and I would like to thank the organizers for the warm hospitality, especially Victor, but also Patricia, but also for the excellent organization of this event. In my short intervention, I will focus on the need or not to introduce a new related right for sports events organizers by reacting to what has been said during the panel 5. And I will mainly discuss 3 points which have already been raised by the eloquent speakers of this panel, by Sophie, by Alejo, by Celia, and these are: first of all, the nature of the exclusivity which is enjoyed by sports events organizers today. The second one is the thorny issue of the enforcement in the era of streaming. And the third one, it has not been addressed yet, but this is a panel about also future trends and how we should shape a new right if we decide for a new right. And this will be the introduction of a new related right from the perspective of the public interest. So starting with the exclusivity which is already enjoyed by sports events organizers, according to the dominant doctrine, because we have also some discussion discussion there in the academic field, but also according to case law, sports events organizers do not enjoy copyright protection over the sport event itself. This means that the event is not an original work of mine, and we have seen, this has been referred also by Sophie, that in Europe, at the highest level, this principle has been confirmed by the Court of Justice of the European Union in the Football Premier League case. However, sports events organizers, they enjoy a significant degree of exclusivity regarding the event, regarding the recording of the event, regarding the transmission of the event, and this is on the basis of a variety of multiple legal tools. And here we can refer first of all to the classic solution of the so-called house right, which confers an exclusivity which derives from the dominium over the property or the possession of the premises where the event takes place. We have also the classic protection of related rights. Sports or events organizers may enjoy the protection of classic related rights, such as the broadcaster related right or the film producer related right, and they can even enjoy copyright law, not over the event itself, but over the audiovisual recording of the event. This, of course, presupposes that this recording contains an element of originality, and given the fact that the threshold of originality is rather low, and I'm referring to EU, for instance, the author's own intellectual creation standard is considered to be a low one, and maybe we don't even really know what does it mean. And given also the variety of choices when filming the event, of creative choices when filming the event, we can have a selection from multiple cameras, we can have the addition of special effects, of commentaries, of 3D animation. This recording might lead to an original audiovisual work of mine. Of course, sports events organizers, and this is the hot issue, enjoy also a protection by a related right in some jurisdictions, and this, of course, this is a case of many member states, and we have seen also what is the nature of this related right in the South American context, and here we can see also a difference of philosophy, because most of these kind of special related rights, so sui generis protection, they have an investment basis, but here we can see also another basis which is more based on the image right or the personality, and this is also another element that should take into account. And finally, sports events organizers, they can enjoy the protection of unfair competition law. This constitutes an important and significant legal arsenal that allows to sports events organizers to enjoy a complete ownership and or control over the audiovisual rights over the sports event. However, the efficacy of these tools has been seriously contested in the digital era, in the era of streaming. And indeed, this has been highlighted both by Sophie, but also by Celia. Most of the value of this event lies in the fact that it is live, and most of this value is lost when the event ends. So, the crucial question here is whether the existing legal mechanism, because we have seen that we have legal tools there, can offer an adequate protection for the interests of sports events organizers in the digital era. And this is, of course, a not theoretical question. And in Europe, already in 2018, during the discussions on the directive on copyright on the digital single market, the jury committee, the legal affairs committee of the European Parliament, had advanced a proposal for the introduction of a new article in this directive that would introduce, that would establish a new special exclusive related right for sports events organizers, giving them control over the fixation, over the reproduction, and the making available of the event. This attempt has finally failed. However, the Commission stressed the importance of the issue, and stated that it will address the challenges of sports events organizers in the digital era. Then, in May 2021, the European Parliament issued a resolution regarding these challenges, the challenges of sports events organizers in the digital environment. And this is really a very interesting document. First of all, the resolution notes that the problem with the existing legal tools is that enforcement comes too late, and calls the Commission to clarify or to adjust the legal framework, including the possibility of issuing dynamic injunctions for the real-time blocking or removal of unauthorized sports conduct. Furthermore, the resolution also addressed the important question of the introduction of a new right. And as regards this question, the resolution noted that these rights exist in certain jurisdictions, and of course they are practiced there, but it considers that the introduction in a union level of such a right won't give a solution to the real problem, which is a problem of enforcement of the existing rights. However, the question of the introduction of a new related right should not only be analyzed from the perspective of the interest of sports events organizers, but also from the perspective of the public interest. And here I will mainly refer to the possible impact of the introduction of this right to the freedom of expression and freedom of information. Sports events, thanks to their very significant cultural and social importance, attract a tremendous interest both by the public to enjoy, but also for the media to report on this event. And this significance calls for a need to safeguard a fair and appropriate access to the event, both for the public, but also both for the media. The potential conflict between the freedom of information and between the exclusivity over audiovisual sports rights has been addressed by the Audiovisual Media Services Directive already a long time ago, and this directive introduced two sets of provisions in order to respond to this need. The first one is the provisions regarding the events of major importance to the society. And the second one is the provisions regarding a right to short reporting for events of high importance. Furthermore, fan culture is also a very dynamic element of the sports ecosystem. And often, fans tend to report on sports events through social media. So the question here is whether the existing legal framework has already taken into account this dimension, and to what degree, or shall it take into account this dimension, and how and whether the introduction of a new right would affect this public interest dimension. Apart from the Audiovisual Media Services Directive safeguards, classic copyright exceptions and limitations apply. However, in practice, news reports, but also quotations of sports events are often extremely short. Governing bodies, but also broadcasters, can still place restrictions on how much amount of content can be shared. And indeed, the house right can be enforced through a mechanism of accreditation that enables to put conditions on how the news reporting can take place. The safeguards of the Audiovisual Media Services Directive apply only to the linear context, while the great discretion has been left to the member states for the implementation of this provision has ended up to a complex legal patchwork. Furthermore, and this is a question that have been discussing during the whole Congress, algorithmic platform enforcement may also endanger the fans, the digital media or bloggers' ability to quote, to make a short report or a parody of this event. So the possible introduction of a new right shall also take into account this dimension, and we also need to consider about this. In conclusion, the introduction of a new related right for sports events organizers may a priori offer a more clear, a more transparent, a uniform, a more solid legal basis for the protection of their interests. I was wondering here, and I was thinking of what also Sophie and Celia made reference to, about how to prove the entitlement to take legal action when you are a sport event organizers on the basis of the existing legal framework, and how the introduction of a new right could be an additional element that will enhance this possibility to take a legal action. Furthermore, the introduction of a new right would a priori have a great symbolic value. Why? Because it will be a recognition of the high important investments that are being made for the production of events with high social, cultural, and economic value. At the same time, however, the new right, if introduced, it should be combined with the existing legal framework, and we need to have in mind that this right won't replace what we have now, but it will be an additional element. This could also end up to more complexity. This could destabilize the delicate relationships with other players in the field, such as the broadcasters, and at the end, this might lead to a degree of exclusivity which needs also to be carefully balanced with the interest of the public to have access to the event, to the interest of the media to report on the event. At the same time, the introduction of such a right, I'm not sure that will give a solution to the true problem, which is a problem of enforcement of the existing rights. And the question of enforcement has become also a multidimensional one. A constitutional approach has dynamically emerged in the field of internet and intellectual property law enforcement. There has been a lot of discussion about this. We have seen to what Celia referred about the example of the German law and all these safeguards that lead only to DNS blocking at the moment. This constitutional approach demands and calls for a careful protection of all fundamental rights at stake. So I would like to thank all the speakers of panel 5 for all these very insightful contributions. This is my conclusion. I believe that it's not certain that we need such a new right for sports events organizer, that there is a lot of way to think about it, and also I would like also to discuss all these points with you. Thank you so much for your attention.
Thank you so much, Tatiana. So our final panelist, Julian, will deal with the creative contributions for theatrical performances. So thank you for that, Julian. In Spanish, so if you're not good with Spanish.
Well, actually in both. Thank you, Patricia, and thank you, Victor Housa and the Portugal group for your kind invitation and for the organization of this lovely event. I must also say thanks and congratulations to the panelists of Panel 6 who made an amazing job. It was pretty interesting, although you made my work even more difficult because of that. I've been requested by our dear moderator Patricia to speak in English, but I've also been requested by distinguished Spanish speakers, colleagues, to speak in Spanish, honoring that this is one of the official languages of ALAI. So I just want to please both of them, and I'm going to speak the first part in English and the second one in Spanish. It's up to me giving some impressions about the rights around the theatrical performances and contribute to the discussion that was taking us away from the lunch and that is now taking us away from the coffee break. And the first thing that comes into my mind could be the dichotomy of granting copyright to directors of cinematographic works versus the discussion around what is the proper right to directors of theatrical works. Because if we assume directors of a fixed audiovisual work should have copyright protection, whether exclusive or remuneration rights, why not considering the same with respect to directors of theatrical works? Is it just because of the fixation requirement which is reserved to each country by the Article 2.2 of Berne Convention? So what if the theatrical performance is recorded just for fixation purposes? Or if the director indeed has a prompt book, which is not the case for all the theatrical performances? Is it protecting then? and what exactly, how it is protected. Because the reality of a theatrical performance that is meant to be in a live stage, and that it could also be a work that is being adapted through the time depending on so many external facts, such as the kind of public or the place where it's presented. So when even theatrical works can be recorded or can have a prompt book as evidence of the directive's work, the nature and the purpose of this kind of work is not its fixation. Then we could also ask, are we measuring the merit of the theatrical creation by not recognizing appropriate protection to directors of theatrical performances? Because assuming, and this is not the case for all the countries, the directors of audiovisual fixed works are granted copyright protection, then what would be the difference between this kind of author and the director of a theatrical performance if both express their personality by controlling how the script is expressed through the actors and through the artists, and how the lights, music, and costumes fit perfectly to create the right feeling, to communicate the vision of the director that is being received by the public. And this dichotomy is brighter if we think in pandemic and how the theatrical performances survive the restriction of agglomerations. There were several theatrical performances that were broadcasted or streamed, so just a temporal fixation of the theatrical work to make it available to the public changes the whole perception about the rights that should be granted to the directors of theatrical performances? And why? Because it is basically the same work that is just using another media to be communicated. However, through this that to gain some rights, there should also be some lobby and some power of negotiation. And the reality of most of theatrical performances is not the reality of the worldwide known theatrical performances, but more a precarious situation for more of the directors and actors. And there is where is the problem. Because even when the new technologies, the social media, and the globalization has helped a lot to have more visibility, it is probably still seen as a weak part of the creative industry. Now, I'm turning to Spanish, but I don't promise to turn more optimistic. Volviendo al español, y para finalizar mis pensamientos sobre los directores, al pensar en una protección de sus derechos como derecho conexo de intérprete, me resulta difícil entender dicha posición basada en el argumento de que contribuyen a la interpretación y por lo tanto tienen un cierto carácter de intérprete. Que si bien como abogados sabemos que generalizar no es tan buena idea, hacer analogías sí es algo que se nos da muy bien. Y pensando nuevamente en hacer la analogía con un director de obras cinematográficas, vemos que el aporte de un director de escena puede trascender las fronteras de una mera contribución a la obra y puede llegar al campo de la originalidad. Pues a través de su dirección, el director de escena tiene la facultad de decidir qué sentimiento quiere imprimirle a la obra, cómo y en qué momento. Es el director el que tiene una visión general de qué quiere transmitir. Y se apoya en los actores, músicos, luces, vestuarios y demás elementos para lograr expresar esa idea que el director tiene en su mente y que se traslada a las tablas. Ahora bien, respecto a los actores, podemos estar en terrenos ciertamente puntiagudos, pues nadie niega que los actores realicen una contribución importante a la obra y al desenvolvimiento de la misma. Lo que entra en discusión es si dicha contribución es suficientemente creativa y original para considerarla una obra. Un aporte que merece protección de derecho de autor más allá del derecho conexo. Es decir, si en este proceso de creación intelectual en realidad hay free creative choices, como lo vimos en el panel 6. Y la respuesta no es ni blanco ni negro. Pues si bien en un principio un actor, por más que haya pensado y escogido cómo interpretar su personaje, esto no necesariamente implicaría un aporte creativo con originalidad, pues posiblemente estará bajo la dirección del director y habrá pasado por unos filtros para ser el actor escogido para interpretar esta obra específica. Pasa entonces que el aporte del actor llega a ser una tuerca dentro de un engranaje complejo que posiblemente solo entiende el director, quien va a guiar la interpretación de una forma u otra para lograr el objetivo y comunicar la intención del director de escena. Cierto es también que como ese tema no es blanco y negro, no podemos negar la posibilidad que en ciertos casos un intérprete a su vez asuma la calidad de autor, pero no por la mera interpretación, sino porque en el desarrollo de su trabajo haya realizado labores creativas adicionales dotadas de originalidad y haya contribuido a la creación del personaje, formando de este el personaje una obra en sí misma dentro de una obra más compleja que sería la obra teatral. Estaríamos entonces en una situación compleja a nivel probatorio, pues entramos en discusiones de quién tiene los derechos sobre qué. Y si se reconocen derechos de autor sobre el aporte creativo del actor, ¿esto impediría de alguna forma la normal explotación de la obra teatral? ¿Será que reconocer una protección de derecho de autor a los actores y no mantenerla como una protección de derecho conexo con los beneficios que eso supone llevaría al efecto contrario deseado? Es decir, más allá del título de derecho de autor o de derecho conexo que le demos, ¿es conveniente otorgar un derecho de exclusiva o es más benéfico pensar en un derecho de remuneración equitativa? Y es que por más romántica que parezca la solución de otorgar un derecho de autorización exclusiva, el efecto podría ser contrario si esto genera la implementación de cláusulas generales de cesión de derechos o la aplicación de presunciones de obra por encargo, pues no es útil que el actor tenga un derecho de autor que va a ceder debido a que no tiene una posición contractual dominante. Y quizá la vía del derecho de remuneración equitativa, cuya cesión esté prohibida, es una solución que puede satisfacer mejor sus intereses. Ahora bien, hablando de stage lighting designers y de sound designers, creo que Rudolf hizo una brillante exposición con la que no puedo estar más de acuerdo. El punto radica no en la labor en sí misma, sino en si dentro de dicha labor existe un aporte creativo con originalidad y si quien la ejecuta es quien diseñó dicha labor escénica creativa de luces o de sonido, o si simplemente fue un mero instrumento. Si partimos de la premisa del artículo 2.1 del Convenio de Berna, bajo el cual entendemos que una obra es toda producción en el campo literario, científico y artístico, cualquiera que sea el modo o forma de expresión, el stage lighting y el sound design podrían llegar a ser considerados obras. Por supuesto, esto es algo que podemos ver con mayor claridad hoy en día, en donde vemos los efectos de luces y sonidos han alcanzado cierto nivel de complejidad tal que no es difícil ver la creatividad en los mismos. En cuanto al diseño de sonido, creo que la discusión sería aún menor, pues la justificación de su protección como una obra musical y como un fonograma no resulta descabellada, pues pensar algo distinto entraría posiblemente en el terreno de clasificación del mérito de la obra. No obstante, en cuanto a la iluminación escénica, el panorama no es tan iluminado, pues podría ser complejo otorgar derechos de forma general a la iluminación escénica, cuando ésta no siempre va a tener originalidad. Pero al mismo tiempo, ¿quién evalúa esa originalidad? ¿Quién evalúa qué es original y qué no lo es? Y esto nos podría llevar de nuevo al riesgo de estar evaluando el mérito de una obra. ¿Y quién lo haría? ¿Quién diría que la iluminación de este auditorio en el que estamos es una obra en sí misma? Pero al mismo tiempo, ¿quién se atrevería a decir con plena certeza que no lo es si estuviéramos en un escenario en donde se reconociera pacíficamente su protección como obra? En este caso, un derecho conexo podría ser una solución más práctica, aunque si nos vamos al ejemplo de los artificial landscapes que nos mostraba Rudolf, en realidad podríamos considerar que un artificial landscape no es una obra, o sí podríamos considerar que sí tiene creatividad. Estas eran solamente algunas de las impresiones y de las dudas que les quería dejar. Para el futuro tenemos mucho que trabajar en temas de derechos teatrales. Es algo que no se ve, no se evalúa, no se piensa en muchos países y que pasa en el olvido, pero que son ciertamente actores muy importantes de las industrias creativas. Muchas gracias.
Thank you very much, Julian, for that. And thank you to all the panelists for your brilliant, sorry, I don't need this anymore, for your brilliant talks. And I was supposed now, we had agreed to let our panelists give you a final takeaway, you know, their final thoughts on their own topic, or perhaps the topics of their neighbors, using those terminology. But there's no time. We've been talking a lot about energy and how there's a lot of scarcity in connection to energy, but there's been scarcity in connection to time in conferences for a long time, so it's an issue. So without further ado, I will ask our audience whether they have any questions, and in that context, could you perhaps tell us your name, if you're comfortable with that, your affiliation, and then we'll let the panelists decide who will deal with the question in particular. Any questions?
Thank you very much. Congratulations for all the excellent presentations. I have a very short question.
Name, sorry, I know
My
your name.
name is Alexander Dias Pereira, University of Coimbra, Portugal. The question is, if we raise the levels of protections for any interest group so high, and then if states and governments don't have the means to guarantee adequate protection of such rights, who in the end will pay? The taxpayer? Because then if the state puts in the statutory legislation that people, groups have certain exclusive rights, but then it has no means to give enforcement either by administrative or court means, judicial means, will not these groups have a claim against the state because their rights are not being adequately protected? And in this case, will not the state, the government, have to ask taxpayers to give some compensation to rights holders? It's just a question.
Thank you for that, Alexandre. There was no reference to a particular set of rights. It was about elevating the level of protection generally. So would any of the panelists be particularly interested in addressing such question? It's, well, someone said that yesterday, then you can say anything, it doesn't really matter. You could just say anything. I thought that was great. So, anyone? Are you happy?
This is a very interesting question, and of course this touches on what we have been discussing all of these days. And as a general comment, I would like to say that the whole conference is a more existential one that we should have already thought before, because it's in fact a conference and the topic about the history, the origins, the purpose, the boundaries of copyright law and more broadly of intellectual property law. So, of course, adding all the time new kinds of protections or leveraging, elevating the existing protection, this has been the way we have been doing traditionally until now in many domains. At the same time, this does not necessarily mean, and I have experience of the topic that I have talked about, that we will have a better enjoyment of these rights and a better protection of these rights. So there is a trend, especially with the disruptions which have been brought by internet, to the field of enforcement. So another question is the existence of the rights, how much right we have, and a different question is the question of enforcement. And regarding specifically the question of enforcement, this also is very relevant not only for the rights of sports events organizers, but in general. I would also like to highlight a very interesting study of the EU IPO regarding the dynamic blocking injunctions and the need to start to consider more globally about this issue. And for instance, in Europe, this kind of legal tools, kind of legal measures have been permitted in some jurisdictions on the basis of an expansive interpretation of pre-existing norms. So there is not a concept in European copyright law of dynamic injunctions. And it's not only about the concept, it's also about the safeguards regarding how we apply these measures. So I think that it's time to think differently. It's time to think in a more balanced way. And it's time to think in a way that the solution to all the problem is not adding new complex rights. We have seen also the example of the database right. I remember that Estelle answered, but also Daniel made this reference. It's not sure that this right has really made the database producers to create more or to invest more. So what is the practical effect of this right? So maybe we need to think differently. And of course, if a new right will be created, this should be justified on the basis of many aspects. And this is something that needs a very careful consideration.
So well done, Tatiana, thank you for that. I think we have time for one more question. There you go.
Hi, thank you very much, Dean Marks. I just wanted to follow up on this discussion because I think the discussion of rights is one thing, but really enforcement is what can make the rights meaningful. And in terms of Tatiana's discussion of dynamic site blocking injunctions, I'd like to refer people to a report by the Jury Committee of the European Parliament on cross-border enforcement of intellectual property rights in the EU, where they were talking, for example, site blocking injunctions, even if they're dynamic injunctions, they're just member state by member state. But a pirate website or pirate streaming service operates cross-border. So you have instances where there have been something like 12 individual site blocking actions across various EU member states against one single pirate website. Should we start thinking about, particularly in the European Union where there's some commonality and acquis European, about is there a way to do more enforcement that doesn't involve having to go against the same website, territory by territory by territory, and member state by member state? I know that comes into great conflict with the notion of the territoriality of copyright law. On the other hand, when you're talking about websites that are engaged in really blatant copyright infringement, where there really wouldn't seem that there's much variation across countries that are members of the Berne Convention, shouldn't we be looking at more pragmatic solutions? I'm wondering what the panelists think. Thank you.
Thank you for that, Dean. Any thoughts on that? Should we go less territorial, more territorial? We seem to be going more territorial rather than less territorial. Does anyone want to say anything about the topic? No? Okay.
No, but the right I discussed had really nothing to do with it.
No, it's not. It's not. It's just general.
Well, I think you make a very good point. But I mean, I don't think we're in any position to see how we can solve such a problem at our level. You know, it's a matter for governments, isn't it? We need an international court, perhaps, to deal with things like that, or or an EU specialised copyright court, perhaps, to deal with issues where the same case should be brought in many countries, and so they could do it, as it were, at an international level or at a European level at least.
Thank you very much, Julian. Now, there's one last question. We have 1 minute for the question and the answer, so it's you, isn't it? You said you wanted to, yeah. So could we be really fast and do it in 1 minute? I know it's difficult. I'm asking for a lot, but the thing is, otherwise I'm afraid I'll
Sure.
only see you at 8 p.m.
Thank you very much for all your presentations, your remarks. Giuseppe Mazziotti, Trinity College Dublin. I started my career as a copyright expert because I was a clarinetist. I worked in film music, symphonic repertoire. There is one aspect, in my view, has been overlooked throughout the conference, the element of evidence, and how through these rights, newly codified or newly identified, the artists very often are lonely. They don't have access to justice. I see with great interest the fact that platforms, especially in Europe, are increasingly asked to incorporate some form of justice or courts, Facebook, but very soon even the largest platforms. How do you think this element can be better explored? Because believe me, with the exception of those countries where we have these wonderful organizations that protect the interests of artists, the vast majority of jurisdictions sees artists as lonely and unprotected people for whom these discussions remain purely theoretical. Believe me, because I know them, and it would be very useful to talk not only to their organizations, but to the people individually taken. Thank you.
Thank you so much for that. And I think because of timekeeping, I think I shall just invoke a famous Portuguese poet, one of the famous Portuguese poets. His name was Fernando Pessoa, who said that when one finds that a reality, a path has become inept, it doesn't work anymore, then we need readjusting, we need adapting. And so this is what he said, Fernando Pessoa. So I just quote him to finish off, and thank you for your comment. And I would then say that the only thing to keep in mind is that to not forget the essence of copyright. I suppose that would be my final remark. Thank you so much. Thank you to the panelists. Some of them traveled from far away, even the ones that didn't. I mean, thank you so much for your brilliant contributions. And let's give a round of applause to... we're a bit late, as you may have noticed. There's an element of tardiness here. Oh.
May I think we have a short coffee break now. Afterwards will come a very interesting roundtable on collective management in Portugal. But my task is, as president of ALAI, to draw your attention that there is a last point which is important for us as an organization. And that is, after the interesting roundtable we will have, we need to have, and we really legally need to have, a General Assembly. Otherwise, we cannot survive. If you want to have other conferences on copyright organized by ALAI, we must have our General Assembly approving, for instance, our accounts. So please, those of you who are members of ALAI, after the coming roundtable, stay a little bit here and wait until to change, to make yourself beautiful for the closing gallery, to approve such things like accounts and some other points of our agenda, as you will hear. Thank you very much. T.
Olá, olá. Olá.
Teste.
Olá. Olá. Olá.
Foi o que eu disse. Não, temos público, então não. Quando a música parar. Okay, so hello, good afternoon, welcome. First of all, I want to thank to Alaï for the invitation to be here to moderate this roundtable. Not so round, but we will speak in Portuguese because the theme is about the future of entidades de gestão coletiva em Portugal. So we'll speak in Portuguese. You may leave the room just for pick your phones. Para encerrar então esta conferência, vamos continuar a falar do futuro, que a par enfim, da nossa reflexão sobre o passado, parece-me a melhor perspectiva para enfrentarmos os desafios. Vamos falar do futuro da gestão coletiva de direito de autor e dos direitos conexos, numa altura em que aguardamos que, sem mais atrasos, mas com discussão pública, que se proceda à transposição da Diretiva de Direitos de Autor, a Diretiva 2019-790, chamo-lhe a Diretiva MUD, que seja transposta para a ordem jurídica portuguesa. Estão connosco nesta mesa redonda representantes de entidades de gestão coletiva, na realidade os nossos sponsors, que estão aqui identificados atrás, António Paulo Santos, da GEDIP, Associação para a Gestão de Direitos de Autor, Produtores e Editores, da parte da Visapress, não está aqui o Carlos Eugénio, Carlos Eugénio, da Visapress, Gestão de Conteúdos de Média, Miguel Carretas, da Audiogesto, uma associação para a gestão e distribuição de direitos, Pedro Oliveira, da GDA, as entidades de gestão dos direitos dos artistas, e Ana Ramalho, da Google, uma empresa de tecnologia internacional que, até pelo pouco tempo que temos, dispensa apresentações com certeza. Esta diretiva 2019-790, traz grandes desafios às entidades de gestão coletiva, acho que é reconhecido por todos, de uma forma que não me lembro que outra, na minha perspectiva, que outra tenha trazido, dada a relevância do mercado único digital e a relevância, enfim, que os direitos de autor e os direitos conexos têm no mercado único digital. Aliás, os considerandos da diretiva, nos considerandos da diretiva é referida precisamente a importância de prever um sistema de gestão coletiva rigoroso e eficaz, e é assinalável o número dos 86 considerandos que esta diretiva tem, o número de considerandos que são dedicados à gestão dos direitos de autor e conexos neste mercado e dos desafios que lhe são colocados. E vamos passar sem demora para o que interessa, que é ouvir os nossos participantes desta mesa. E eu perguntava, enfim, o que é que vai ou tem mesmo de mudar? Quais são as vossas principais preocupações e os desafios que pensam que vamos enfrentar? Miguel?
Começa por mim. Olá, muito boa tarde. Antes de mais, é um prazer e um gosto estar aqui. Gostava de agradecer à organização este fantástico congresso que tivemos. Enfim, talvez este tema pareça um pouco paroquial a alguns dos participantes, um pouco local, para facilitar a tradução, mas, de facto, eu acho que nós podemos, enfim, transpor algo daquilo que é a experiência portuguesa, porque ela, de facto, não é assim, afinal de contas, tão diferente do que outros países. Bom, como o Sr. Desembargador acabou de assinalar, nós não temos a diretiva transposta, mas, em termos gerais, a visão que temos, que tem a Audiogesto da gestão coletiva, é que vê a gestão coletiva como um meio, um instrumento que tem de estar sempre ao serviço dos próprios titulares. O grande desafio, se quiserem, é este, e são as grandes questões que se colocam. Ao passo que, no mundo offline, as categorias de direitos são relativamente estanques e sempre foi muito claro qual é que deveria ser o campo da gestão coletiva, têm-se levantado algumas questões no mundo online. Mas, na minha forma e na minha visão de ver as coisas, eu continuo a acreditar que a separação aquela velha separação entre aquilo que chamávamos de utilizações primárias e utilizações secundárias continua a fazer sentido. O que eram as utilizações primárias no mundo offline? As utilizações primárias era, no caso da música, enfim, aquilo que me dedico mais, era obviamente a venda de música, a venda de gravações musicais. Essa venda começou por ser feita em cassetes e vinis, depois passou a ser feita por CDs. A partir de determinada altura começou a ser feita através de downloads, mas a grande mudança de paradigma nem está no download. A grande mudança de paradigma está quando passamos para um momento em que as pessoas deixam verdadeiramente de adquirir um produto e passam a adquirir um direito de acesso globalizado a tudo e mais alguma coisa, toda e mais alguma música. Não é? E, portanto, neste momento, e esta é que é uma ideia muito importante a reter, o streaming não é um substituto da venda de música. O streaming é a venda de música. A música, hoje, fundamentalmente, aliás, não há nenhum mercado da Europa e do mundo onde esse fenómeno não ocorra, o acesso a uma plataforma digital é a forma típica de consumo de música. E, portanto, de uma forma geral, o streaming on demand é uma utilização, a nosso ver, primária. E desse ponto de vista, o papel da gestão coletiva deve ser o mesmo que há nas outras utilizações primárias. Ou seja, faz-nos pouco sentido que as utilizações on demand, aquilo que é a venda, aquilo que é o mercado, seja gerido coletivamente. Eu não estou a dizer que não pode. Não estou com isto a dizer que não pode. O que eu estou a dizer é que só faz sentido fazer intervir mecanismos de gestão coletiva quando eles contribuem para uma maior eficiência de mercado efetivo. Uma maior eficiência de mercado ocorre, por exemplo, isto é muito claro, quando estamos a tratar da cobrança de direitos em termos genéricos a rádios ou televisões, ou este espaço, ainda agora brincávamos aqui um bocadinho sobre a música que estávamos a ouvir, estava autorizada, estava licenciada, e está, por acaso há ali uma licença de artistas e produtores que permite que este espaço passe essa música. Ora, é evidente que é absolutamente impossível a cada um dos artistas, a cada um dos produtores, licenciar cada um dos espaços e cada um dos espaços ir pedir uma licença a cada um dos produtores e artistas da música que passa. Portanto, isto é uma forma eficiente e ainda está assim ao serviço dos titulares de direitos. E, portanto, se os titulares de direitos quiserem optar por uma gestão coletiva noutras áreas, também fará sentido. Agora, se nós olharmos para o direito europeu, não há nenhum mecanismo imposto por nenhuma diretiva, nem esta, de gestão coletiva obrigatória para as chamadas utilizações primárias, elas no direito europeu existem exclusivamente em relação à retransmissão por cabo e satélite, e são as únicas onde elas são verdadeiramente impostas, porque não há outra solução de gestão. Em todas as outras, elas são atos voluntários. Até porque a gestão coletiva, quando de facto funciona, é natural que os titulares se organizem e que a escolham. E a grande questão é esta, se quiserem dito de outro modo. Quando nós, e colocando aqui a questão com toda a abertura, porque ela foi colocada em vários painéis durante este Congresso, quando defendemos mecanismos de gestão que não partam de um ato voluntário, há algo que nós temos de ter sempre presente. Vamos estar sempre, mas em qualquer circunstância, a cobrar por todos e a distribuir só por alguns. Isto é fatal. Qualquer mecanismo de alargamento ou de presunção de mandato leva a isto. E, portanto, aquilo que eu entendo em termos gerais, eu não quero discutir cada uma das questões da diretiva, não é isso, também é uma questão muito mais de princípios. Aquilo que entendo em termos gerais é que esses mecanismos devem ser reservados para situações onde, do ponto de vista económico, não haja outras soluções viáveis. E, como limitação de direitos individuais que é, agora do ponto de vista jurídico, já que estamos num congresso que aborda temas jurídicos, qualquer limitação da liberdade individual do titular, e temos que ter isto em consideração, deve estar sujeita aos princípios de necessidade, adequação e proporcionalidade que estão previstas nos textos europeus, mas também, na esmagadora maioria, se não todas, as constituições dos Estados-membros da União Europeia. E, portanto, esses critérios, é necessário ou não é necessário? Não digo para a voluntária, digo para ter qualquer imposição ou limitação de vontade dos titulares. É adequado ou não é adequado? E a ser necessário e adequado, é um meio proporcionado ou não? Ou seja, essa limitação da vontade, porque qualquer gestão coletiva imposta por força de lei constitui sempre uma expropriação, queremos ou não, da capacidade de exercício do titular, ela tem que passar sempre este teste. E aí vem, e eu não vou entrar por aí, e com isto termino, um conjunto, obviamente, nomeadamente quando verificamos a adequação, um conjunto de elementos económicos que têm que ser tidos em conta, saber se temos um mercado que funciona, que não funciona, se faz sentido ou não faz sentido, para que mercados e para que tipo de obras. Portanto, em termos gerais, e sem querer aqui particularizar, sem querer aqui discutir se faz mais ou menos sentido num caso ou noutro, esta é a visão que têm, tipicamente, no mundo inteiro e em Portugal, os produtores musicais sobre a gestão coletiva.
Carlos, da parte da Visapress e da gestão dos conteúdos de média, qual é a perspectiva sobre o futuro da gestão coletiva em Portugal?
Bom, muito boa tarde a todos. A perspectiva que nos assiste relativamente à questão da gestão coletiva em Portugal para a imprensa acaba por ir de encontro um pouco, em termos gerais, àquilo que o Miguel acabou de dizer. Estamos mais ou menos de acordo com tudo aquilo que o Miguel acabou de dizer, mas eu gostaria de falar um pouco da necessidade da criação deste direito conexo. Acho que faz mais sentido explicar aqui um pouco a história do porquê da criação deste direito conexo para os editores de imprensa, que é algo que, olhando para o texto da diretiva, parece que, de alguma forma, foi ali um bocadinho encaixado em algo que se estava a tratar de direitos de autor no digital, mas não da imprensa. E a criação deste direito conexo vem na senda daquilo que aconteceu, principalmente, salvo erro, na Alemanha, que os editores de imprensa ficaram privados de aceder aos direitos da cópia privada por não serem reais titulares de direito de autor. Em Portugal, essa questão para nós está resolvida. O nosso Código de Direito de Autor é, a meu ver, perentório no que diz respeito ao direito de obra coletiva para o editor de imprensa e, a partir daí, no nosso caso, aquilo que nós acreditamos é que estamos protegidos QB. Todavia, este novo direito, este direito conexo, aquilo que nos vem fazer é alertar para uma realidade e levantar aqui algumas bandeiras vermelhas relativamente àquilo que tem sido o comportamento de plataformas internacionais e daquilo que é o ecossistema da internet no que diz respeito à utilização dos conteúdos de imprensa. Todos nós sempre nos habituámos, a partir do momento em que a internet nos entrou na nossa vida, a consumir conteúdos de forma gratuita. Da imprensa ainda é mais gritante. Questões tecnológicas fazem com que seja muito mais simples esse tipo de acesso a essa informação. O aparecimento dos telemóveis e dos tablets, então, simplificou ainda mais, o que levou a perdas muito significativas, quer no modelo de negócio existente, que era assente na publicidade, e a imprensa está a tentar reinventar-se para que consiga, de alguma maneira, conseguir manter os níveis económicos que permitam a que exista uma imprensa sustentável. Esta diretiva, a ser transposta o mais fiel possível àquilo que é a gênese da mesma, que é aquilo que nós acreditamos que irá acontecer, vai fazer e vai permitir que, de alguma forma, fique bem vincado a necessidade que há das plataformas contribuírem, plataformas e não só, mas das plataformas contribuírem na quota parte da utilização que fazem dos conteúdos de imprensa e que até à data, pouco ou nada, contribuíram empobrecendo ou contribuindo para o empobrecimento da imprensa em Portugal. Portanto, relativamente à questão da transposição, aquilo que nós acreditamos que faz sentido é robustecer o direito que nós temos, principalmente em ambiente digital, clarificar aquilo que são as utilizações e que devem ser remuneradas por tal, e por isso mesmo achamos que a forma correta de transpor é da maneira mais colada possível àquilo que é a diretiva, como amplamente também aqui foi indicado relativamente ao artigo 17 durante esta conferência por eminentes professores de Direito.
Pedro, eu não lhe vou... A GDA, Gestão de Direitos dos Artistas, eu não lhe vou perguntar acerca das posições acerca da transposição da diretiva e acerca da proposta, da única proposta que conhecemos, pelo menos que eu conheço, mas em relação da parte, enfim, da gestão dos direitos dos artistas, e qual é a sua visão sobre, enfim, o futuro da gestão coletiva desses direitos em Portugal na sequência desta diretiva?
Muito bem. Em primeiro lugar, agradecer às pessoas presentes e muito especialmente à lei, no nome da Margarida Almeida Rocha e ao Vítor, queridos amigos, e é um prazer estar aqui com vocês. Nós não queríamos centrar muito este debate na questão da diretiva, porque achamos que seria um debate tão rico que mereceria muito mais tempo e dedicação. Por isso prendi muito só com esta ideia mais geral do que é que realmente é a importância e o que é que há de ser o futuro da gestão coletiva. E é mais isso que eu vou fazer. São breves notas, por isso não tenham medo que eu não vos vou pegar uma grande seca. Vai ser rápido. Nós também é engraçado que partilhamos um pouco esta ideia que até o Miguel aflorou, não exatamente com os mesmos contornos, mas de que realmente, para nós, desde o início, a gestão coletiva não é um fim em si próprio, não é um objetivo. A gestão coletiva é uma ferramenta, porque nós sabemos que existem determinado tipo de direitos que, pela sua natureza, e já aí depois podemos ver, que obviamente só podem ser geridos coletivamente. E isso parece-nos que é evidente, já se falou aqui na Cabo, de forma material, a comunicação pública em geral, eventualmente a questão digital, mas realmente essa sempre foi, né? Essa é a nossa ideia, e não somos os militantes da gestão coletiva como um princípio e um fim a atingir-se. O que acontece é realmente na gestão individual e como relativamente àquele que eventualmente me possa contratar. Por isso, quando nós falamos, para nós, no futuro da gestão coletiva, o que realmente importa é manter esta ideia do rigor. E é isso que nós temos vindo a trabalhar ao longo dos anos, de aperfeiçoar o nosso trabalho no que diz respeito ao rigor dessa gestão desses direitos. E isso é que é o nosso grande objetivo. E então, sim, é o empenho total no que diz respeito à cobrança, seja feita por nós individualmente quando a lei nos permite, seja conjuntamente com outros titulares de direitos, como nós fazemos, e ao mesmo tempo, que é algo que nós não falamos muitas das vezes, mas me parece que é central, que é o rigor na distribuição dos direitos, que é sempre, aliás, um lado que é muito criticado pelo público em geral, pelos próprios titulares de direitos, e que temos que estar muito focados nessa questão que para nós é determinante. E por isso eu posso-vos dizer que ao longo destes últimos anos o grande investimento que a GDA tem feito, sem dúvida, tem sido na distribuição e no aperfeiçoamento dessa distribuição. Tanto do ponto de vista tecnológico como no número de pessoas que temos a trabalhar, sabendo nós que é determinante para criar confiança nos próprios titulares de direitos e sabendo que lá está que é um ponto fraco na gestão coletiva que ao longo dos anos tem sofrido muitas críticas sobre isso. Por isso posso-vos dizer, e com um imenso orgulho que eu digo isto, é que eu sinto que nós estamos na vanguarda das sociedades de artistas do mundo, onde realmente essa preocupação existe, onde esse investimento tem sido fortíssimo e eu acho que tenho aqui amigos e colegas que estão aqui ao meu lado que reconhecem que realmente temos feito um trabalho grande nessa área. Por outro lado, também vou tocar num ponto que também geralmente é esquecido, mas que eu acho que cada vez tem tido mais importância, que tem a ver com a questão dos fundos culturais e sociais. Por isso, ou seja, já não estamos a falar na gestão clássica dos direitos de cobrar e distribuir, mas numa nova realidade que está a ter um peso tremendo, ainda por cima, passado estes tempos terríveis da pandemia, e também com algum desgaste da própria indústria, onde já houve mais dinheiro, onde as coisas não eram tão simples, ou eram mais simples e mais objetivas, e que realmente temos vindo a sentir ao longo destes anos a importância que realmente a gestão destes fundos tem tido, no nosso caso, para a classe artística. A GDA, por opção, criou uma fundação só para se dedicar única e exclusivamente a essa gestão. E, no fundo, a missão dessa fundação é valorizar e dignificar o trabalho e as carreiras dos artistas que representamos, mas também na sua dimensão humana, cultural e do desenvolvimento social que isto implica. Esta missão, no fundo, assenta num determinado número de programas que nós temos implementado ao longo dos anos e que estão muito focados, lá está, nessa ação cultural, na ação social, institucional e na própria formação profissional, que é uma coisa que nós percebemos que está a ser determinante, ligada até também com a questão da internacionalização, que é algo que preocupa muito os artistas portugueses, sendo nós um país pequeno e com dificuldade de penetração noutros mercados. E temos de tentar trabalhar muito nisso e com resultados, e até alguns destes programas têm sido feitos com outros titulares de direitos. Por isso, e acho que devemos estar orgulhosos desse trabalho que temos vindo a fazer. E, no fundo, tentarmos promover a diversidade e a participação cultural, criarmos uma rede de solidariedade social que afeta muito a classe artística, como deve imaginar. Recentemente, nós sabemos a catástrofe que foi estes anos dos músicos e dos atores não poderem trabalhar durante 2 anos. E eu acho que nós aí tivemos uma participação forte de ajuda a toda a classe. Mas, no fundo, também lá está tentar promover, institucionalizar e internacionalizar o seu trabalho e as suas carreiras. No fundo, também para desenvolver aquilo que nós chamamos de economia da cultura, que é algo que às vezes fica um pouco para trás, não falamos nesses termos, mas estamos a falar aqui de uma economia de cultura e de um setor criativo. Nós somos um país que tem recursos não muito ricos e que, obviamente, que são estes setores que nós devemos realmente nos preocupar.
Interromper, mas já interrompendo, eu sei que não quero falar muito, ou seja, disse logo no princípio que não queria falar muito da diretiva, mas esta diretiva não vem trazer especiais, os artistas, por exemplo, em termos de negociação individual,
Sim.
de gestão individual dos seus direitos. Esta diretiva, o mercado único digital, esta diretiva não vem trazer especiais, eu não queria dizer problemas, mas pronto, enfim, assuntos a resolver no âmbito das entidades de gestão.
Eu acho que, lá está, eu não queria estar a falar muito da diretiva, mas eu acho que há ali um aspecto que para nós é determinante. É que há uma constatação, e não é só do legislador comunitário, mas eu acho que é do público em geral, que há desequilíbrios neste negócio. No fundo, o que nós sentimos é que está a ser aplicada uma fórmula de negócio que é um pouco aquela que existiu antes. Antes de haver a questão do streaming, muito baseada nas regras clássicas da compra e venda, etc. E realmente nós temos que admitir que isto é um novo mercado completamente distinto, que se calhar vai implicar alterações no que diz respeito, nomeadamente nesse tal equilíbrio entre todos os intervenientes. A nossa batalha nunca foi contra os produtores ou contra os autores, bem, isso menos, mas não é isso. O que nós discutimos é um modelo de negócio em que e está reconhecido isso na própria diretiva, de que se tem que discutir seriamente se há um grande desequilíbrio ou não entre os titulares de direitos. Mas lá está, doutora, eu aí não queria entrar tanto em detalhe, porque só esse tema mereceria aqui 3 horas de discussão com toda a gente.
Se quiserem ficar.
E pronto, doutora, só para concluir, é dizer, para nós o futuro da sociedade de gestão é trabalhar cada vez de forma mais rigorosa e nunca defraudar as expectativas daqueles que representamos. Isso para mim aqui é linear e é a âncora do nosso trabalho há 20 e tal anos. Não defraudar os artistas que confiam em nós para que os seus direitos sejam efetivados.
Muito bem.
Obrigado.
António Paulo, qual é assim, a sua posição enquanto representante da GEDIP, a posição da GEDIP, quanto ao futuro, e aos desafios da gestão coletiva em Portugal?
Em primeiro lugar, quero agradecer o convite da organização deste excelente evento, a ALAI, nas pessoas dos seus órgãos, dos titulares dos seus órgãos sociais, não vale a pena estar a dizer os nomes. Quero também agradecer a presença poder estar aqui com a senhora desembargadora e com os meus ilustres colegas aqui de painel, mas vamos então àquilo que importa, que é, eu vou falar da diretiva. Eu vou falar da diretiva porque o futuro da gestão coletiva em Portugal está bem, recomenda-se, e exerce a sua função naquilo que é a gestão coletiva dos direitos que são passíveis de ser cobrados através deste mecanismo de gestão coletiva. E quais são? Falava-se nos primários e nos secundários, eu costumo dizer os pequenos e os grandes direitos, todos aqueles que são direitos secundários ou os direitos secundários ou os pequenos direitos, é uma expressão que eu utilizo muito, e que não são passíveis de ser negociados diretamente pelo titular do direito, seja ele um direito de autor ou um direito conexo, então é a gestão coletiva que entra. Porquê? Para obviar a questão do tráfego jurídico e da execuibilidade daquela cobrança daqueles direitos que são reconhecidamente direitos que podem ser geridos e devem ser geridos através da gestão coletiva. Bom, esta diretiva traz-nos aqui uns desafios para a gestão coletiva muito interessantes e que deixa tudo em aberto. Em primeiro lugar, o que nos veio dizer, primeiro, acabou logo, dado início pelo Safe Harbor, para as grandes plataformas, para os gigantes da internet, agora vão ter que pagar, pelo menos é o que diz a diretiva, e, portanto, vem-nos dizer o seguinte: os distribuidores de conteúdos vão ter que licenciar as obras que os users generate contenders, ou os prosumers, se quisermos, colocam nas redes sociais e na internet. Aqueles pequenos trabalhos. Ora, isto tem uma particularidade. Não são obras audiovisuais, e aproveito já para dizer que há diferenças entre a música e o audiovisual, diferenças claras pela sua própria natureza, mas não são obras, portanto, as utilizações têm muito deles próprios, desses próprios produtores consumidores, metem muito deles próprios naqueles trabalhos e aproveitam pequenos trechos de outras obras. E é aqui, e à custa disto, ou isto é, por força desta realidade que existe na internet, os grandes gigantes têm ganho muito dinheiro. Muito dinheiro a nível internacional e também à conta dos trabalhos dos titulares de direitos. E o value gap é exatamente isto. Convém a gente focalizar-nos na diretiva. O value gap é quem ganha dinheiro tem que compensar aqueles que também contribuem para esse ganho. Isto é, depois vem-nos dizer também uma questão muito importante. Portanto, nós já sabemos que não são os produtores destes conteúdos que têm que se licenciar, mas os distribuidores. E porquê desta bondade? Esta bondade, isto funciona quase como uma blanket license. Ao contrário do que se dizia no início, e algumas entidades diziam, isto vai ser o fim da internet, isto é um horror. Nada disso é verdade. Isto fez muito barulho, muito ruído, com inverdades, que é uma expressão agora muito politicamente correta, com inverdades. E o que é que... A verdade nua e crua, aquela que nós costumamos desviar o olhar para não ver, é só uma. É que, agora, estes produtores de conteúdos ficam livres de ser prejudicados ou de ser demandados judicialmente por uma utilização abusiva. Essa responsabilidade deixa de estar na esfera jurídica deles e transfere-se para o licenciamento das entidades que distribuem estes mesmos direitos. Bom, isto é o plano objetivo que nós temos à nossa frente. Depois temos um segundo momento que é, e agora? A quem é que se vai pagar? Vai-se pagar aos titulares de direitos. Os titulares de direitos, eles têm um direito exclusivo e, como tal, podem autorizar ou não autorizar, têm toda a legitimidade para fazer, até porque estamos ainda na presença de um direito, aparentemente um grande direito, e que pode ser ou não ser negociar diretamente. E, portanto, nada disto me choca que seja uma possibilidade. Mas a diretiva também, claramente, aponta nos considerandos, nos diversos 46, 40, há uma série de considerantes que nos levam para uma outra solução, sempre de uma forma equilibrada e mitigada, que tem a ver também com a possibilidade, com a capacidade negocial das partes envolvidas e para a facilitação da negociação do tráfego jurídico. Facilita muito mais negociar com um conjunto de entidades, se elas quiserem. E já lá vamos, já iremos. Eu não tenho problema nenhum em falar em gestão coletiva alargada e gestão coletiva voluntária. A gestão coletiva obrigatória, neste caso, não é possível, a diretiva proíbe-a e não faz qualquer sentido, até porque, como disse o Miguel, põe em causa a liberdade de contratar e estamos na presença de um grande direito. Podem passar disso. Agora, há aqui outras questões que são importantes, nestes pequenos, grandes pormenores. É que, por exemplo, no caso da GEDIP, que representa os produtores audiovisuais nacionais, a representante tem mandatos de todos estes produtores, da esmagadora maioria, não digo de 100%, porque há sempre um que está de fora, que entra e sai, por causa da própria natureza do mercado, que é volátil, as empresas criam-se, extinguem-se, e, portanto, mas na realidade tem este próprio mandato em seu poder para poder autorizar estes distribuidores de conteúdos das obras a que ele representa a nível mundial. Agora, o que é evidente é que esta negociação terá que ser feita em Portugal. E porquê? Primeiro, temos que defender a cultura portuguesa. Temos que defender a língua portuguesa. E porque se a gente centralizar isto em termos mundiais, e eu tenho experiência disso, o que vai acontecer no final do dia é que recebemos umas migalhas que não representam a realidade objetiva de contribuição cultural que nós damos para este tipo de trabalho. E, portanto, neste caso em concreto, porque também os próprios produtores nacionais não têm uma dimensão gigante como têm as multinacionais do cinema, têm que recorrer, se calhar, a um mecanismo de gestão coletiva alargada com a possibilidade de opt-out para garantir que a liberdade e que, obviamente, respeite todos os princípios da adequação, da proporcionalidade, mas não querendo dizer com isto que não o possam fazer diretamente. Agora, do ponto de vista do tráfego jurídico, do ponto de vista objetivo, temos muito mais a ganhar e a diretiva não vai contra isto. Vai contra a gestão coletiva obrigatória, não vai contra a gestão coletiva. Agora, é evidente que há realidades diferentes. E eu entendo perfeitamente realidades umas das outras. Esta é, por isso é que eu disse falar da diretiva, esta é, efetivamente, a posição da GEDIP, que representa os produtores audiovisuais.
Os produtores audiovisuais e... Ana, por falar em gigantes... temos a posição da Google, as suas ideias sobre tudo isto e o que foi dito aqui.
Algumas ideias, não poderei responder a todos, acho eu, tenho esta ingrata tarefa de ser a última e também quero agradecer aos organizadores do convite e dar os parabéns pela organização deste evento que estava excelente e obviamente também agradecer aos meus colegas de painel e à moderadora um debate rico de ideias. Ora, eu acho que vou começar com o que eu penso que são as ideias com que todos concordamos. Acho que todos queremos alguma clareza legislativa. Isto é importante dizer-se porque ainda não temos um texto de transposição da diretiva em Portugal. Acho que podemos também todos concordar que este mundo do licenciamento, estamos a falar em Portugal, mas isto é verdade para o resto da Europa, este mundo de licenciamento traduz-se numa rede muito complexa de vários atores e, finalmente, acho que também todos podemos concordar que estamos aqui a tentar navegar da melhor forma essa rede complexa de licenciamento de uma forma que, por um lado, cumpra a lei, mas que, por outro lado, também suporte a criatividade, que é aquilo que nos traz aqui todos, não é? Agora, fazendo aponto para algumas coisas que foram aqui ditas e passando para o ponto de vista legal, porque, no fundo, o meu background é lei, começaria por apontar que, por exemplo, as diretrizes da Comissão sobre o artigo 17 reconhecem expressamente que há alguns titulares de direitos, nomeadamente produtores musicais e de filme, que têm uma preferência clara pelo licenciamento direto. E esta, por falar nisso, também é a nossa experiência enquanto Google, que nos diz que alguns titulares preferem negociar diretamente e em grande escala. Agora, Por isso eu penso que podemos pensar em fazer um uso mais eficiente das ferramentas de licenciamento e de gestão, sejam elas quais forem, ao mesmo tempo que, seguindo este exemplo, mas há outros, respeitamos os direitos dos criadores originais e dos titulares de direitos relativamente à exploração das suas próprias obras e do seu próprio material protegido. Posso referir também que, de momento, eu penso que temos 40 ou mais acordos na região EMEA e estes acordos são, eu penso que refletem esta rede complexa de titulares, porque não são só com titulares de direitos, são também com sociedades de gestão coletiva, são com os chamados hubs de gestão coletiva que incluem muitas sociedades de gestão e que, por isso mesmo, incluem e logo favorecem muitos titulares de direitos. Estávamos aqui, e não consigo deixar de referir, por causa do que o meu ilustre colega acabou de dizer, estávamos aqui a falar de um value gap, mas o que é certo, e isto é apenas um exemplo, é que a YouTube só no período de um ano pagou mais de 6 bilhões de dólares a criadores, à indústria musical, neste caso. E isto foi entre junho do ano passado e junho deste ano. Posto isto, e já que estou a falar no YouTube, não é? Obviamente continuamos, e isto é a nossa posição, continuaremos a trabalhar para ampliar os objetivos do artigo 17, neste caso, não é? Que é não só envidar os melhores esforços para obter as licenças necessárias, que se revelem necessárias, mas também assegurar a disponibilidade de determinadas ferramentas para os titulares controlarem os seus direitos. E abro aqui um parênteses um bocadinho grande para falar destas duas vertentes, do licenciamento e também da disponibilização de determinadas ferramentas. Porque resulta muito claro do último acórdão do Tribunal de Justiça que, estamos a falar do artigo 17, número 4, linhas A, B e C, que não há aqui uma hierarquia. Portanto, o Tribunal de Justiça, e se não me engano é no parágrafo 49 da decisão do caso da Polónia, diz-nos que todas as formas, portanto, do artigo A, B e C, são cumulativas e são aplicáveis. Tanto que, e isso era o principal objetivo desta decisão, era verificar a legitimidade ou a legalidade, se quisermos, das alíneas B e C do artigo 17, número 4, e o Tribunal considerou que estas alíneas eram compatíveis com a liberdade de expressão e que, portanto, deveriam ser válidas. Portanto, não há aqui uma hierarquia no sentido em que o facto de termos alinhado os melhores esforços para licenciar não se deve ser lido em detrimento das alíneas B e C, e é nesse sentido que não só, obviamente, iremos envidar os melhores esforços para obter as licenças necessárias, mas também para a utilização de determinadas ferramentas. Agora, a segunda questão de que falou, e que era a gestão coletiva alargada, que alguns membros deste painel referiram. Queria só referir que também foi referido pelo meu colega, que é um artigo que não é de implementação obrigatória, e de facto não é, há um motivo para isso, já lá vamos, mas a ser implementado por um Estado-membro há um determinado número de requisitos do artigo 12 que têm que ser cumpridos. Não quero amassar a audiência porque é uma lista tão extensa que acho que ficávamos aqui além da hora, mas vou referir algumas partes, nomeadamente pressupõe a existência de um acordo prévio entre a sociedade de gestão coletiva e o licenciado, e isso resulta muito claro do último relatório da Comissão sobre a gestão coletiva alargada, e depois esse acordo pode ser estendido ou alargado ou não. E é aqui que eu penso que vale a pena abrir outro parênteses, e que tem a ver com a gênese desta gestão coletiva alargada, que surgiu nos países nórdicos nos anos 60, como um modo de beneficiar o licenciado, que neste caso eram os organismos de radiodifusão, que queriam passar música, queriam ter a certeza jurídica, como falou, que é essa, efetivamente, um dos objetivos. Queriam ter a certeza jurídica e, portanto, e que pediram ou requisitaram este mecanismo que acabou por se espalhar, nomeadamente nos países escandinavos. Agora, e daqui se retira que a principal premissa é que é um acordo entre a sociedade de gestão coletiva e o licenciado, que neste caso eram os organismos de radiodifusão, para estender licenças que, mais uma vez repito, eram existentes. E eu penso que isto também pode ser lido na diretiva, já que estamos a falar de termos mais legalistas, porque, por exemplo, temos o considerante 44, que nos fala expressamente em, e passo a citar, oferecer licenças, denotando assim a base não obrigatória e quiçá mesmo contratual, deste mecanismo de gestão coletiva alargada. E temos também a questão de ser uma licença, se não me engano, considerando 29, de base voluntária. Portanto, esta questão do acordo entre as partes interessadas acho importante. Não é para dizer que a gestão coletiva alargada não será importante em algumas áreas, que se tem visto na experiência europeia que é, mas sempre com esta premissa e respeitando as origens da gestão coletiva, que é efetivamente essa base contratual e de acordo. E depois, obviamente, temos os outros requisitos todos, nomeadamente representatividade, que aqui podemos discutir se é quantitativa, se é qualitativa, se é ambas, que é necessário um mecanismo de opt-out. Portanto, há aqui uma série de requisitos que não nos podemos esquecer. E, por último, se me permite, isso ainda tenho tempo, a questão da gestão coletiva alargada, estamos aqui sempre a falar de remuneração e de preço e de remuneração, certo, mas estamos aqui a falar também de direitos exclusivos, não estamos a falar de direitos de remuneração. E os direitos exclusivos implicam algo mais, como, por exemplo, um titular de direito poder escolher como quer que explorar o conteúdo, quando, onde, durante quanto tempo, que é uma granularidade que as licenças de gestão coletiva alargada não permitem. E, portanto, mais uma vez, não é para dizer que não há aplicação, mas há determinadas condicionantes que temos que ter em conta antes de dizermos que a gestão coletiva alargada é uma espécie de penso rápido que se pode aplicar sempre e em todas as situações. Portanto, há aqui determinados condicionantes que temos que ter em causa.
Sim. Miguel, a propósito, artigo da gestão coletiva alargada, mas queria falar do artigo 12, concessão de licenças coletivas com efeitos alargados, o que é, se for transposta, enfim, para já em geral, e que não é de transposição obrigatória, o artigo 12 para Portugal, e confesso que eu tenho muitas curiosidades acerca da transposição, nomeadamente quanto ao artigo 12.
Bom, enfim, eu não gostaria de me alargar muito sobre esta matéria e devo dizer, correndo muito embora o risco, ainda tenho alguns patrões na sala, é uma outra gestão coletiva alargada, mas que, obviamente, alguns requisitos que estão no artigo 12 também se aplicam. E reparem bem, e isto dá para perceber o mundo de diferença em que estamos, numas coisas e noutras, utilização de obras que se encontrem fora de comércio, gratuitas, em utilizações gratuitas e sem fins lucrativos, por parte de entidades responsáveis pelo património cultural. É o único caso em que ele é obrigatório. Portanto, tem que nos fazer soar aqui algumas... mais uma vez, eu não digo que não haja um espaço, e até nisso concordo consigo, mas tem que nos fazer aqui soar alguns sinos, quando de repente queremos pegar nisto e aplicá-la a obras que estão no comércio, por definição, a utilizações que não são gratuitas, por definição, feitas por parte de grandes plataformas, por definição, não podiam estar mais dentro do comércio. Não é? Isto tem que nos fazer soar sininhos. Ora bem, e a questão é esta. Nós não podemos, e é só esta questão técnica que eu gostava de salientar, nós não podemos confundir e ler o artigo 12 como uma presunção de representação à partida com opt-out, como acabou de explicar muito bem a doutora Ana Rabalho. Não é nada disso. É ao contrário. Simplificando, o que o artigo 12 diz, mais uma vez, voluntariamente, por isso é que tem, de facto, o artigo 12 tem um campo de intervenção dos utilizadores. Os utilizadores têm que escolher se querem isso ou não. Então, o artigo 12 não funciona. Esta ideia paternalista, que também já ouvi alguns argumentos neste sentido, as plataformas precisam muito disto. Quer dizer, eu acho que as plataformas são suficientemente grandes para saber aquilo que precisam. E eu não tenho pretensão de dizer ou de querer indicar a empresas com a dimensão das grandes plataformas, e nomeadamente a Google, como é que a Google se deve proteger. Não tenho essa pretensão. E elas têm, de facto, uma palavra a dizer sobre isto, mas reparem o seguinte, simplificando, no artigo 12 o que nós temos é um acordo que é feito, eu vou já terminar, que representa em que uma entidade de gestão fez um acordo com o utilizador, essa entidade de gestão representa quase tudo, e, portanto, pode, para efeitos de liberatórios da responsabilidade do utilizador, chamemos-lhe assim, passar a representar tudo. Não é uma presunção à cabeça de representação. E atenção a isto, porque eu só vou chamar a atenção para isto. Quando a gestão coletiva é voluntária, os utilizadores escolhem a entidade que querem escolher. E é natural que os utilizadores nacionais escolham uma entidade nacional. Quando a gestão coletiva tem por fonte alargada, sem ser alargada, necessária, etc., com opt-out, sem opt-out, a base legal, convém não nos esquecermos que há o princípio da liberdade de exercício da atividade de gestão coletiva dentro da União Europeia. Cuidado com países com a dimensão de Portugal quando nos metemos por este caminho. Talvez não corra bem às entidades nacionais.
Carlos, e ao nível da gestão dos conteúdos de média, qual é assim a posição?
Relativamente à gestão coletiva alargada, obrigatória, o que seja.
Sim.
Bom, quem conhece o panorama nacional da imprensa portuguesa, lá está, nacional, percebe que, pela dimensão do país, nós temos uma mão cheia de jornais nacionais, diários, semanários, o que seja, e depois temos uma míriade de jornais regionais e locais que são muito significativos. A vantagem que existe... Bom, deixem-me dizer-vos que normalmente nos jornais regionais e locais nós temos 3 pessoas, sendo que são de cariz familiar. Possivelmente o jornalista ou o diretor, o chefe de redação é o dono, depois trabalhará o filho, a esposa, eventualmente algum empregado nessas publicações. Eles trabalham diariamente para conseguir recolher informação, tratar informação com a sua curadoria e entregar essa informação no formato de uma publicação periódica aos seus leitores. Isto tudo para dizer o seguinte: a última preocupação que estas entidades têm é com questões de direito de autor. A gestão coletiva alargada, no nosso ponto de vista, faria sentido para ajudar estas pequenas publicações a, de alguma forma, terem a possibilidade de, sem grandes preocupações, terem acesso a uma remuneração que, de outra maneira, não conseguem obtê-la, porque a última preocupação que têm é exatamente esta. Todavia, por sabermos que há algumas questões que são delicadas, é algo que nós compreendemos que, de alguma forma, não deve ser exigida por nós. O que eu quero dizer é que faria muito sentido para a imprensa termos, de alguma forma, a possibilidade de utilizar os mecanismos previstos no artigo 12 para a gestão coletiva alargada, mas também sabemos que a liberdade contratual do ordenamento jurídico nacional faz com que, moralmente, não o possamos pedir de uma forma expressa.
Obrigada. Pedro e António Paulo, temos, enfim, 5 minutos. Não, para os dois, e ainda lhes pedia que me guardassem 1 minuto para eventuais questões, porque prometi que acabávamos à hora.
Força, Pedro. Então, muito rápido.
Sim.
Pronto, eu já disse que não queria entrar muito.
Não queria entrar.
Mais detalhe da diretiva, por isso não me vou alongar muito.
Marcamos outra conversa.
Há aqui uma ou duas questões que me parece que ainda continuamos um pouco viciados em alguns conceitos que me parece que estão a ser completamente alterados, nomeadamente exploração primária e secundária, direitos primários e secundários. Eu parece-me que isso cada vez mais se está a desaparecer no horizonte, sinceramente, principalmente até do lado dos fonogramas. Acho que está a haver uma alteração drástica no que é, conceptualmente, o que é um direito primário ou secundário, em primeiro lugar. Segundo, também tenho muitas dúvidas por aquilo que o Paulo disse, até me deixa, de certa forma, perplexo com a questão de diretiva impedir completamente a gestão coletiva obrigatória. Eu pergunto, então, o que é que se vai passar com a Espanha e o que é que se vai passar com a Bélgica, que transpuseram já a diretiva, em que esse instituto está consagrado na lei, e não me parece que esteja a haver aí um alarde e uma perplexidade de incumprimento total da diretiva, e eu penso que até há de ser um movimento que naturalmente se possa estender a muitos outros países e começamos a caminhar por esse lado, o que não quer dizer que eu esteja de acordo com o princípio, mas que é um facto, é.
Posso até já. Tenho aqui algumas questões que eu tomei aqui, algumas notas, que eu tenho este mal feitio de tomar notas para responder. Bom, relativamente ao artigo e o direito exclusivo, é evidente que estamos na presença de um direito exclusivo. E quem tem o direito exclusivo faz dele o que entende, isto é, e ainda por cima, as formas de utilização são independentes entre si. Licencia para o efeito, pode licenciar para outro, são independentes, por isso é que existem janelas de exibição relativamente a obras audiovisuais, enfim, isso nunca está em causa, nem nunca estará da nossa parte. Esse direito exclusivo é absolutamente nuclear no direito de autor. É o direito que eu tenho de licenciar para aquilo que eu entender, quando eu quiser e onde eu quiser. Portanto, não está em causa. E eu penso que a questão da gestão coletiva alargada não vem conflituar em nada com princípios de liberdade contratual, nem com o direito exclusivo. E não vem porquê? Porque se a gente pegar nos diversos artigos que vão fundamentar a interpretação do artigo 12 para a possibilidade de gestão coletiva alargada, posso passar o 46, o 47, mas no 48 há uma parte muito interessante que diz assim: os Estados-membros deverão assegurar a existência de salvaguardas adequadas, aplicáveis de forma não discriminatória para proteger os interesses legítimos dos titulares de direitos que não tenham conferido mandato às entidades que oferecem a licença. Portanto, todas estas, o que está aqui em causa e que é importante dilucidar é que se eu for uma grande multinacional de cinema, por exemplo, uma Disney, ou como pode ser uma Paramount, ou pode ser uma outra coisa, é evidente que eu não necessito de uma sociedade de gestão coletiva para negociar os meus direitos, porque tenho uma dimensão global, de multinacional, tenho uma estrutura, tenho um head office enorme, tenho advogados em tudo quanto é sítio e consigo gerir os meus direitos diretamente e melhor, faço uma defesa melhor dos meus direitos do que se for através de uma entidade de gestão coletiva. Porque por isso é que se diz que a gestão coletiva é um mal necessário. É quando não se consegue fazer diretamente. Bom, mas se esta é a realidade, também não é menos verdade que para os titulares de direitos, em Portugal, algumas são microempresas, não são pequenas, são micros, e algumas microscópicas empresas, têm que encontrar alguém que possa representar, e pode ser através de mandato voluntário, um mandato de representação voluntário, podem fazer, mas deixo sempre esta possibilidade e a diretiva não vai contra isso. O contrário, relativamente à gestão coletiva obrigatória, não vejo, e a Bélgica, o que se passou na Bélgica é uma gestão coletiva alargada e não uma gestão coletiva obrigatória. Temos tempo depois para discutir isso.
Bem, Ana, temos um minuto. No minuto.
No minuto. Talvez referir que, se olharmos mais uma vez, para o panorama jurídico europeu, que tem também um mapa de direitos infindáveis, verificamos, e só assim falando de uma média, verificamos que a gestão coletiva alargada e a gestão coletiva obrigatória se verifica com muito mais frequência relativamente, primeiro, aos direitos de remuneração e, segundo, às exceções e limitações. E há um motivo para isso. E o motivo é que este tipo de gestão tolhe o direito exclusivo de uma forma ou de outra. E por isso é que um dos requisitos deste artigo 12 revela a subsidiariedade, se quisermos, da gestão coletiva alargada. E por isso é que eu não digo que é um ban na gestão coletiva alargada, mas há esta subsidiariedade. E esta subsidiariedade verifica-se exatamente quando a gestão, quando o licenciamento direto é oneroso, é impraticável e faz com que não haja licenciamento. E eu penso que é isso que temos que ter em causa, juntamente, obviamente, com todos os outros requisitos do artigo 12, caso o legislador nacional decida implementar o artigo 12, mas é esta subsidiariedade da gestão coletiva alargada relativamente ao licenciamento individual.
Muito bem. Nós chegamos ao fim do nosso tempo e eu peço à organização 5 minutos só para algumas perguntas do público.
Hello, thank you very much for this interesting discussion. So we tried to follow from translation. I hope I was able to catch up most of the things. I'd like to note a couple of things to start with, because I must say that the most prominent and the most common version of collective management in Europe and across the world is the voluntary collective management of exclusive rights. So when you look at the revenues collected by the authors, 80% is collected by the music author societies, which are operating based on voluntary collective management of exclusive rights. And then more than 60% of that is collected in Europe. And the other one is the visual rights societies, which are again operating based on the voluntary collective management of the exclusive rights. So it's an important part to correct, because I think the music author and visual arts societies were not represented in the panel. That this point was missing, I wanted to note. In that respect, there are obviously licenses with the music author societies. There is much less for the visual arts societies. I think the directive language and the guidance language is clear that the OCSSPs needs to get the licenses from at least all relevant CMOs of whose content they are making available. So better, if not best, effort is required there. And then the other point is the 6 billion euros or dollars that was mentioned as paid to the right holders. For the same period of time, the revenues of Google were 29 billion, and then according to third-party technology providers reports, 89% of the usage on YouTube included music. So I think, again, a better effort needs to be needed.
I'm sorry, I really have to ask you to conclude, okay? Yes, please. Só dizer que a Sociedade Portuguesa de Autores foi convidada foi convidada, enfim, conversámos, trocámos alguns mails, mas infelizmente por um motivo imprevisto hoje, enfim, não podem estar presentes. Num minuto, alguém quer responder aos comentários, dar alguma resposta? Um minuto, sim. Se calhar, sim, pode fazer, sim, é melhor, e depois respondemos no final. Respondem.
Okay, Johan Kaas from APA Artists. I first would like to thank the translators. They made you all sound very nice and friendly and very intellectual. So I do not speak Portuguese, but they did a great job. I'd just like to point out what was said in the beginning, the principle of collective management interfering with primary or secondary uses, and then Miguel made the statement that when it's primary, collective management should, and I'm going to rephrase what you said, back out. It's none of your business. We'll do this ourselves. This is individual. No collective management needed. This is primary, and you called streaming a form of primary. But I don't see that happening in practice. In the music streaming industry, I do not see any individual management anymore. Sorry. I see independent labels becoming member of Merlin and doing this collectively. And smaller labels that are too small to join the Merlin program, they don't do it individual. They have to go through intermediate companies, and they don't decide the tariffs. They don't it's no negotiation. Yeah. It's just signing. I agree with your general terms. Mm-hmm. And The major labels, Universal, Sony, Warner, that's also no longer individual management because the contracts they sign do not concern.
In a sense that it's not the Google experience.
Yeah, the contracts they sign do no longer concern individual records. They concern the catalog. They concern the collective of the catalog. So the solution is always collective management, whether it's done by the collective management or whether it's done by the labels.
We really have to conclude. So, alguém, Ana, okay.
Yes, and I'll speak in English, perhaps easier. And maybe I will start with the last question, and I will start by saying, don't shoot the messenger, because what I mentioned is not only our experience, but it's also concretely mentioned in the guidelines of the Commission, as you probably know. Regarding the first question, and if we want to keep with the guidelines as well, one thing that can be read throughout is not only the principle of proportionality, but also a number of criteria that have to be taken into account, and one of them is the prevalence of content. And that has to be taken into account when talking about taking down licensing and so on and so forth. I would just also like to add that we are here discussing this directive, but let's not forget that we have the Collective Rights Management Directive that is transposed in all member states. And as far as I remember, the Collective Management Directive does not take as a threshold the profit or whatever that the licensee has. And if you look at Article 16 of this directive on collective management, is the value of the rights in trade. And this is what we also have to bear in mind.
Okay. Miguel, you want to say something?
Just a clarification. I didn't say that in exclusive rights, collective management should be banned. It was not exactly what I said. What I said is collective management should be voluntary. And your examples are examples where the performers voluntarily choose the distributor, choose Merlin, choose whatever. And by the way, I think that it's preferable than to have just one entity in one country or all over Europe, it doesn't matter, without really competence between them. And I think it's better to have the possibility, or to leave the possibility to the right holders to choose whatever they want for their for the exploitation of their rights. And obviously, and by the way, as far as I understood, as far as I can understand, the outcome of the negotiations, both from Merlin or from the big companies, as you said, is not that different. What proves that, in fact, probably, most probably, let's say, the interference of a collective management organization will not, in fact, make any difference at the final value of the streaming. That is the question. Okay. The market will not increase because we have someone else to share another slice.
Miguel, obrigado a todos. Ficávamos aqui, enfim, mais umas horas. Ficávamos aqui mais umas horas. You have a question? A small one? Small? May I?
Thank you, everyone, for this participation. Just a reflection, I'm from the Spanish Collecting Societies of Performers' Rights, and I have heard to speak a lot about Article 12, but I haven't heard a word about Article 18, where an appropriate and proportionate remuneration is established for performers. We have an experience in Spain about a collective management, which is mandatory on the streaming and its functioning. And also, this experience is being replicated in Belgium now, and in other countries there is extended collective management, such as Hungary. Nobody has posed the possibility about transposing this directive in this sense for performers in Portugal. And I would like to know how this, for me, this is the elephant in the room, the question of the remuneration of performers through this directive, one of those. Yeah. And we keep on discussing about Article 12, about other possibilities, but we don't focus on that. And I don't agree with your statement that it has been a problem for the market share to have streaming as a remuneration right, through collective management or through extended voluntary management. So please take also this into account. Thank you.
Pedro, gestão dos artistas, performers. Yeah.
If you hear me.
Yeah.
Of course, I agree what I said. And well, it's a fact. We've got two countries, like Spain and Belgium, and well, there are pioneers fighting this way, and so I cannot understand the impossibility in this directive to the ways to protect the artists. It can be perfectly well the collective management.
So, obrigada a todos. Não temos mais tempo para aquilo que faríamos aqui até à noite, mas obrigada a todos, obrigada a Laí e obrigada a todos os participantes desta mesa e boa Assembleia Geral. Adeus, boa tarde.
Oh, yes, okay, it's okay. We are going to continue with our General Assembly. I would like to say also a little word about this very interesting panel. This shows